Section 29 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Giles, Jr. for embezzlement. St. Louis, Missouri, Part 9. The Speeches of Counsel. Mr. Blennerhassett for the defense, November 30th. Mr. Blennerhassett said he was not insensible to the fact that the jury must regard it as a great tax on their time and patience for counsel to address them on this matter. Yet he thought they would all see the propriety of continuing the attention which had been bestowed throughout the examination until the cause was closed and submitted to them. They must not imagine that speeches were made to them because it was thought necessary in order to get a verdict of not guilty at their hands. Counsel were not here defending Charles from the penalty of the law simply, nor were they going to invoke the clemency or humanity of the criminal law of the jury for the purpose of getting a verdict of acquittal. They had a higher and holier duty to perform than that. The duty of absolving him even from a suspicion of guilt. They wanted, by a common deliberate investigation of the facts, to send him abroad without a stain or blemish upon that reputation, which was unassailed and unassailable, until the blighting and contaminating touch of the Bank of Missouri and its officers was brought to bear against him. His occupying the time of the jury and trespassing upon it was cause of embarrassment. Yet there were other embarrassments to him on this case. We had all heard the great mass of evidence which had been introduced, had heard it as impartially as our minds could be brought to bear upon it, and to take it from beginning to end. He would ask an impartial mind to point out one fact, or any number of facts that had been proved, taken together, and upon which, as an honest man, he could say the defendant was guilty of the charge against him. It was embarrassing for counsel to argue when there was nothing for the mind to grapple with. Breaking ground, as it were, groping in the dark, contending against a shadow without a particle of substance upon which to predicate a conviction. And this was his situation. The defendant had passed through a fearful ordeal. He remembered well the feelings with which he first heard of the charge against the party on trial. He thought of those who were making the charge. He thought of the ordeal through which he would have to pass to preserve his innocence. The peril in which he had been placed upon this trial was a fearful one. Around him had been concentrated the influence of a host of men who do not peril $1 of money out of their own pockets, but who stand behind a powerful, moneyed influence, which enabled them to bring upon his devoted head might and weight. There was not a director, cashier, or other officer of that institution, but what had combined all the power and influence which wealth enabled them to exercise in order to shift the responsibility from themselves. The influence of money was powerful. It runs into every nook of society, pervades every place, the castle as well as the cottage, and sets minds to work in an extraordinary manner. When the holders of it go to work in order to crush their victim and do not accomplish it, he must be protected by a power greater than the power of man. That such influence and power had been displayed in this case, no one can deny. That it had been brought into requisition, the witnesses themselves prove. Every fact furnished additional evidence of the fearful ordeal through which he had passed. But thanks to the law and the institutions of the land that throw a shield more powerful than gold around him, he is enabled to demand of the jury a fair trial, and to stand up against moneyed power, concentrated or scattered abroad. He felt that this case had not been tried as cases ordinarily were in the criminal court. The peculiarity of the trial had been such as to oblige a departure from the ordinary course. No man who practiced under the criminal law, or had read one page of it, but who had ascertained that great landmarks had been erected for courts, regulating the manner in which trials should be conducted so as to produce just results. In this case, he was forced to the conclusion that these landmarks, old as the law, had not only been defaced and obliterated, but completely stricken down. No one was to blame, not the counsel for the prosecution or the court, but he felt that it was to be attributed to the inherent defect in the charge preferred against the defendant, a charge from beginning to end without a shadow of proof, a charge preferred and sustained by proof that would not even justify a magistrate in committing the party for trial. For I even took it as proven, that on the 11th, 12th, and 13th of August, in which time dates the arrest of Childs, the officers of the bank and everybody connected with it knew as much as the facts can prove now, and I contend that the selection of Childs was just as reasonable and just as much warranted by the law and evidence and the principles of justice as would have been the selection of myself or any other person in the courtroom, except from the fact that he happened at one time to be an officer in the bank. When a man is to be tried in this court for murder or other crime, the court will not trouble itself about ascertaining who did the deed, unless it was first proven that it had been done. This was a plain principle that must come home to every man's mind. A man is not to be tried for stealing unless it is proven that a larceny has been committed. And here it is that the old landmarks of the law have been destroyed in this case. And why? Because the Bank of the State of Missouri required that it should be done. That is, it was said, $120,921.62 had been taken from that bank, and it was necessary for the purposes of justice that the doors of the criminal court should be thrown wide open, that the machinery of the criminal law should be set at work, that an investigation should be had, and that Childs should be selected on whom to fix suspicion, just because he happened to be an officer in the bank at one time, and at the time the charge was preferred happened not to be in the bank. This was the only excuse that can be found for this extraordinary proceeding. He asked the jury to go with him quietly and calmly into an examination of the cause. He would advance it as a settled principle, knowing that he would be followed by gentlemen of high legal ability who would correct his proposition if incorrect. That the bank has been, as it should be, on trial in this court, and not Childs, and whether the conduct of its officers be attributed to mistake, ignorance, dishonesty, or what not, it would be his purpose, on evidence introduced by these bankmen, to show that their action in the arrest of Childs was not only unauthorized, but that the officers have exhibited a course of proceeding in the management of the institution, that they had betrayed a course of conduct in reference to the party on trial, which should invoke the deep and eternal indignation of every man who regards personal rights as worth preserving. For one, he would not bow down to the bidding of any such institution as the officers of that bank had proved it to be. He would as little regard its vengeance as he would despise himself, if, on this trial, he courted its favor, directly or indirectly, when the consequences may be so vital to the defendant or to any man that they may see fit to select for the purpose of covering up their own blunders and mistakes, or, if you please, their own dishonesty. He held that on this trial it had not been proven, according to law, that the bank had lost the money it says it has. Here was the first point in this case, and the first point in every case. What is ordinarily understood in technical phraseology as the body of the offense has not here been proven. It is a legal principle that testimony required to prove the body of the case, the loss of the money, is of a different character from that necessary to prove a party guilty. He meant by this that the jury must have positive evidence that crime has been committed by somebody before they can go an inch further. When a man is on trial charged with an offense, if positive evidence cannot be given and circumstances are resorted to, it must be positive and proved in point of fact that the offense had been committed. His legal proposition was, when there is no positive proof that any offense had been committed, and the prosecution resort to circumstantial evidence, the circumstances, when proven, must bring conviction to the mind, so that it can repose undisturbed by the least glimmer of doubt, and leave no room for argument. Thus, in the offense of murder, you cannot try a man until somebody is murdered, and to prove the murder, it won't do to prove that somebody fell out of a third-story window and was killed. It won't do to prove that a man left his home and was gone 20 years, then take a party up and introduce circumstances to show that the man lost his life by violence. The body must be found and the jury must be satisfied that the man is dead and that he came to his death by violence. The principle was the same in regard to larceny. It was an absurdity to talk about convicting this or that man of stealing, as long as there was a doubt on the mind whether anything had been stolen or not. It was absurd, laying aside all principle of law, and cruel, that you are to jeopardize the character of a man by accusing him of stealing money, when the very fact of the money being stolen depends on the recollection, and there is a possibility that the man claiming to have lost it may not have been robbed. He had another cause of embarrassment in this argument. He did not know whether or not they were trying the fact that the bank had lost $110,000 in 10 thaler pieces and $10,921.62 in sovereigns, making the sum of $120,921.62. No one could tell. He had been 4 weeks at this table, and when not here was elsewhere trying to figure it out and could not tell. He asked the gentleman engaged in the prosecution what they were going to ask the jury to find. In this respect it was a remarkable case, and it was the one reason why he felt anxious that the prosecution should commence the argument and state what they believed the bank had lost. This was the difficulty in which they were placed, and 24 hours deliberation on the part of any juror could not explain what the bank had lost. You may have a suspicion, if you please, that so much money was lost, and that Childs, or Shirls, or Hirschberg, or somebody else in the bank took it, but you can't tell more. We are talking about the starting point in this connection, the proof of the fact, without suspicion and without doubt. What has the bank lost? No man in the courthouse could tell. No director dare swear to it. If my memorandum is right, there's just so much in the 57 boxes, says the director. That is it. They have no knowledge upon which to state the fact. Not a bit. It was a strange, unaccountable fact that a man's liberty should be put in jeopardy, his character impugned, and he placed in the criminal box, when no man can swear that he has lost anything. The veriest object in the shape of humanity that walks can claim more consideration at the hands of the law than to be placed in such a position. The beggar, the man without character, who moves through the world a blank in our country, where personal protection is guaranteed, can demand the consideration of law, but not so this defendant. He has gotten along too well in the world. He has lived, not for himself alone, but for the good of his fellow men. Quietly and unostentatiously, has wended his way over a thorny path, was too good and cut too pious a figure. This is the complaint. The finger of envy was pointed at him. The man of avarice has marked him as a victim. The old landmarks of the law were to be trodden underfoot, and he is to be offered up as a sacrifice for the sins of the bank officers. Fatal day for any man who values his reputation to have anything to do with such an institution. He said he would now make it a matter of grave argument, by facts and figures, to show that the bank had lost nothing, no money at all. The witnesses introduced by the prosecution do not swear that a single bag was taken out of those boxes, except so far as their memory is aided by a memorandum, from the time of the February and March count to the time this trial commenced. Take high school, for instance. If he had not been furnished with the memorandum from Sherrills, he could not have come into court and told the boxes he counted, much less their contents and the days on which he counted. When the counsel on the other side come to argue this case, they will have to take the specie books and semi-annual statements, and without regard to the testimony, take the memorandum made in September in connection with the specie books, put down the round sum, tell you it is gone, and advise you to find it so. It might be that counsel on the other side would be able to establish the fact that the money was missing, but whether stolen or paid out was another thing. They certainly will be able to show that the most extraordinary blunders in the world have been committed by the directors of this bank. Let us see how they really fixed on the amount of $120,921.62 as being abstracted. Bear in mind, it was on the 10th of August that box number 30 was taken from the vault and opened, and a bag found missing. This gave rise to the proceedings of the next day and the 13th of August. It was then, I believe, there were various opinions in regard to the amount. At one time, it was $20,000. At another time, more, and it finally crept up to the sum $120,921.62. And there settled. The great inquiry of how it got to that amount has not been answered before the jury. After this bag was missing, the August count commenced, and at the same time the directors were busily engaged with Giles. Subcommittees were appointed for various purposes, one to go to the graveyard and ascertain the cost of a railing around the graves of his children, another to get his tailor bill, etc., another to go to Spruce Street to see a lady and ascertain if the missing gold was not secreted upon her premises, and these duties engaged the directors on Monday the 13th. On the 14th, these 13 distinguished gentlemen, Engelrod absent, got into the cashier's room and determined to open all the boxes and ascertain their contents. Mr. Walsh, the oldest director, takes the count, and from that count he tells you that, in round figures, $1,577,734.53 is the sum total of coin on hand. We will stop there for a moment. The last absolute count of the coin previous to this was in March last, when $1,566,458.36 was the amount of coin then on hand. So that, if you take a broadcast view, they have really not lost any coin. Because of the 15th of August, they have $11,186.17 more on hand than they had in February and March. Yes, says one, but we have made up our minds that some money has been taken out, and so it has been proclaimed, and now we have got to ascertain the amount. What, says another, how are you going to tell that? In order to get at the matter, you must know how much coin has been received since March, and how much paid out, and according to the result, know whether we have lost anything or not. Stop here. What does Mr. Walsh say? The difference between the two counts was $11,180.27, and at the August count we had no data to show the amount of coin received and paid out in the interval. As they could not tell the cash or coin account in August, between the interval of March and that month, it was then really a matter of obscurity whether they had lost anything. Mr. Walsh was mistaken. If the specie book was made up every week, as it has been stated, for that would furnish him the data. If, however, the specie book for the week ending August 11th had not been made up on the 15th, then Mr. Walsh testified correctly, and had no data, and the flurry about the bank and among its officers makes it probable that the weekly specie balance was not furnished up to the 15th, and they really acted without data. However, Mr. Walsh fixed himself at $11,186.17 as the amount over the March count then found on hand. There was paid out of the bank during the week ending August 11th. Remarkable circumstance connected with this alleged abstraction. $198,571 in coin and taken in for the same period $93,936.93, leaving the amount of $104,634.07 as the sum paid out of the amount taken in. For the week ending August 4th, there was paid out $134,770 and taken in $149,743.70, leaving the sum of $14,973.70 as the excess taken in over the amount paid out. For the week ending July 29th, there was paid out $170,618 and taken in $134,881.07, leaving an excess paid out over the amount taken in of $35,736.93. And for the week ending July 22nd, there was paid out $125,907.27 and taken in $145,471.91, leaving an excess of $19,564.64 as the sum taken in over that paid out, thus showing, in the period of 4 weeks previous to the discovery of this alleged loss, the sum of $105,832.66 as an excess of gold paid out of the bank over the amount taken in. Well might Mr. Walsh say they did not have the data when they settled upon the sum of $120,921.62 as the amount abstracted. This data, which Mr. Walsh did not have, he endeavored to make a calculation upon. And how does it work? Take the sum of $1,698,656.15 as the amount of coin on hand August 15th. Then deduct from the sum of $1,566,548.36, being the amount of coin on hand at the close of the March count, and you have left the sum of $132,107.69. Deduct from this the sum of $11,186.27, the difference between the two counts, as reported by Mr. Walsh, and what have you left? The sum of $120,921.62. The directors then adopt the idea that this amount was taken from the 57 boxes of foreign gold, and go to work to calculate accordingly. One of the directors comes into court with a memorandum and states that in March the amount of 10 thalers counted was $428,858.38, and at the invoice of coin in September, the amount of thalers in these boxes was only $318,958.38, showing an abstraction of $109,900 in thalers. Add to this the bag of sovereigns alleged to have been abstracted from Box 11, $6,171.72, and the bag from Box 30, $4,850, and that will bring out the sum of $120,921.62 as the amount abstracted, and this is the way the counsel for the state will argue that point. All of these 57 boxes in which foreign coin was packed at the August count have been put in evidence on this trial, and he had taken the trouble to take off the contents of every box in regard to thalers, having thereby the same means the directors had for that purpose, and unless he had made a mistake, the amount of 10 thalers in all of them was only $416,426.08, showing $12,432.30 difference between Mr. Christie's statement and what he found by the memorandum on the boxes. How did the directors get at the number of thalers counted in March? From the endorsement on the boxes, or the memorandum taken at the time of the count. None have said an invoice of the various kinds of foreign coin was taken in August. The number of thalers then counted was all a matter of figures and calculation, and if in that they have made a mistake, they may be incorrect in every particular. November 30th. Mr. Blennerhassett. The evidence had not proved the fact of the loss of the money. The data by which he was governed was within the reach of anybody who had access to these boxes, and by taking off their contents as marked upon them, it showed a total failure in establishing the main fact to be proved, that the bank had lost the money claimed in the indictment, and if they are mistaken at this, then the basis of the charge falls to the ground, and they have no foundation upon which to maintain their case. In point of fact, instead of $428,858.38 in 10 thaler pieces being put in these boxes in March, there was but $416,426.08, and in this estimate he had calculated the contents of Box 5, which, upon being produced in court, did not purport to contain 10 thaler pieces, and had also included a bag of Prussian thalers in Box 57. Take out the contents of Box 5 and the bag of Prussian thalers in Box 57, and this amount is considerably more reduced. How is the matter further proved? Witnesses are asked to testify to the value of the different kinds of thaler pieces, and they give them of different value, from $7.75 to $7.90, and they tell you they were put in these boxes at $7.85. At what rate were they all counted? Take a great many pieces of this kind of coin and deduct on each by 5 cents, and it will make a great difference in dollars. It has been testified as a fact that when the bags were filled and placed in these boxes, the lids were screwed down and sealed, and the amount and character of coin marked on each. Yet, when we go to box number 5, we find them at fault there, and the amount of coin only put down. In order to prove whether there was any mistake about his calculation of the amount of thalers the boxes contained, he, Mr. B, went to the 57 boxes and took down the quantity of coin they contained, excepting thalers. Recollect, they assumed when these boxes were counted in March, they contained in all $969,360.92. He found then the result of his calculation to be $552,934.91, to which add his calculation of the amount of thalers, $416,426.08, and the aggregate contents is obtained, thus proving his proposition correct, viz., a difference of $12,432.30 in the amount of thalers which the bank claims they contained in the amount they actually did contain, according to the memorandum upon them. If he was correct in his calculation, and he thought he was, then the fact was before the jury that the directors had made a great mistake in reference to this matter. He would show mistakes in other matters. Mr. Shirles was asked if he stated on the direct examination that 14 of the 16 boxes from which abstractions were made each contained 2 bags of 10 thalers, and he said he knew nothing about it himself, except from the memorandum made by the directors. And upon that he makes affidavit for the arrest of Childs and for a search warrant, in which he swears to a certain number of pieces of coin of certain value as having been abstracted. At that day and time it was no difference to the bank officer as to the peculiar kind of coin sworn to, and he threw that as a strong circumstance to establish his proposition that the dividing of thalers and ascertaining the amount in these boxes was a second consideration, and for the purpose of bringing about the amount said to be abstracted from the bank. On his examination, he swears the 14 boxes from which abstractions were made contained each 2 bags of 10 thalers. How is this? Box number 5 contained 3 bags, 2 of Prussian coin and only 1 of 10 thalers, and boxes 8 and 14 contained only 1 bag of thalers. Is there no mistake about this matter, this main subject? Is it not clearly proven and admitted by witnesses on the stand that box 30, in point of fact, contained 4 bags when opened, and is so reported on the original memorandum made at the time of counting, and yet it is alleged that 1 bag of sovereigns was abstracted from it. Mr. Christie says, "Oh, it was a mistake." That is what we are talking about, and from the number of mistakes it becomes a subject to grave argument whether the whole matter was not a mistake. End of section 29. Section 30 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement, St. Louis, Missouri, Part 10. Mr. Blennerhassett reviewed the manner in which the February-March count was conducted, in regard to which the testimony was not clear, and certainly not positive, but in which large and enormous mistakes might have occurred in marking on the outside of the boxes, or taking down on the memorandum their contents. There was a mistake in regard to box 30, and the same might have occurred in regard to 20 other boxes. The directors say it is not so. Now test that, and can the jury be satisfied that it is not so? Can any director tell of his own memory how many boxes, much less their contents, he counted? Not one. They had to depend on a memorandum. How was the memorandum made? Did each one keep a memorandum of his own? No, it was a general one, used first by one subcommittee and passed over to the next, until the counting was completed. It may be correct and it may be erroneous. That they were not confident of the correctness of their count in February is manifest, and hence they had to make another count on the 6th of September. They were not satisfied with their count in August, when they went over those 57 boxes to ascertain the amount lost, and upon which examination they fixed the amount abstracted. But they subsequently went over all the coin, gold and silver, to ascertain the actual loss upon correct data by the amount on hand in February, and the action of the bank in the interval. If the paper memorandum of the contents of the 57 boxes was correct in every particular, they would have saved any further examination. They would have said from $969,360.92, the stated contents of the boxes, there was missing $120,921.62, and there they would have stopped. But they had no confidence in this count as proven by the statement published at that time. On the 30th of June, the bank made its semi-annual report of its condition, at which time, according to the statement, it had no knowledge of its loss. A month and 11 days intervene, and these directors go to work and count the coin, and publish an expose of the bank and its branches. Why include the branches in the expose published on the 15th of August? Did either of the branch banks lose any money? There would have been no necessity for an expose at that time, were it not for this loss, and yet the directors thought it would look better to put out an expose of the condition of the mother bank and branches. And mark, this statement published on 15th of August was not true in point of fact, and is admitted not to be true. In it they publish, under the head of resources, gold and silver coin on hand, as appeared by boxes that had been sealed and marked by the board, and counted and weighed, $2,226,915.52. Why put out that statement? Was it so? In regard to the amount of coin, it included parent bank and branches. But what director attended it? And what officer informed them that the coin of all the branch banks was counted, boxed up and sealed? Not one. But by whom does this expose say it was done? By the board. What board? Any ordinary man taking this statement would say by the board of directors of the parent bank. that the board really marked and sealed the $2,226,951.52. No one pretends that this is so. The fault and peculiarity of the statement is that they did not know the condition of the bank and wanted to make the best face they could to the public in the report of the 30th of June. They give the item of profits at $240,659.90. And in their statement on the 15th of August, they give this item as the same. Had the bank made no profits in the meantime? The bank had sustained a loss, and it was necessary to satisfy the stockholders and assure them. Ordinary men will not go into a calculation of figures, but take results. It was necessary to show a firm basis and restore public confidence, and hence the amount of coin is fixed at $2,226,915.52. The loss by the bank has gotten rumor, and they turn upon Giles. The cashier's room is turned into a court, and inquisitions established. Our duty is now to bring the matter before the criminal court, show that Giles had possession of this money, perhaps keep the jury in doubt, throw suspicion on him, and the more strongly suspicion is upon him, the better we will get out of the matter ourselves. If it was only 21,000, we would not trouble ourselves about it. But as it is 121,000, we must see to it. So they go to work. He was struck with surprise when the gentleman who opened the prosecution announced that perhaps that amount of money was not there in point of fact during the March count, but was covered up by a kind of hocus pocus, and that it was for the jury to say that Giles, ever since he went into the bank as teller, had been taking $10, $20, and $50 bills, and perhaps a little gold and silver, until it got to the amount of $120,921.62. And then, when the February and March count came about, that he went into the vault, and when the director sent a box down to him, he had a candle ready to apply to the seal, then unscrewed the lid, took out a bag, and sent it up again, when it was counted twice, and in this way covered up his prior defalcation? He thought there was some mistake about the matter when the rumor was first given out, that the bank had lost gold, then that they had lost no gold at all, but paper, and this is what we have endeavored to get the prosecution to allege. The defendant is a man occupying an interesting position in the community. You say he has embezzled $120,921.62 out of the bank as a mere matter of humanity and mercy. Say whether you mean to ask these 12 jurors, young and old as they are, for a verdict for stealing gold or paper. No, you won't do that. You are going to give the testimony to the jury, and when you get it cooked, we'll serve it out to them, and they can do as they please with it. He thought they had been too long about the dish and spoiled it, and when the question was presented to the court for the purpose of compelling the prosecution to tell what ground they intended to insist upon, the senior counsel, with all his sense of justice, could not be coaxed to announce to the jury what points of fact they were trying. This satisfied me that the conclusions arrived at by the calculations had compelled the officers of the bank to abandon the idea of gold being stolen, and as they had gotten their foot in the trap by insisting on the prosecution, they would shift their position, let the gold go overboard, and go for a paper abstraction. Their figures and calculations would not bring them out satisfactorily in regard to gold. They couldn't back out, and now they wish to make it appear that he stole some paper money. Is there any proof that he stole paper? They introduce Clark, the receiving teller, and he says there has been no paper money taken at all. He says the paper money was kept in a safe in the vault, to which no one but himself had a key, and that which was in the chest, he kept it in such parcels that no considerable amount could be taken without his knowing it, and he insisted that none had been taken. Bear in mind that there was a count in December 48, February and March 49, a semi-annual count in June last. the special count on the 15th of August, and another on the 6th of September, and it has never pretended, directly or indirectly, that a single $10 bill has been missed from the bank. And the only testimony in this cause, squinting that way, is the testimony of the young man at Clark and Brothers, who did swear that Childs at one time brought some paper money to that office, which smelt of the vault. Is it not an extraordinary idea that men, the businessmen having charge of the bank, laying aside the common dictates of humanity and all those principles which should govern man, should permit so trifling a case to be fastened upon them, by presenting to a jury the magnificent idea that gold was lost and not lost, that paper was lost and not lost, that silver was lost and not missing. It was extraordinary that the time of 12 men should be taxed, the public interest made to yield to the bank, and character and liberty and reputation put at the peril of a trial. By such testimony as this, when such circumstances are relied upon for a verdict, the proof authorized the assertion that truly this defendant had passed through a fearful ordeal. If Childs were really guilty, there had been means resorted to, and vigilance used in exercising and procuring testimony against him that would prevent the bare possibility of escape, no matter how ingenious he might be in avoiding detection. The bank and its officers and agents had been to every broker's office in this town. Every clerk's memory had been brightened by inquiries brought to bear upon it. Everything had been brought to their aid, everything hunted up against him, even from the grave of the dead. And if there was the least lingering suspicion of guilt, they would have had it before the jury. After all this, what is the lingering suspicion? That some paper money which did not look as if it had been handled by rough hands was brought into Clark and Brothers by Childs. And this young gentleman paid great attention to it. It made a great impression on his mind. It was the great embodiment of larceny. He thought of and about it from that time to this, and may have dreamt on it, and afterwards being brought in here to testify to it. Strong circumstances. The ingenuity of counsel on the side may have a great deal to say about it, but nothing to argue. What's the last idea? That Childs did not take gold, but took paper. He held, therefore, that the starting point in this prosecution had not been established. He held that there was no proof, such as the law requires, and any man charged with crime has a right to demand that the money has been lost out of the bank. He took higher ground, that, under the Constitution and the laws of the land, which regulates the trial of men, the prosecution had totally failed to satisfy the jury of the first great fact to be established. The defendant, according to the evidence introduced for 21 days past, stands before this community and the world as absolved from the crime, as free and clear from it as does any one single witness connected with the bank who has sworn against him. He doubted not but that opposite counsel, in reply, and by aid of memorandums made out since the prosecution commenced, would argue quite differently. But if they took the data furnished by the proof, there could be no material difference. The bank directors come into court with a memorandum which, they say, was furnished by Mr. Sherrills, and knowing nothing about its correctness, they testify upon it, what they did in February and March. Suppose this data not to be erroneous, and that the bank lost $121,921.62 in gold, or silver, or paper. The question arises, who took it? Assume, for the sake of argument, that the bank sealed up 57 boxes of gold of various denominations, and during the boxing up, somebody, by some hocus pocus, got 16 bags out, making $121,921.62. And suppose, as a mere matter of suspicion, that Childs, being teller and cognizant of all that was going on, was the man. Did it not occur to the jury that if he was ingenious enough to accomplish it, that he would be smart enough to conceal it? Occupying the position which he did in the bank, and knowing that 16 boxes each were minus a bag, and might be discovered, and would be discovered at the annual count in June. Was it not an absurd idea that he should, against the wishes of the cashier and a majority of the directors of the bank, resign his place and give the possession of these very boxes to a man who would be the very one to detect him? Would he not have remained in the bank just as long as he could, so that when anybody called for $80,000 or $100,000 in gold, he could go down into the vault and select any other than a box from which an abstraction was made? Could he not, and would he not, have done that? It was absurd to contend for such a proposition. Had Giles taken that money, or any part of it, believe me, he would have stayed in the bank and watched the boxes, if taken in fact in gold, and made false counts, or procured false counts to be made, in order to cover up the abstraction. He must have known that, in 48 hours, one of these boxes might be required for use. He would have remained there, and prevented anybody from handling them. And as long as he stayed in the bank, he could have prevented any detection, so far as he was concerned. He asked, taking the testimony adduced in this case, and putting the president, tellers, clerks, and cashier on trial, whether Giles would not be the very first man for whom they would render a verdict of acquittal, except for the strong point developed, that he had the opportunity. Because he had the opportunity, therefore he did it. He did not say that either of those gentlemen stole the money, but applied to them the rule applied to the defendant, and they were in just as bad a box. Their opportunities were just as good. When the bank commenced operations, according to the evidence of some of the witnesses, they did not know what seal they would use. They sent Engelrod for a seal, and he brought a Prussian seal, which they declined using in consequence of its official character, and after this, for the first time suggested, they picked up an old seal and used it. Before that count, Giles did not know that they would use that seal, but counsel will say it was laying about the room several days after they commenced sealing, that he got an impression and had a new one made, and used the old seal until he gave it to Engelrod. It was not in evidence that the seal was out of the cashier's room one day from the commencement of the counting up to the time it was given to Engelrod, and by him to Sherrill's. Is it not absurd to contend that Giles could have gone into the vault, abstracted this money, and resealed these boxes, when somebody had access to the vault at every moment of the time, with not one chance that he would escape, and 100 that he would be caught? He left the bank early in May, and the count was concluded the 24th of March. Even if he had the disposition, he must have taken the money between that period. And is it in evidence that even then he had the opportunity? They forget that his successor had doubled that period of time up to the discovery, and with the very same opportunities that Giles had. Call that gentleman on the stand, and he will tell you that he can go into the vault at any moment, and no person who has not the keys can go in and steal that money. It was sophistry to contend that Charles had, from the 24th of March to the 8th of May, in which to steal that money, and he is guilty, while another man, with double that time, is innocent. It was no injustice to any of the officers of that bank to draw a comparison between them and this man on trial. Their integrity, honor, and honesty is not going to lose by that comparison. Put the successor of Giles on trial. He had access to the vault. You find him when Box 30 was paid to Page and Bacon on the 10th of August, and although absent at the time it was opened, and while a portion of its contents were counted, he is the very first man to discover that a bag was lost. Take another circumstance, which, if proven against Giles, would be strongly urged. When the box was paid over to the young man of Page and Bacon, the teller refused to let them take it from the bank to be counted, as was customary. mistakes either way to be rectified, and declared himself not responsible for its contents. Take Cochrane and try him. In point of position, he may be as respectable as anybody else. When you tried Charles, try him too. Did he not have a better opportunity than anybody, if he desired, to steal the money? Suppose he obtained an impression of the keys to the vault, as they were thrown about the bank, and got a set made from the impression. What was to prevent him from going into the vault at night and taking as much time as he wanted to accomplish the abstraction? All he wanted was the seal, and his opportunity for getting an impression of it was just as good as Giles. He slept in the bank all night, had an opportunity of getting the keys and seal, had his own time to accomplish it, and could as well have done it as anybody else. Take Charles and put him on trial. He had keys to the vault and the seal, and access to the bank every Sunday from the 24th of March up to the 11th of August. And what was in the way of his doing it? He lived in the banking house, and it had been proven that he directed the porter to leave the bars off the door in order that he might go into the bank on Sunday to write letters, he being, by virtue of the charter, in possession of the coin, and with these facilities had a better opportunity of doing it than Giles. Suppose we take the directors and these subcommittees, but they are just as much liable to suspicion as is Giles, whose moral character stands just as well as theirs, and pick up circumstances against them. They say the amount of 10 thalers counted in February and March was $428,858.38, and they were placed in these 57 boxes. He would show that one committee counted just that amount of the contents of these boxes. Mr. Yateman says it is the amount his committee counted. The aggregate of foreign gold counted and boxed by the committee with which I was engaged was $428,858.28. Only 10 cents difference. It was a remarkable coincidence. Without thinking of this fact, the directors, to suit this case, go to work and separate the thalers from other coin counted in March, and the difference between the count of one committee and the aggregate of that description of coin was only 10 cents. To take the round figures as data, one would infer that that committee counted nothing but thalers. If there was any hocus-pocus about the bank, any mystery, it seems to be an unaccountable circumstance that one committee should count within 10 cents of the very amount of thalers it was important to show was in these 57 boxes. Let us suppose that, of these 57 boxes of foreign gold, 16 were minus a bag each. Could it not have been done in the counting room? If the 3 or 4 gentlemen, or any one of these counting committees, should have made up their minds to feather their nests out of the bank, and many extraordinary things had been done by men connected with banks, before the Bank of Missouri had hocus-pocus practiced in it. Suppose they made up their minds and conspired to take an amount of money to pay for some purposes of the bank. Did they not have an opportunity of slipping a bag from these boxes? A better opportunity than Giles had, infinitely better. Before the seal was put on the boxes, or the contents marked upon them, it might have been done. And if done at all, could have been done by any man who had access to the cashier's room during the count. The jury has heard much evidence in regard to the private affairs of Giles, his style of living, from which the idea was taken by the directors that he was pilfering from the bank. They set themselves to work and attempted to show possession of no such property, extended the inquiry to a period long before he came to the state or the Bank of Missouri was in existence, and by this expected to leave an impression on the mind of some man in the jury box that he was guilty. The prosecution introduced this testimony with double effect to disprove a statement made by Giles to the bank last spring, and to show an excess in his manner of living and accumulations. After all the testimony introduced, Every single fact in that statement was corroborated, and not one single fact contradicted. Their search had been vigorously prosecuted. The widowhood of Mrs. Whitlock and the age of Mrs. Hayden furnished no protection against their monstrous and iniquitous proceedings. Have you given up all, Mrs. Whitlock? Haven't you got a little tin box? We come as friends to you in order to disabuse the public mind. Strange mode of proceeding. It was not enough to charge the defendant with robbing the bank, but something else had to be started. His profession of religion was all hypocrisy, and only a cloak to cover his misdeeds. Even the character of woman, improper intimacy, had to be sacrificed. To such an extent of madness were these reports concocted and circulated. It was an extraordinary thing to charge a man with crime simply because he happened to get along too well in the world. A crime to be rich. A lesson was to be learned from this trial, and if a man wants to get along well, he must keep a diary of his proceedings, how he made this or expended that, so that when they are brought up before a jury, they could show it. It is only extraordinary that the defendant had accounted for the little property he has so satisfactorily. He was a businessman and had a method of attending to his affairs, or else he might have been troubled in the task. He has gotten along too well. True, his tax lists don't amount to as much as some, and is more than others. In reference to that point, we have seen that he has accounted and satisfied you beyond controversy for all his property, without ever having got $1 from the bank except what he got honestly. In this city, we find men who come here 7 or 8 years ago, who had no profession or salary, as far as we observed them, and now see them putting up extensive buildings. If the fact be established that the bank has lost this money, the responsibility was on its directors. They are responsible if they permitted others to steal it. They are responsible for neglect and ignorance of the duty which they assumed. And they are responsible to the people of the state if they cannot account for the manner in which it was taken away. Hence their anxiety in order to get a conviction against this defendant. In conclusion, in going over the mass of testimony, he had left a good many things unsaid that ought to have been said. He left the case of Childs in the hands of the jury, confident that every man he saw before him understood his duty as a juror, that no matter what efforts may be made, even to raise a suspicion from the circumstances of the case, their sense of duty would enable them to stand up and say, "Away with suspicion and your vague presumption, when you ask us to mark with a brand the citizen whose life is a model in itself. Away with them. We will send him forth with such a verdict as to free him from all suspicion." End of section 30. Section 31 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement, St. Louis, Missouri, Part 11. Mr. Williams for the State. Mr. Williams commenced by commending the extreme patience and attention and gentlemanly conduct of the jury during a number of weeks not often occupied in the trial of a single case. In this particular, he coincided entirely with the gentleman who had just taken his seat. That gentleman, he feared, however, had complimented the jury for their patience, because he well knew he was about to tax it greatly more. For although he declared it, in his opinion, entirely unnecessary to make a speech to acquit his client, or to dissipate even the suspicion of guilt, yet 5 long hours had passed by, during all which time he had labored most assiduously to convince them of the defendant's innocence. He would not make any promises as to the time he should occupy. The conduct of the jury up to this period was a full guarantee that he would be heard. He thought Mr. Blennerhassett might well be charged with insincerity, and such charge he hoped himself to escape. Whatever he might say, in what mode soever, without reference to time, he trusted he would be all the while sincere. He did not think with Mr. Blennerhassett that the innocence of defendant was quite so apparent. Much less was he above suspicion in this transaction. He thought it unfortunate that Mr. Blennerhassett should declare himself pure and spotless, and especially was it unfortunate to contend that if acquitted by the jury, he would go unsuspected and unharmed, save by the contaminating touch of the bank directors. But most of all, was it unfeeling in his counsel to urge upon those who were to try him that he should be acquitted, because he was too religious, too pious a man, lived too much for the good of others, not enough for himself to please the directors? Too religious indeed. Many of those gentlemen were professors of religion, and loved a good man as did the jury. Many of them had knelt with the accused around the same altar of prayer, partaken of the communion at the same table, and often, with pleasure, heard him dispense to them and others the bread of life. Lived too much for the world, and not enough for himself. And with this, the directors were displeased, and so persecuted him in a most lawless and high-handed way. Mr. Williams named several of the directors as men who admired just such a character as Mr. Blennerhassett accused them now of persecuting, and being heretofore the warm friends of defendant, had once admired him. But Mr. Blennerhassett has also appealed to the prejudices of the jury, and called upon them to remember that it was a large moneyed power on the one side, and a humble individual on the other, and asked them to aid him in resisting such influences and in putting down the bank. He commented with severity on Mr. Blennerhassett's expression that the bank deserved the deep, everlasting, and eternal indignation of every man who loved liberty, and dwelt at some time upon the impropriety of such appeals to persons elected as jurors, and sworn to try issues of fact according to the law and testimony, without fear, favor, or affection, in this land of freedom. Talk like this might do well enough among the bogs of Ireland, but it would find no favor in American breasts. Such appeals he thought on a par with most of the conduct of the defense throughout the 20-odd days they had been together. All the while, whenever opportunity presented itself, appeals of every sort and character were made by all the gentlemen engaged by the prisoner. They had permitted no one to escape. Even unoffending and delicate female reputation had been hawked about by them with rude and ungovernable hands. They had lugged into the case the handsome widow, as she had been called by Mr. Bates, and her aged adopted mother, over whom they hoped to shed a few tears, and they had, by their own witness, attempted to inculpate Mrs. Shirles, the respectable and delicate wife of the cashier, and they had made a cut-and-thrust business when they could, sparing no one, the counsel opposed to them, the witnesses for the prosecution, the court, whose ermine was white and unspotted, had all been pierced. Indeed, everyone seemed to catch it, except the gentlemen of the jury, of whom they only seemed to stand in fear. With them, and for them all, were smiles and compliments. He himself had come in for no small share of their animadversions. It was apparent to the jury that he had been treated with extreme professional courtesy, social kindness, Christian and gentlemanly deportment by at least one of the defendant's counsel. Such was the bitterness of the pelting storm raised upon him, that at one time he almost felt disposed to bow his head in silence. But, as he was conscious of having done nothing wrong, although, for reasons that must be appreciated, he had been quiet during the examination of the witnesses, he had concluded to present himself before the jury and discharge fearlessly and faithfully, as he could, the duty devolved upon him. Why his name had been so often rung in their ears, coupled along with the visit to Mrs. Whitlock, he was totally unable to opine. If done only to victimize him, he felt assured the effort would prove abortive with many of the jury, who had known him long and well, and he hoped it would fall powerless upon the community with which he had lived so many years. Whatever the intention of the gentleman or the effect it might have, he treated both with deserved contempt. It was not necessary to ensure conviction that the state should identify the sort of money taken by prisoner, if indeed he took any. He was charged with embezzling the funds of the Bank of the State of Missouri, and if it should appear from the circumstances that surround him that he had taken gold or silver, thalers or doubloons, or paper money, he was alike guilty. A count in the indictment charged him with having taken gold, another with having taken silver, another with having taken both, another with having taken paper money, and another still with having taken the funds of the bank. He might be found guilty under our criminal code or under the 47th section of the charter of the bank, no matter what the funds taken were. So they were funds, and no matter whether $120,000 or $100. He agreed with Mr. Blennerhassett in the position that if no positive proof of loss of funds existed, the circumstances must be such as to leave no glimmer of doubt on that point, but expressed his amazement at the assumption by the counsel that nothing had been lost. He said he was not sitting where he could see Mr. Blennerhassett, or he presumed he should have observed a peculiarity in the expression of his mouth or his eye, that unfailing index of the mind, such as the good Swedenborg said, was sometimes observable in those members when certain persons were saying what they did not believe. He could not believe the gentleman in earnest, unless he was forced to the conclusion by his labored speech of 5 hours, and then he thought it argued but little for the innocence of the accused, that a lawyer of such experience and ingenuity should base his hopes of acquittal, not acquittal only, but of all suspicion of crime, on such untenable grounds. If Childs was innocent, why not meet the question fairly, frankly, and claim his acquittal on some sensible, reasonable presentation of the case? It is hardly worthwhile to notice such a suggestion, but as it has been urged with zeal and apparent sincerity, let us examine it, and if it turn out that the jury have any shade of doubt whether the gold has been removed from the boxes in which it was placed by, or in view of the directors, and indeed that the amount claimed to be lost is not missing from the bank, then acquit the prisoner instantly. He contended beyond a doubt by the testimony of every gentleman who had been examined that there were 14 bags of 10 thalers and 2 bags of sovereigns removed from the boxes in which they had placed them, or seen them placed, during the count in February and March last. He said there was no foundation, in truth, for the insinuation that such count and sealing had been induced by suspicion of Charles. That such insinuation had been refuted by the evidence of Mr. Barnes and Colonel Campbell, who stated that as chairman of a semi-annual committee 2 years ago, Mr. Barnes had recommended that the foreign gold, and quite a large amount being on hand, should be thus dealt with, that it had again and again been talked of before the board, but never gone into until the 2nd day of February last, that it was done with reference to the convenience of the thing, that it was counted by tare, and sealed and certified, that it might be more readily gone over as semi-annual or special counts, that it might be known as the amount of specie deposit of the bank, or, at a proper time, be ready counted for transportation east to be recoined, and was done with all the foreign gold of the bank in 1845, that it was done with a view to have it remain untouched as a circulating medium for years perhaps, or it may be till the charter was wound up, all of which was well known to defendant, who had been informed all about it time and again. All that is heard of suspicions against Childs before the count seems to have been what was said by Colonel Campbell to Mr. Barnes just before last Christmas, when those two gentlemen were talking about this very contemplated count. Mr. Barnes remarked that it would be well to have the count, whilst there was a specie teller in office in whom they all had confidence. Colonel Campbell said, "Perhaps you are not aware that Mr. Childs is not above suspicion in the estimation of some." On being answered in the negative, he said he had heard suspicions of him, but this conversation had scarcely any influence on Barnes, who was then, and continued up to the hour of his resignation, his warm and devoted friend, and in the hour of need stood by him with a helping hand, by offering the amendment of confidence of the board to Sarpi's resolution to receive his resignation. And now, forsooth, when Barnes presumes to think and believe him guilty, his touch becomes contaminating and deadly. When are any other suspicions heard of? Not until the February and March count was completed, and Colonel Brandt, Mr. Walsh, and perhaps Mr. Sarpy expressed that some things have been whispered about him, not calculated to do him good. Particularly, had it been said that he lived too high and spent money too lavishly for one receiving a salary of $1,200, and the $20,000 of gold lost 2 years ago was spoken of, and at the suggestion of one of the directors, Mr. Bay was required to examine into the amount of property held by him, which was attended to and reported, which appearing pretty large in amount, it was suggested, doubtless by some friend of his, perhaps Shirles himself, who is devoted to him, that he be called upon for an explanation, which being done, he complied with the request and made a statement, since destroyed by him, and that statement proved satisfactory. At the time he furnished the schedule of his property and effects, with explanatory notes. He tendered his resignation, which was not only accepted, but on motion, as before observed, a unanimous vote of confidence was passed. Colonel Brandt told you about the suspicion was about to point out someone, in your presence, who started them, or had something to do with starting them in his mind, but was stopped by defendant's counsel. After all this, the touch of Brandt, Walsh, and Sarpy, because they dared to believe him guilty of the offense charged, is contaminating. Not only so, but you are told that everything is made to yield to the bank influence, that all landmarks of the law are broken down, and you are warned lest the very liberty we enjoy, and for which some of you and most of your fathers fought, be crushed beneath the iron hoof of the moneyed institution. A general broadcast onslaught is made at all the directors, not only as burglars, but as dishonest men, and men having no business capacity or talent. And you have been told that if on trial any one of them would be convicted sooner than Childs, and so with every clerk and messenger of the bank. And if Poland could be believed, even female purity and innocence would be engulfed and whelmed in ruin, while this pure and immaculate man would be pronounced innocent by acclamation. Mr. Williams defended strongly the directors individually, both as to their honesty and business qualifications, also the cashier and other officers of the bank, protesting against the desire of the defense to make false issues and turn off the minds of the jury from the matters which they were called upon to decide. Again did he allude to the eternal harping upon his own name and Mrs. Whitlock's house, and said that it was not true, as Mr. Blennerhassett had intimated, that the state had brought into this trial injured and unoffending females, widows and aged mothers, that the state had said not one word about them, that whatever had been said about them was forced upon the prosecution by the counsel for the defense, who had, at the very commencement, brought Mrs. Whitlock before the public gaze, and finding that they were not likely to be successful in their efforts with her and her pretended mother, who is not of kin at all, they introduce a witness whose testimony, thank heaven, is not and cannot be believed by any of you, to insinuate that Mrs. Shirles stole the gold. Injured innocence, ruined virtue. How dare they use such terms after their course of conduct here? They deserve rather to be lashed with the scorpion whip naked around the world. Mrs. Whitlock, Mrs. Hayden, Mr. Williams, the bank directors, Brandt, Christie, Walsh, the devil. Anything to call your minds away from the question at issue. Permit them to cut and thrust everybody, and then acquit Giles amid shouts of acclamation, and they will be satisfied. He again referred to his own position in regard to the visit paid Mrs. Whitlock, and the note addressed to the defendant by him, and said that all these things might have been ruled out, but he did not desire it. He wanted no insinuations as to his conduct about anything, that in this whole affair he had not said or thought or done a thing for which he felt any misgivings. He had no repentings to make, that no man had a right to call on him for satisfaction, for he had required none, that he believed in God as a pardoner of sin, and the punisher of offenders against his law, and that he knew that about this whole transaction he had not been asked, and never would be asked, to forgive him, for he had done nothing of which to make such request. He then alluded to the charge made by Mr. Blennerhassett, that the directors were not to be believed, because they were all interested in clearing themselves, and repudiated the thought of their perjuring themselves to convict anyone. He also noticed the argument they might have paid out the gold by mistake, and ridiculed it. He then denied that the amount of the thalers was arrived at by calculation, for the purpose of finding out how much had been taken, and contended that the amount missing was discovered on the 11th of August, when the boxes were first opened in presence of the directors, and referred to one of them, who had taken down, at the time, the amount of 10 thalers in the February and March count, and paid a just compliment to Mr. Engelrod, not only for his integrity and business capacity, but his sharp-sightedness in seeing that a very large amount of that peculiar coin seemed to be on hand. He called the attention of the jury to the fact that, whilst the proof showed that the gold in the chest had been counted first, then the shelf gold, and last of all, that which had been received from the sub-treasury, which, according to Child's own statement, consisted of sovereigns, yet there were 10 thaler pieces found all along the count, among the last boxes a double bag, and even in the very last, number 57, a whole bag of such coin. He said it was a strong circumstance, as he would show presently. The count in December last did not exhibit more than 1/2 the amount of thalers, as was found on hand in February and March, about 2 months afterwards, and he called upon defendant's counsel to explain whence they came, and especially did he ask them to account for their running all along this count, and down to the very last box. Well might Engelrod note their immense number, $425,000 and more, a very enormous amount to have been acquired in 4 years, when, in 1845, after the bank had existed 8 years, there was not 1/3 of that amount sent east to be recoined. Whence did such an amount come? He would show after a while. He referred to the argument of Mr. Blennerhassett, that the same mistake that occurred in number 37 might have occurred in 20 boxes, and asked how it could possibly be, and still the amounts agree with what Childs represented to be on hand, as it did when the count was finally wound up, there being an overplus of only about $5. It was true, he said, that the defendant professed extraordinary powers in making his accounts always balance, but that would have been difficult had such a mistake been made in counting as the leaving off, or adding on to them, of 20 bag of thalers. He asked the jury if they had not been astonished at the wonderful facility with which Childs always brought out his balance correct. At one time during this very count, the proof shows that Engelrod made some mixed gold overrun his say-so, about $400, and it was taken down accordingly, and yet at the end all was straight. And when Walsh reported to him on the 24th of March, there was a difference of $100. It was immediately set right by him. He seemed indeed to wield the spear of ethereal, to possess necromantic powers in producing even balances. He, Mr. W., commented upon the use attempted to be made by Mr. Blennerhassett of the statement of Mr. Walsh in regard to the count in August, and replied at length to the argument deducted that it was for the purpose, by calculation only, of coming at the amount lost. He contended that the loss of $120,921.62 was fully discovered on the opening of the boxes on 11th of August, and so it was proved by every director examined. He said that Mr. Brandt was absent, as he had stated, when he first heard of the deficit, and might now be mistaken in supposing it was rumored 20, then 30, then 40, and at last $120,000. He being, as he assured us, in great distress of mind at the thought of the fearful odds there were against his injured present client, and weeping day and night at the fiery ordeal through which poor Childs had to pass in his unequal contest with this monster, moneyed power. Had Mr. Brandt been here, he would have seen the first statement of the affair to represent the loss correctly. It could not be otherwise, for the gentleman who had a month before counted and sealed it now opened it and found it was not where they had placed it. The gold had been put in the different boxes now deficient, with their own hands, or under their own immediate supervision and inspection, and when these boxes were opened a month or two afterwards, $120,921.62 were gone, or were not found where they had placed them. The first inquiry very naturally arose who had done the deed, and is it not a powerful circumstance, not to prove his guilt, but against the prisoner, that without one dissenting voice all the directors cried out, "It is he, thou Childs art the man"? They had been his friends. They had been associated with him, some of them for a dozen years, had counted and weighed the coin twice every year in his presence, had lent him a helping hand when he was ready to sink, had congratulated him when sunshine lit up his path, had walked with him, prayed with him, and heard him preach, and had loved him, and now not one was found to hesitate about his guilt. Like the sunflower that turns to her God as he courses the heavens, so did they all turn and point at him, and it is certainly nothing in his favor. But why should they have suspected him with such unanimity? End of section 31. Section 32 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement, St. Louis, Missouri, Part 12. Mr. Williams alluded to the position Childs had occupied in regard to the coin of the bank. He was the first specie teller the bank had, appointed in 1837, when the amount of coin was small and easily counted through the fingers, and doubtless when he received it into his charge, like a prudent, cautious businessman, as his counsel represented him to be, he did count it. It was then he opened his specie book, which, 9 in number, have been produced in evidence and are before you. The first entry was on the 29th of August, 1837, at which time, according to book number 1, there was on hand $239,022.47 in silver, and $46,061 in gold, an amount easily counted in a few hours, and which it is assumed he did count, for he has not attempted to prove that any one handed it over to him, as he did to Hirschberg. There was no predecessor of his to hand it over. Ever since that period, these books kept by him represent the daily and weekly amounts of coin on hand up to the period of his resignation, and during all that while, it is a fact that he has been present at every semi-annual count, and always there at special counts and biennial counts, and there has never been any discrepancy in the amount stated by him to be on hand, and what was found to the satisfaction of those counting. Always did matters balance, till he resigned, and then at the very first actual count, a deficit appears of $120,921.62. It is a little remarkable that during the 12 years' existence of these specie books, more than three-fourths of the amount of foreign coin represented to be on hand by Giles are even sums, and they have always balanced. He thought it would be very difficult, complicated and various as was the amounts of the different sorts of foreign coin, to have the aggregate sums so often of even amounts. Hardly ever were they odd, except when there was a count, and yet a balance was readily struck. The amounts found to be in the vault, at least satisfactorily, never disagreed with what he represented to be on hand by his specie book, and if any discrepancy was spoken of, it was soon set to rights by his wizard pen. He dwelt at some length upon the different counts, the mode in which they had been conducted, vindicated the conduct of the directors and their method of counting, and stated that he would, before he left off, tell the jury how he thought the whole thing had been done, and recite the circumstances that pointed to the guilty party. He then spoke of the mode of discovery, thought it was providential in shielding both Shirles and Hirschberg from the suspicion of guilt. It occurred when the defendant was in the city, when there had been no change at directors, allowing opportunity of saying his friends were away, before any sensible man would dream that Hirschberg had become familiar enough with the office to attempt it, before the boxes had been moved, and under such a state of case as to make the matter notoriously plain. No deaths had occurred, no change of officers, no time allowed for change of circumstances in any one's condition that might cast suspicion where it ought not rightly to rest. How was it? Clark and Brothers had been paid a draft of $50,000 in gold, which consumed all of the loose coin of the bank, save about $19,000, and what was in a chest, the key of which was in possession of Barnes, it containing some mutilated notes, which the directors did not wish put again in circulation, but which they were deliberating about burning. Page and Bacon called for $40,000, and Hirschberg agreed to pay them in sovereigns, but not finding Mr. Barnes, so as to get the key of the chest. He went to the cashier and asked what he should do. The cashier told him to go and get one of the sealed boxes of sovereigns, which he did, number 30 having the amount nearest what he wanted, according to the certificate of Mr. Walsh on the outside. This he brought up, and handing it to Page and Bacon's clerks, said if they were willing to take it by the certificate, well and good. If not, to open it there and count it, that it was sealed and certified by the director whose name was on it, but he himself would not be responsible for its correctness, as he had nothing to do with it, and knew not that the count was correct. The clerks opened it, and Hirschberg discovered that there were but 4 bags in it, whereas 5 were marked outside. He told the cashier of it, and Mr. Walsh was sent for, and when he came, like a prudent man, he supposed it possible that the bag might have gotten into another box, counted on that day, and asked that directors who counted with him might be summoned next morning, which was done, and the deficit fully discovered. There were good reasons for believing that the gold was taken and carried away from the bank during or since the count in February and March. That Giles took it, but he nevertheless did not think it was thus abstracted, but that it was taken before this count, and the deficit made good in the foreign gold, which, being true, he could demonstrate it was chargeable alone to defendant. He had now reached a very important point in this case. He had attempted to show from testimony, beyond contradiction, that the gold was removed from the boxes in which it had been packed, and it had been also testified that on the count of August and September, there was found a deficiency in the money of the institution, corresponding precisely with the amount of gold abstracted or removed in the boxes, and he had asked who took it. He could now attempt to answer that question by making it manifest that if it were taken or removed from the bank during or since the count in February and March, it was chargeable upon the defendant, but if it were not taken and carried away then, as he believed it was not, but prior to the count, as he believed it was, and the defalcation made good then, he would demonstrate that it was done by Giles. First, then, was it taken during or since the count, and if so, who did it? He assumed that it was most palpable that there had been no violence done to the vault or banking house in any way, no disturbance of the boxes known to anyone who had deposed upon the subject, no suspicions resting upon or attaching to any person outside for having taken it. Hence, he thought, it might well be assumed that it was the act of someone inside, and if inside, then it was someone who had time, opportunity, and all the means necessary to the accomplishment of the deed without detection. He asked the jury to look at the state of the case as proved, and judge of whether any one of the officers of the bank could have done it. Could Clark be guilty? Take his statement, and the statement of all who were about there, and what is it? In ordinary times he had about as much to do as one could well attend to, in attending to the duties of receiving teller. He did not usually keep the keys of the vault, and had access only in the morning to get out his paper, and in the afternoon to place it again in his iron safe. The vault used to be left open during the day, but of late date, before and since Giles left the bank, it was closed during the day, except when something was needed that it contained. But a portion of the time since the count of February-March, whilst Hirschberg was sick, Mr. Way acted as specie teller, and Mr. Clark kept the keys of the vault. But when he deposed before you, he stated that he only was in the vault in the morning and afternoon, to bring up and carry down the paper needed for his daily transactions, that the porter would open the vault and bring out the coin for the day, while he brought out the paper, and then the door was shut, and remained closed till something was wanted, and so in the afternoon the same thing would be done, and he, seeing the doors all fast, would sometimes leave the key of the outer door in his drawer, where he always found it undisturbed, that he very seldom had occasion to go into the vault during the day, and never except for a minute, and never was there after bank hours. There is no sort of suspicion that Clark has, since the count, opened 16 boxes of this gold, taken from each bag of thalers or sovereigns, containing 1,000 each, and brought it off from the bank. He could not have done so without being detected, and besides, where is the proof that he had access to the seal? Who for a moment believes such a thing of this gentleman? It may be with certainty answered that no one thinks of such a thing. Did Mr. Robinson take it? That gentleman, too, was a witness, and scarcely anyone failed to observe his manner and appearance as altogether favorable to his truthfulness. He stated that he was general ledger bookkeeper, and as such, although he had something to do with Giles, in receiving from him statements of amounts of coin on hand from week to week, yet he had but little to do with the vault, and nothing whatever with its contents, except occasionally to hunt up an old book, that sometimes he would be in the vault more than once during the day, and then he would not visit it for several days, that he never observed what was there, remained but a short time, and always brought up into the banking room what he went for. Now and then he would send the porter down for a book, who would find it and bring it up to him. Is there anything about his visits and business connections with the vault that suggests the thought that he took this gold? Could he or the porter have concealed 1,000 thalers or sovereign about his person, and walked among the clerks and other officers there without detection? If once they or either of them had succeeded in doing so, could they likely have done it 16 times? Take Corcoran, and how seems his case? He has occasionally gone into the vault, too, for the purpose of hunting up some books or papers which, when found, he brought up and used at his desk during banking hours. No more opportunity had he of doing so than Robinson, and would certainly have been detected in the effort to conceal the money, but none of them were ever known to go into the vault, and on coming up to absent himself long enough to go home or elsewhere, and hide his gains. Indeed, Corcoran's home was at the bank. It was there he lived, both day and night, and so regular was he that he swears he was seldom out of evenings till later than 8, and never after 10 o'clock. Not one of the jury could have the slightest suspicion of Corcoran. Did Barry take it? He was never in the vault at all, but when Corcoran was sick last summer, he slept in the bank for a week or so. But how could he get at the gold? The keys, if in Hirschberg's possession, were down at his house, and if Clark had them, the one of the interior door was at his house, while those in the cashier's keeping were locked up in his chamber. So it may well be said that Mr. Barry stood no chance whatever, unless he had forced the vault, and that has never yet been done during the administration of anyone. Perhaps Mr. Way, who acted for Hirschberg a short time, feathered his nest with these 16 bags. He has been examined, and states that he very seldom went into the vault at all. That Clark and the porter were there in the morning, and his coin was brought up to him, and then carried down again at 2 o'clock. Never did he stay long enough among the boxes to open one of them, screw it up and reseal it, if he had been in full possession of the means to do so, which he was not. Then it can hardly be contended that Way did it. Maybe Christie, the porter, took it, his testimony, and he is truthful as anyone. Mr. Clark's statement, Way's, Corcoran's, Robinson's all go to exculpate him from the crime. All he ever did with the vault was to go down on an errand and return with his report immediately, or else he was there in company with someone else, and it would scarcely be urged upon the credulity of the jury that either of the gentlemen named had taken 16 bags of gold, amounting to $120,000, and brought them out of the bank since March last. Their opportunities for doing so were not ample. They had only daytime in which to work, and could not have accomplished such a task without detection. It would have been discovered by those who were acquainted with the arrangement of the furniture of the vault. Who then did take it? As was remarked by Giles to Dr. Forbes, the abstracted money lay between Charles Hirschberg and the defendant. Were any circumstances pointing to either of them as the guilty man? How was it with the cashier? If he took it, then it was in gold itself, for, as would appear presently, no one else did extract it, if done prior to the count but Giles. When did Charles go into the vault and remain there long enough to take out and carry away 16 bags of gold? He swears he never was in that dark place 5 minutes at one time in his life, and that he was never there alone. But he is so deeply interested that you can't believe him. He is a perjured villain. He is bent on convicting Giles to screen himself, say the gentleman. It is not probable that the jury will agree to brand a man who has so long lived in their midst, who has children and grandchildren associated with theirs, who has always hitherto borne a high character for honesty, integrity, and truthfulness, around whom but the slightest circumstances cluster, calculated to raise a doubt of his innocence, unless it be the bare fact of his having keys of the vault, merely to gratify the hungering and thirsting of the counsel of the prisoner. They are hardly ready to acquit Giles, if this act is to convict Charles. The cashier, moreover, states that he has not been in the cashier's room on Sunday, or alone at night, or during the day since January last, when he was sick. The doors have all been so secured that he could not get in without going to someone for the key, and no one who kept that open sesame recollects ever to have handed it to him, except the worthless fellow, Bolin, who himself scarcely dared to place him there alone, but rather left you to infer it from such expressions as these: "I did not want him to see where he went. He went where he pleased," etc. Charles told you the truth, no doubt, and you must feel satisfied that he did not get it, when you reflect that on a salary of $2,500 and housebound, he is poor and generally a little behind. Let us now turn our attention to Hirschberg. Did he take it? It makes me indignant, and the jury should also feel the contempt for the thought suggested against this man by the defense. An honest German, scarcely speaking our language, imposed upon by the same confidence in Giles that imposed upon others, gladly accepting a most responsible post with a small difference in salary. It was testified before you in such wise as to fasten conviction of his truthfulness on your minds, is to be made the victim. It came a little too soon, but it shall at any rate be tried. He tells you that he has never been at the bank since he succeeded Giles, except during the hours of day, and when someone was there, that he was not in the vault unless in the way of business, and then only long enough to attend to that business, and very seldom alone, that he had never touched these boxes till he went for the sovereigns with which to pay Page and Bacon, since he received them from Giles, and that he had, when well enough, been fully occupied in banking hours at his counter. He did not doubt that every honest-minded man would acquit Hirschberg and Charles both, when they looked at the mode of the discovery. If Hirschberg had robbed box 30, would he have brought that to Page and Bacon, and asked them to open and count it before his face? Much rather would he have acted as Mr. Blennerhassett thought Giles, had he remained in the bank and been guilty, would have acted. He would have kept out of view the boxes till they were forced upon him. When he discovered there was a bag missing, did he act as a guilty man? Why tell the cashier something was wrong? Why go over to Page and Bacon's to see if Haight had not taken the bag away by mistake? Would he not have kept silent, knowing there were 15 other bags out of place, which would soon be brought to light? Most assuredly. And if Charles had taken the gold, would he not rather have gone and pointed out the box he desired Hirschberg to pay out, than say, "Go and take a box of that sealed gold," leaving him to select indiscriminately? And when discovered, and Walsh had been sent for, and mentioned the possibility of his having gotten into some other box, counted on the same day, would not Charles, had he been guilty, gone into the vault that night and taken a bag from some other and placed it in box 37, so as to have prevented, if possible, further examination? The person who removed the bags, whoever he was, did not desire a disclosure, or else why did he not leave the boxes open or take all the bags out of every box opened? But on examination of the boxes counted on the same day with 30, it was discovered that 37 was rifled of as a bag, and then it was at the solicitation of the cashier that a full inspection was had of all the boxes, and the whole deficit discovered. The acts of Charles and Hirschberg and their conduct fully exonerated them of all suspicion in the minds of any intelligent, honest man. We now come to the prisoner, and ask how he stands. The gold was brought up by him and the porter, and when counted and compared with his own memorandums and representation of amounts, it was taken by him and the porter and carried into the vault. How long the porter remained in the vault it is not known, but we may well suppose a short time. There he left in the vault at twilight, when all about the bank were gone, and how easy for him, if he desired it, to open a box, take out a bag, screw on the top, and reseal it. He had all the materials at hand, and had plenty of time and no company to watch or detect him, either in the vault or as he came out. He could have taken the bag and brought it out and borne it off, and no one had ever seen it, unless, indeed, Bolin had discovered it, and if so, he might have easily bribed him with a handful of the shining dust, for a man who will deliberately swear a falsehood would readily accept such a bribe. He told Dr. Forbes, not that he took it, but that it was carried off a bag at a time. Besides, he has been known to visit the bank at night, so bleak and so cold as to be remarked from that circumstance, and last winter more than once did he do so. Another circumstance, though small in itself, a very weighty one in determining this case, existed against defendant, and that was the purchase of wax in such quantities as would be required to reseal 16 boxes, which on close inspection would be found to correspond precisely in color and quality with the wax on the upper seal of each rifled box, and different entirely from that on the lower seal and untouched. But I shall say more of this circumstance presently. The jury will agree that Giles had a better opportunity to take the money during or since the count than any other one in or about the bank, but he did not hesitate to say that in his opinion it was taken prior to the count, and then the defalcation made good. He did not expect the jury to believe for a moment that it was taken bag by bag and brought out of the vault by anyone, since it was put into the boxes by the directors. Certainly, no one took it or wanted it for circulation, or else why not take doubloons or sovereigns in large amounts, or in preference to all other American coin? Thalers were too unusual to be circulated in such amounts without suspicion. Even sovereigns would scarcely be plenty enough, but American gold might have been used with very much less suspicion than any other, and yet that was passed over, and 14 bags of thalers taken, and 2 of sovereigns. If it were wanted for use, why not remove all from a box? No, gentlemen, the manner in which the thing was done is enough to convince anyone why it was done at all. The money had been used before, and the defalcation was made good in this foreign coin. It will be recollected that Childs was specie teller, and as such might readily take paper money and place it to account of specie, and no one find it out, without actually counting the coin. This was testified to by Mr. Clark, who, while he swore that no paper money in large amounts could be taken from his bulk of paper in the safe without his knowing instantly, yet he also stated that the defendant might very readily pocket paper during the day and charge it up to specie without detection. Mr. Clark never stated, as Mr. Blennerhassett had said, that no paper money had been taken. As long as Childs retained the confidence of the board, and especially of those who were pleased upon the semi-annual counting committees, how easy was it for him to deceive them, as he has deceived the whole board. Mr. Barnes, who has been for 10 years a director, has served on almost every semi-annual committee, and the warmest and greatest friend of the prisoner all the while, helping him out of all difficulties, till this trial came. Then he could not aid him in his escape from the Siberian bog that was ready to engulf him, lest he too might be carried down to its deepest bottom. Then, and not till then, did he lose confidence in the man, and for relinquishing his hold upon him, he is now denounced and introduced as a dishonest man, whose touch is contaminating, is death almost. The defendant had the confidence of others, Christie, Yateman, Walsh, indeed of all, but Brand himself has been his friend heretofore, and it was only necessary and very easy to abuse that confidence, and thus succeed in covering up his defalcations from time to time, as he had doubtless done for years before. Mr. Williams here referred to the December count and to other semi-annual counts of the coin of the bank. Generally, the gold was weighed in the course of 2 days, usually one chest today, the other tomorrow. Never was it all counted or weighed in one single day. How easy could Childs, when part was weighed today, take from it what he wanted, with which to make up any deficit existing, and place it with that which was to be weighed tomorrow, and if he did not thus change the position of as much as he wanted today, could he not take out of the morrow's count and put it on the shelf? In December last, it happened that both chests were weighed on the same day, and then look at the amount found on the shelf. $230,000. 50 or 70 bags more than even Boland had ever seen there for any purpose. Why so, unless it was to swell the amount as he wished? The jury can see how easy it was in February and March, when going into the vault with the sealed boxes, to take with him the screwdriver and seal, the wax he had in his pocket, and open a box, take out a bag, and place it where it would be recounted. Open another and do likewise, till he had got the amount wished for, and then all was snug. Now, Childs knew all about the reasons for this count. He knew the coin was not soon to be disturbed in any way, and he knew that thalers were very seldom paid out by the bank, hardly ever, so that he would be very anxious to place his deficit just where it has been found. Here it is worthwhile to recur again to this wax, bought a second time at Fisher's, and the jury would not fail to see how important a circumstance it was, particularly as in color, texture, and equality. It agreed precisely with what was used in resealing the rifle boxes. It did not prove of itself that Childs took the money, but it was a strong circumstance, and this was a case depending entirely on circumstantial testimony. If such a state of things did not exist and stand around defendant, as prevented his escape without tearing them down, they should acquit him. If the proof so surrounded him with little and big things as unerringly to point to him as the guilty man, he would be found guilty. Now the jury see how it is that thalers are found scattered all along the line of these 57 boxes, a circumstance under the proof accounted for in no other way. It was taking them out of the boxes where they had already been placed, and sending them up to be recounted. Here too will be seen the necessity for borrowing bags of Clark, as it was proved he did. The bank had never borrowed bags before. They were to be had anywhere, and had always before been purchased, but he wanted old ones, lest the sight of new ones coming before the eyes of the directors too often might excite their curiosity and produce inquiry. Moreover, it is in proof that the gold was already in bags, it being thus kept always in bank. The seal was where he could get it, and it is proved he did have it on the last or among the last days of the count. He threw it on the table and asked Mr. Agarwal to take charge of it. But that was after the defalcation was all fixed, and on that very day, after the boxes counted had been carried below, and after candle lighting, while Mr. Agarwal was counting some old mixed gold. The pecuniary condition of the defendant was a powerful circumstance against him, and in favor of the theory he advocated. In larceny it was well considered a bad sign to find the person charged growing suddenly flush of the article stolen. In embezzlement it might as legitimately be urged against a man accused that he had been growing rich much too fast for his means, and if such charge were not met and explained satisfactorily, at least it should have its effect upon the minds of a jury. The accused here, it had been fully shown, went into the bank poor, and the evidence most conclusively proves that he left it a rich man, wielding his thousands. But before going into that, let's say what he represented on that subject. Just after the count in February and March, at the instance of some of the board, he was asked to furnish, and did furnish, a statement of his property and effects, in which he said that he held most of the property appearing his, of record in trust for others, that he had, when he came into the bank, $1,200 in cash, and had saved of his salary $30 per month, that he had built some little houses in Franklin Avenue, and collected the rents, that he had sold a lot on Morgan Street by which he realized a profit of $600, that he was only worth about $8,000, an amount accumulated, as he stated, from his rents, sale of Morgan Street lot, and salary saved, except $500 or $600, which he had made by occasionally shaving a note or lending money. This paper he borrowed from the cashier under promise to return it, but which he destroyed, and when called on, refused to exhibit. The circumstance of his stating an untruth about his property, when called on to speak, if he did do so, is greatly against him. He need not have answered at all, but he should have told the truth when he did speak, and the circumstances of his now withholding the paper is not a favorable sign. Well, what is the proof in regard to his present pecuniary condition? He, Mr. W., here exhibited an account current, in which he stated all the items proved as having been bought and paid for by him since 1837, and gave him credit for all the money he proved had passed into his hands, whether his own or that of others, including $4,000 of sawmill accounts handed him by his brother Joshua, and $5,000 received from the cemetery, and $3,600 paid him for the church by Rucker, and $5,000 paid him by Schumer, and there was still left a balance in his favor of $27,561, now absolutely owned and possessed by him, putting down his real estate at first cost. He said that his property in that account, now held and owned by him, and his notes and cash, were well worth $40,000. In this estimate, nothing had been said about his family expenses, gifts, and other extravagances. All these he had left out, and balanced by his salary, which everyone knew was not more than half sufficient to meet them. The account current made out from the proof showed that he had received and spent since '37 $51,665, and that he had paid out to others, supposing he had paid over the church and trust funds received, $4,635, putting down sawmill accounts in full at $4,000. But what he now owned was his home place and improvements, proved to have cost, putting the land at $14 per foot, $9,048.82. His Pine Street property, the improvements costing $2,500. His personal property, estimated by himself $1,800, and his cash and notes $14,212.69, making the aggregate of $27,561.51. He stated he was worth about $8,000, and the jury could judge of the truthfulness of such statements and his reasons for underrating his property, and it was for them to judge whether his large property had been honestly acquired. This calculation had nothing to do with his deposit account at Clark's, which was more than $10,000 per annum for the last 5 years. The jury had a very painful duty to perform if they should conclude to find against the defendant. The very few juries were firm enough to march right up to the verdict against one who had enjoyed the reputation of Giles, who had for 10 years been known as a minister of a numerous and influential church. If painful as it might be, they should not shrink from the discharge of the high duty placed upon them by the state and the accused. It was not the first instance in which the ministers of the gospel had been accused of high crime, nor was it entirely new that those wearing the livery of heaven could fall. Lucifer was an angel in heaven, enjoying the very presence of God, and he fell, and to that fact we owe the existence of a hell, for the punishment of sin. Other striking instances of error in men called good were enumerated, and he concluded by saying that it was more than probable that he should never as advocate address this same jury, or they as a body occupy their present position, that it was not for him to know what they thought about the guilt or innocence of the prisoner, but they would certainly meet on a day that had been appointed for all to be judged, when they would find out, as he had no doubt in the plays of eternity, they would anxiously crowd around. When the defendant was called upon to give his account of the deeds done in the body, to hear the truth in regard to this astounding defalcation. End of section 32. Section 33 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 13. Mr. Wright for the defense. December 1st. Mr. Wright. Gentlemen of the jury, with the permission of the court, I may say, at the suggestion of the court, I rise to take part in this debate. The argument is pressed upon us by the bank. I say bank because I prefer substance to form. The representative of the state has long since disappeared from the cause, with a becoming propriety. He has treated the state as a nominal party, and thrown the responsibility of this prosecution upon the attorneys of the bank. In numbers they are a regiment, and in quality, veterans, or if not all veterans, juniors who make up in zeal what they lack in discretion. If the gentleman were present who last addressed you in full view, and under the searching gaze of that eye of his, which reads the souls of men, I would repeat what my colleague, Mr. Blennerhassett, uttered, and that is, we do not deem argument necessary to a verdict of acquittal. Mr. Williams is charitable enough to doubt our sincerity. The best proof of that is the proposition made by Mr. Bates on our behalf to submit the case. If it had been acceded to, the jury would have been possessed of the cause and might at once have disposed of it. But the bank is hostile to such haste and precipitancy. 22 days of grave and solemn deliberation by the most attentive jury ever impaneled in a civil or criminal cause were not enough for decision and judgment. A calendar month must be devoted to a bank case. In the spirit of monopoly, it demands a term of the court. Perhaps some deference is due to it as a legislative creation. The lawmaking power gave it being, endued it with passions, but breathed into it no soul. Eyes it hath, and there is speculation in them. Hands it hath, and enough of them to touch at once every interest of society. But there is no heart in its anatomy. Of the natural agents who surround this artificial being, I may have to speak. I shall, of course, approach such dignitaries with appropriate awe. Against them I shall utter no insinuation. What I mean I shall charge, but never say upon compulsion, and then only to return the poisoned chalice back to their own lips, which they prepared for Giles. I repeat it, we are forced into this argument. Upon full consultation, we did not deem argument necessary for the vindication of our client. I take it we are safe guardians of his interest and honor. Here, safe at least, as he may find. At all events, he asks no other. But Mr. Geyer says, argument is indispensable. Indispensable? Why? Indispensable for what? To vindicate the bank? To postpone the hour of honorable acquittal? To disgrace by epithets the man whose liberty they cannot destroy? Was not every lawful interest of the banker's state safe in the hands of the most patient and attentive jury that ever tried a cause? Or were you, gentlemen, to be made competent dispensers of criminal justice and faithful administrators of the law only by the electrical eloquence of a Williams, the impassioned logic and high philosophy of a Leslie, and the wit, sarcasm, and analytic power of a Geyer? The court also has deemed argument necessary in consequence of the peculiar nature of the cause. Gentlemen, I grant that this is a peculiar cause, got up in a peculiar way, and sought to be maintained in a peculiar manner. But while I do not see how these peculiarities should beget debate, rest assured we do not shrink from the argument. No, not even from such an argument as 'tis decided we must have. An argument which violates the universal logic of debate, by keeping those who hold the negative ignorant of the ground to be occupied by those who hold the affirmative. An argument taken not from the schools of philosophy, not from the accustomed and sanctioned forms of debate, when truth is the object and fairness the rule of investigation, but which comes borrowed from military tactics and the strategies of war, wherein the policy is to deceive the adversary by feints and maneuvers, and to win a victory by opening upon a surprised and unguarded column the artillery of a battery held in mask. An argument which reverses the true and lawful position of the accuser and the accused, which puts the accuser in possession of all that may or can be said by the accused in his defense, and withholds from the accused what is to be said against him. An argument allowable only in such tribunals as put upon the state but the easy task of accusation, and on the accused the weighty burden of proving his innocence. From such debate as this, against which, as you know, we have in vain protested, we do not recoil. We are not frightened by such formidable odds, and with the proper respect for the power of the champions of the bank, as well those who have gone before, as those who are to follow, we fear not the issue of this contest, for we are clad in the triple armor which all may wear, who have their quarrel just. What has the bank lost? I do not narrow the question down to embezzlement or larceny, for a bank may lose by mistake, by indiscretion, by bad management, by negligence, without either embezzlement or larceny. But my inquiry is a broad one, and on the modes in which a bank may lose. What has the bank lost? It is one of the peculiarities of this peculiar cause that the investigation of 20 days cannot furnish an answer to this plain question. On the 11th of August last, the president of the bank, the head of the corporation, backed by the nominal cashier, Judge Shirles, I say nominal cashier, for his part is the beau ideal of a sinecure, keeper of the cash, as the word imports, charged exclusively with the funds of the bank, by the express provisions of the charter and bylaws, put under large bonds, as he is, for the faithful performance of this duty. He has managed to shuffle off the entire responsibility. He is considered by universal consent of the directory to have nothing to do with the money, has never handled a dollar of its funds, in paper or in coin, and has ever avoided all visitation of the vault, as forbidden ground to him. Backed by this nominal cashier, the nominal president goes to Justice Butler on the 11th of August last to swear a loss, embezzlement and larceny of moneys of the bank. By joint affidavit they commit their consciences to the fact that between the first days of January and April 1849, $121,000 in gold were embezzled and stolen from the bank. They swear the gold thus taken consisted of 10 thaler pieces, money of the Kingdom of Germany, and sovereigns of the coinage of England. They swear that they have good reason to believe the defendant stole and embezzled said coin, and that a part thereof is hid and secreted at his residence on 15th Street in this city. In virtue of this swearing in duplicate, they obtained from the justice one warrant to arrest defendant and another to search his house for the lost thalers and sovereigns. They also swear that this enormous loss in thalers and sovereigns was discovered and ascertained on that day. The next step is to present their affidavit to the assembled board of directors for verification and approval, and forthwith the board approves the swearing, approves not merely the proceedings taken on the swearing, but the swearing itself. The consciences of the nominals and the conscience of the bank, if it have a conscience, are thus pawned for embezzled 10 thalers and sovereigns, amounting to $120,000. Gentlemen, this looks like an answer to my question, but what have you just heard? The gentleman who has just taken his seat, one of the authorized agents of the bank, placed here to speak not only for the cashier and president, but for the entire corporation, after performing elsewhere for it important service. This representative of the bank, and guardian of its interest, pronounced this swearing an egregious blunder, a capital mistake, a total error. He pronounces gravely that the consciences of these gentlemen were committed to a false fact, that not 1 thaler piece, nor sovereign of gold, was taken from the bank. He gives 40 reasons to prove the thing impossible, and dismisses the idea as an unmitigated blunder. In his own emphatic rhetoric, this is all fudge. We have, therefore, bank authority for saying the corporation stumbled at the start, and we shall see it has never gained an erect position in the entire race of this prosecution. If not 10 thalers nor sovereigns, the question recurs, what has the bank lost? Light broke in upon the bank from some quarter soon after the swearing. They did not search the house of Charles for secreted gold, and when they searched another house, the search was for anything but gold. They abandoned altogether the idea of lost gold. It could not be maintained, though it started in plausibility. In February and March, 57 boxes are filled with gold and sealed up. On the 11th of August, following, they are opened, and $120,000 are gone. Gone in the shape of 10 thalers and sovereigns. Divine Providence opens the boxes, and the same power, perhaps, keeps the gold within the bank. The gold was not taken from the bank, says the counsel. Not from the bank, echoes the whole directory. The abstraction, which we have heard repeated so often, is the most abstract of ideas. It never goes into the concrete. The abstraction is not from the bank. 'Tis only from the boxes. Gentlemen, let me explain to you this twist in the corporation. They found themselves caught by the first swearing. They found it impossible to make Giles guilty if the gold was taken from the bank and out of the sealed boxes. They knew they could not show against him the sine qua non of all crime, opportunity to do the deed. They knew he had been 3 months absent from the bank, without keys to the vault. They knew he never, at any time, slept in the bank, as did the nominal cashier and others, and that daylight could afford him no means to pack off their gold. Stern necessity drove them from the ground they occupied, and forced them to take a new position. They backed out from affidavits verified by the board, and gave a new phase to the prosecution. If justice or magnanimity were bank qualities, they would have abandoned the charge and sued for peace. But a corporation has no soul. They hated the man because they had injured him. Besides, they felt the instincts of self-preservation, and yielding to their double impulse, they resolved to carry on the war. They changed their front, and mortifying as it must have been, they said, "The bank has lost no gold." Magic is invoked, and they proclaimed that necromancy deceived them. They counted $120,000 in gold more than they had. Giles fooled a subdivided directory in the only accurate count they ever made, fooled them in broad daylight and before their faces, and made them recount 10 thaler pieces and sovereigns. He cheated them by magic to cover up a prior defalcation. A prior defalcation where? A prior defalcation in what? If you lost before, when was it and what was it? The question comes back. What has the bank lost? Who proves any prior defalcation? We have heard as witnesses the entire corporation, save Mr. Sarby, a sick director, and the supernumerary watchman who reinforced the bank about the time of the Nesbitt robbery. 23 of the 25 guardians of the bank have been on the stand, and not one of them gives the least modicum of intelligence of any prior loss, and your 4-time defalcation. Gentlemen, perhaps the most remarkable aspect of this remarkable cause is that what was lost by the bank is so little a matter of fact, and so much a matter of opinion, that it was solemnly objected by the bank, and as solemnly decided by the court, that a director should not be questioned on the subject. The evidence was gravely ruled out, on the ground that the witness would be testifying only to a matter of opinion. That is a fact, and it is one without parallel in the history of judicial trials for crime. A bank robbed of $120,000, and the lost matter, a mere matter of opinion. The loss is to be proved not by the evidence of those who lost it, not by the guardians and keepers of the treasure, but by Cocker's arithmetic. It was not coin, says Christie, one of the directors, neither gold nor silver. That is impossible. It may perhaps have been paper. That is impossible, says Clark, the paper teller. I know the paper is all safe. Was it Shawnee Town notes? No. Cupidity has never been aroused to touch them. Was it Illinois bank certificates of stock? No. Was it suspense account, the mysterious generic symbol of assets? No, not that. Then in the name of all values, I ask, what was it? And the echo comes back in reverberations from the bank room, from the cashier's room, from the lumber room, and from the vault. What was it? As the blind voice said of light, can anyone tell me, what was it? No mortal man in the shape of a witness can tell. If one could have been found in America, he would be here. The pains taken by the bank to bring Boland here is proof of this, and in the absence of all human testimony, Mr. Geyer invokes the shades of Cocker and Dilworth, like Warren Hastings on the trial of the unfortunate princesses of Oude. The bank seeks to establish crime, not by any known code of laws, nor by the mouths of witnesses, but by the multiplication table and the rule of 3. I suggest to Mr. Geyer an error in his policy. Algebra would have been a higher authority in the case, for it is said to be the science of computing by symbols, and treats of unknown quantities. Gentlemen, are we to surrender our common sense because it is a bank that prosecutes? Must we give up our reason and our laws because a bank demands a victim? Let me suppose a case. One of your neighbors, you gentlemen of the jury from the country I speak to, is a grower of stock, consisting of horses, mules, oxen, sheep, and hogs. You meet him on a beautiful morning, say the 10th of August, 1849. You find him in a frenzy, the victim of intense excitement. He tells you he has been robbed of his stock, has suffered immensely in that way. From the generosity of your nature, you deeply sympathize with him in his distress. You tell him that if you can in any way serve him, he has only to command you, and you express the hope that a kind providence or remunerating justice may restore the loss. With a view to give him practical aid in his misfortune, you inquire, "What's gone? Was your loss in horses?" "No, I missed no horse." "Mules?" "No, the mules are all safe." "Then the blow has fallen on your oxen. How many were taken?" "I can't say that I have lost a single ox." "You were fleeced then. Your loss has been in sheep." "No, thank Providence. The sheep are all secure, not a lamb even missing." "Well then, it is quite clear that your entire loss is hogs." "No, fortunately there was no asportation of my hogs, but my loss in stock has been immense." "Gentlemen, you would feel that your neighbor had sustained one heavy calamity, not the loss of stock, but the loss of his senses, and you would be inclined to breathe the prayer that medical skill or kind providence might speedily restore him. It is the bank and their advocates here that give us pause upon the question of loss. They open 57 boxes containing gold. They discover $120,000 of gold missing, and instead of standing on this ground, the ground upon which the defendant stood at the time when he was asked for his opinion, they abandon it wholly. They adopt a new hypothesis. They declare no gold was lost. The lost gold ceases to be the corpus delicti, the body of the crime. It sinks into a motive, an argument merely, of a prior defalcation, of something not gold. That something, whatever it may be, if it be anything, becomes the body of the crime, and that something this bank has not been able to show. Is Shakespeare or common sense, and they are one and the same, for the immortality of the bard rests upon the solid basis of his common sense. Be authority, the loss which the loser can't define, and does not know, is no loss at all. Mr. Geyer undertakes, however, in the absence of all testimony, to prove it by arithmetic. Now, gentlemen, with a proper basis, arithmetic may prove much. I do not object to scientific deductions from certain insufficient data, but such results are evidence and amount to knowledge. But what is Mr. Geyer's basis? What does he begin to figure on? It must be some book of the bank, some count of some committee. either legislative or semi-annual, or some one of the various sworn statements made by the nominal cashier to the legislature or the public. It can be nothing else. If a book of the bank, what book? Is it the specie teller's book? That, Mr. Geyer has already repudiated as utterly uncertain and deceptive. Is it the daily balance struck at the closing of the bank at 2 o'clock, evidenced by the balance sheet? He repudiates that also as no test of truth. Is it the weekly statement? That he condemns likewise. Is it the general ledger? You have heard him denounce that. Is it the individual ledger, as it is called? You know that book has been at war with the general ledger from the beginning till now, and the utmost skill of accountants has not been able to make peace between them. Remember, gentlemen, my client does not make nor keep these books. Is it the count of any semi-annual committee of the bank? Mr. Geyer tells you none of these can be relied on. Is it the report of the legislative committees, made every 2 years upon examination of the affairs of the bank? He tells you these are worse still. All that is left is the cashier's sworn reports, and Mr. Geyer acquits him, and he perjures himself of all knowledge on the subject. What, then, is to be the basis of the arithmetic? Is it to be the specie book of the teller? Now, gentlemen, what has been the affirmative testimony brought by the bank itself to disprove any defalcation by Childs? They have verified his specie book by every mode in which that bank can verify anything. First, by the daily balance sheet not made by him, then by the weekly statement, next by the general ledger, next by the actual examination of a committee twice a year, who report that, by count and by weight, the money called for by his specie book was found and ascertained to be on hand in the vault. Then, by the legislative committee sent down by the governor, who informed the General Assembly in written reports, sanctioned by their oaths, that they too have, upon actual inspection, count, and weight, found the same thing. And lastly, by the cashier, who, as exclusive keeper of the cash, in virtue of the solemn express provisions of the Charter and the bylaws, under the sanction of an oath too, has verified the accuracy and truthfulness of the specie teller's book. In the face of all this array of confirmation and approval, Mr. Geyer denounced the specie book as false by denouncing all the corroborations furnished by the bank. He declared that unless he could get rid of those various countings, weighings, and reports, the prosecution must stop at once. He therefore repudiated the entire mass as false and unreliable, and yet to this repudiated mass he must resort to get the data of his arithmetical testimony. If there be one count in all the numerous countings of the bank in which a single truth can be picked out of the surrounding mass of error, which is it? Is it the December count of 1848? That count has been severely condemned by the advocates of the bank here. And mark you, these countings are not the work of Mr. Childs. He made no count. It is the work of the bank that is repudiated, and repudiated because it sustains Mr. Childs. Of that count in December 1848, it was said by Mr. Haight, who opened the case, before the introduction of a witness, that it would show the important fact of a presence, at that time, of $100,000 in 10 thaler pieces, less than there appeared to be present in the February-March count, and that emigration and other causes between December and March would not account for the decrease. Mr. Williams further said in argument, after the evidence was closed, that this turned out to be a fact from the testimony in the case. Now, gentlemen, you know that there has not been one word of evidence, documentary or oral, in figures of speech or figures of arithmetic, as to how many 10 thaler pieces were in the bank at the December count. You know that the only proof attempted to be introduced on that point was the calculation of Mr. Christie, a director, which calculation was never heard by any one of you, and was not given by the witness, because the court excluded the evidence as illegal, it being confessedly a calculation made by the use of arithmetic, with no foundation to start upon. You know that the witness was told to say if he knew how many thalers were there in the December count, whether he learned the fact by figures or otherwise, and that the witness told you he did not know, and he did not even attempt to guess. There was no other evidence offered on the point. The written report of the committee who counted did not specify the kind of coin counted. It stated that they counted so much in foreign and so much in American gold. And what is quite fatal to the assertion made and urged in argument without proof is that at the count in December, there was more foreign gold by about $100,000 than in the count of February and March. I demand then to know what count Mr. Geyer will make as his basis. Mr. Geyer said, "I will show you in my speech." Yes, show me in his speech when there is none to reply. But I defy the gentleman to show it in any way but by speech. He has repudiated every other basis. Will the count in February and March be relied on? That the most accurate of all the counts made by the bank, the only count by tail, is particularly deceptive. That was the count by magic and conjuration. Will the June count do? No, it is only another specimen of error, furnished by the semi-annual committee of the bank. How of the August count? That was after Childs left the bank, after the discovery, after the entire corporation had rashly and specifically plunged into this prosecution, and were deeply interested in shaping appearances to support a cruel charge. It was a count, too, loosely made for public opinion, to sustain the credit of the bank. Count the rents and holes of which they tried to patch up by a September count. Gentlemen, Mr. Geyer finds himself in this awkward dilemma. If he does not repudiate the books of the bank and its various countings and reports, he cannot establish a defalcation against the defendant. If he repudiates the books and the countings, he destroys the basis of his arithmetic. It is a painful quandary for the bank advocate. His discretion is confined to the question, which horn of the dilemma shall he mount? He will only follow the footsteps of the bank. They have been at arithmetic to prove a loss. They set Christie to work at it as far back as September, and brought him here to prove this sum. But the count said the figures would not work, and Mr. Geyer must now try to prove by a closing speech what Christie could not swear to. My colleague, Mr. Blennerhassett, in his very able speech, attacked the figuring of the directors in the argumentative loss. He showed how they had forced this sum. Mr. Williams, in reply, admits the fact, but exclaims repeatedly, "What difference is it? They proved something." A friend of mine at the moment gave me an anecdote in point, which I furnished to Mr. Williams as authority for his view of the case. A plaintiff in Kentucky brought a suit for damages against a neighbor for the loss of his nose, bitten off, as he alleged, by defendant in a fight. He proved the loss of the nose by 3 respectable witnesses. The defense relied on was a trial by inspection of the plaintiff, who was in court with the face bandaged to the eyes. He asked the court if it was lawful for him to insist that the bandage be taken off. The court decided it to be every way proper, as the jury might more clearly see the ravages committed upon the plaintiff. The sheriff, in obedience to the order of the court, delicately and tenderly performed this office, and exposed a proboscis duly elongate, a fine development and entire integrity. It seemed to court and jury a full defense, but the counsel for the plaintiff asked the court, "What difference is it? We have satisfactorily proved by 3 respectable gentlemen under oath the loss of the nose." Gentlemen, the first thing to be established in any prosecution for crime is the crime itself. Until this be made certain, it is useless, it is unlawful, to inquire who did it. The law does not warrant an investigation to find out who perpetrated a doubtful crime. Under our criminal code, The magistrate must first ascertain certainly that the crime charged has been committed, and then, but not till then, may he hunt for the offender. It is cruel, as well as a lawless proceeding to act otherwise. I ask you then, are you satisfied that the body of the crime has been established upon all the showing of the bank? Has not the bank, by its course, taken altogether, involved this question in reasonable doubt? The law demands that this matter must be made sure. It will not put to hazard the meanest man's life or liberty by violating this rule. The caution of jurors in court is invoked by Hale on this point. Men have suffered on the gallows for supposed murders. The dead body must appear in evidence. Life must be proved to have been taken before you have a right to ask who did the homicide. 'Tis not enough to show, as Mr. Williams supposes, Caesar's robe to prove he was murdered. The rent made by the dagger of the envious Caruscus is not enough to prove him dead, nor would it be enough to show that he felt pierced with wounds at the base of Pompey's statue. The heart of the great Caesar must have been stilled forever. If I am forced into the other inquiry, who did it, I shall have an unpleasant task to perform. It is quite possible that I may not use the softest epithets, the tenderest adjectives, furnished by our language. Indeed, I think it probable that I may have to use the knife. If I cut deeper than the skin, I will avoid an artery if I can. But if, unhappily, I touch a vital part, and death ensue, put down the consequences to those who make the operation necessary. You were told by the gentleman, Mr. Williams, and often too, that we claim a verdict of acquittal because the defendant is a preacher. At this point of his argument, my client handed me a hastily penned note, penned in your presence, and while the speaker's words were ringing in his ears. I read it as the best and only reply which I shall offer. Reads, I discard all claim to clemency from the fact that I am a preacher. If I am not innocent from the testimony and from the showing from the bank itself, then let me suffer. End of section 33. Section 34 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement, St. Louis, Missouri, Part 14. Gentlemen, the cause you are trying is one brought by a mighty moneyed power against a single man. I leave out the state, for the state of Missouri is as much a nominal here as the cashier is a nominal in the Bank of Missouri. In this contest of the many against one, what is the spectacle exhibited? The accusers are agitated. The accused is calm. Frenzy, trepidation, and terror seize the bank. A universal horror pervades the corporation, but their intended victim is self-possessed and serene. Surrounded by the conclave of directors on the 11th of August, shut up under lock and key, and listening to the proclamation of war sounded by the board, who of them saw dismay upon his brow, or pallor on his cheek? The accusers paint to you the scene of agitation, but they have not dared to speak of any tumult in his breast, of any tremor of his eye, of any quiver of his lip. It was the bank alone that trembled. Without reproach, with a mild bearing but erect mien, he tells them he is innocent, and will defend his innocence to the last. And what was the secret of this agitation? They knew public suspicion would rest upon themselves. All of them had access to the funds. Opportunity favored them with facilities to rob the bank. To screen themselves, they resolved upon Childs, long absent from the bank, as a victim. That resolve was sudden, and if simultaneous as Mr. Williams has declared, they knew it to be a step of hazard and full of difficulty. The common bond of interest united his accusers. They determined to sink or swim together, and you behold them signing together the first manifesto and the last, though each manifesto is flatly at war with the other. You have witnessed here, gentlemen, the mild, calm, quiet bearing of my client in every stage of this remarkable trial, looking his combined accusers full in the face, and wearing in his aspect the resignation and composure which the Christian faith teaches to be a duty and an attainment. I have seen him elsewhere, by his own fireside, with his household gods around him, and there, as here, I have beheld only the quietude and calmness of a soul unruffled by persecution. Is there nothing in all this? Does not this mere surface aspect of the case help you to decide it aright? For many years it has been my fortune to defend men accused of crime, and I have found it ever a hard task to reconcile confusion, trepidation, alarm, flight, or falsehood with conscious innocence. And it is a yet harder task for any guilty mind to counterfeit a soul at ease. The way of the transgressor is hard. You were told by Mr. Williams that one strong circumstance against the accused is the fact that 12 of his warm, devoted friends, the directors of the bank, turned against him suddenly, in a minute, to use his own words. He represents these 12 gentlemen as men who would be the first to fly to the succor of my client if the lightning in the cloud beset his pathway, and this in virtue of the religious faith and common worship which bound their hearts together. It is lamentable to witness the sudden extinction of that ardor which perished from its own intensity and could not endure a moment's trial. Such friendship is doubtless honorable to our nature and would be very valuable if it could last. But strong emotions soon exhaust themselves. A colder sentiment, exhibiting itself in a far less torrid enthusiasm, might have perhaps availed my client more. Be this as it may, these kind and loving directors have high authority for the quick transition of their feelings. One of the disciples of Christ sold him to his enemies for a moneyed consideration, while his lips were yet warm with the kiss of love. And another of them, of a generous nature, denied his master under the instinct of self-preservation. These examples strongly support the directory, but they break the force of the argument, for if the Savior of mankind was betrayed by his disciples without the commission of an error, the friends of Charles might turn from him and he be innocent. Other examples, if need be, might perhaps be found of men who drop their friends, as trees their leaves in wintry weather. But is it law that when a man's friends desert him, to save themselves, he shall go to the penitentiary for it? Gentlemen, there must be a mysterious influence in the atmosphere of a bank. It makes of men and their corporate character what they would be ashamed to own as individuals. How else can you account for the enormities perpetrated by this corporation against our laws, against enlightened public opinion, against the most sacred sentiments of civilized man? The bank arrests Childs and drags him before Justice Butler. He gives bail in enormous bonds. He is free. He goes to his own home, shielded by the laws and constitution of his country. But the bank demands a higher security than constitution or laws can furnish. It throws around his home a chain of sentinels, night and day. The myrmidons of the bank guard his residence, stop all egress, and subject to search and imprisonment every citizen who passed the threshold of his dwelling. The defendant himself, on the next morning, it being Sunday, starts to the Sabbath school, of which he was the useful and honored head. He is stopped at his own door by the bank and driven back. The same lawless monster seized a pious and unoffending young gentleman, put him to the search, and found in him guilty possession of a volume of Clarke's commentary on the Bible. Appealing to law for redress, the bank starts with the violation of law. It outraged what is more valuable even than gold. It trampled under the foot the Bill of Rights and Constitution of the state. Gentlemen, you have been cautioned by Mr. Williams not to be hasty. He tells you to come to your conclusion slowly, carefully, cautiously. He more than intimates that a spontaneous verdict would be criminal. He conjures you as a bank advocate not to acquit from the box, and he begs you to retire and read over a bundle of specie books in the jury room. After his active service performed on Spruce Street and his eloquence here, it would be unkind not to accommodate him. I have never asked a jury to acquit from the box. In a long practice, I have left the mode and manner of acquittal to the sound sense and sound discretion of the jurors. But if any case could make me change my course, it would be the cause in which you are now sitting. Mr. Williams has laid down for your guidance a safe rule. You are not to jump to conclusions. You are to be slow and cautious and weigh all matters well. But how was it with the 12 friends of the defendant, those tender gentlemen whose hearts ran over with the milk of human kindness? They changed in the twinkling of an eye. How was it with the gentleman himself? Oh, if he had followed the rule prescribed for others, his agonies had been spared, and I the pain of commentary. There is, gentlemen, a deep mystery in sudden conversions, baffling the reasoning powers of man. Take 2 illustrations of this, which I borrow from my own profession, both lawyers, one on the road to Damascus and the other on his way to the bank. Saul of Tarsus, the bitter enemy of Christians in the mountains of Syria, falls to the earth and rises on the instant their fast friend. The fostered animosity of his heart is turned to love. We pause before this prodigy and ask its cause, and the light which fell upon his pathway and the voice he heard are the answer. On the morning of the 13th of August, Mr. Williams learns the unhappy destiny of his friend, the defendant. His soul is moved by sympathy. His generous nature is touched to the quick. The friendship, which started in kindly intercourse and social endearments, had ripened into brotherly love at the altar, and the communion table burned with ardor and panted for expression, and it found it in these memorable words. Monday morning, 13th August, 1849. Dear Brother Childs, I sincerely sympathize with you in your distress. If I can in any way serve you, command me, and may a kind providence shield and protect you. Yours truly, W. L. Williams. Gentlemen, in the same hour, the writer of that note was at the bank, in full consultation with its directors, planning the foray upon the widows of Spruce Street. What light burst upon his pathway, what voice he heard, is not given us to know. But the bank breathed its spell upon him, and straightway the currents of his soul were changed forever. In the light which the evidence has furnished, we can better understand the object of the prayer put up in the concluding line of that missive of friendship. Executioners have been known to mutter prayers for the victim lying under the uplifted axe, over beasts ornamented for sacrifice. Prayers have been said, and it may be the touching appeal to Providence in behalf of my client was made to shield him from the effects of the meditated outrage about to be perpetrated upon a defenseless and unprotected woman. I acquit the bank and its emissaries of any hostility to that lady. She had by no act aroused its animosity, nor would she have been stricken but that, through her breast, the javelin of the bank would better reach the heart of Giles. The atrocities of that expedition have no parallel in history, unless they be found in the plunder of the Begums by Warren Hastings. That governor of British India, aided by Confederates, gratified his rapacity for gold by robbing of their treasure 2 old women, the unfortunate princesses of Oud. The deed itself was splendorous enough, but the manner of its execution has consigned him and his instruments to infamy forever. One of these old women had a son, who was Nabob of Arcot. Hastings tried to seduce that son in virtue of an obscure passage in the Koran, to claim that treasure as his right. He failed, but emboldened by defeat, he awed that son into the robbery and plunder of the mother that bore him. A letter written by one of the unhappy victims set the outrage in so clear a light that he feared its effect upon the British Parliament. He trembled at the anticipated indignation of the English nation, finding a voice in such statesmen as Fox and Burke, and Sheridan and Pitt. He framed a pretext for his violence, and gave out that these old women were engaged in open rebellion against British power in India, and that the treasure seized by robbery was a justifiable confiscation for treason. He bribed a British judge to get up evidence of the rebellion, to the eternal shame of England's judiciary. This judge, in the person of Elijah Impey, traveled through Hindustan to find a rebellion, and returned with a bundle of affidavits about as numerous as the street rumors borne to Mrs. Whitlock by the emissaries of the bank. These affidavits consisted not of proof of hostile armaments, of forces organized, of expeditions planned, of battles fought, not of forts erected, not of collected munitions of war, but of paltry hearsays, unfit to be produced in any court of justice upon earth. The plunder of the Begums soiled the character of a nation. It stained the ermine of the English bench. But those were not all, nor the greatest of sacrifices. Hastings outraged the human heart. He violated the sacraments of nature by seducing, awing the son to plunder his mother, and thus breaking the primal bond of society. He was condemned to deathless infamy by the moral power and avenging genius of Sheridan and Burke. What was the crime imputed to the unfortunate and unprotected widows of Spruce Street? Accessories after the fact to the embezzlement of the bank, to be proved by street rumors issuing from the lips of insolvent slanderers, not one of whom could pay $1 in damages for their insolvent defamation. The confiscation of a widow's property by fraud or violence was the smallest part of the outrages of this marauding expedition of the bank. The natural bearing of man to woman was forgotten. The appeal which her condition makes to the heart of civilized or savage man was silenced or unheard. What civilization teaches to be her due from our sex, under all circumstances, was indecently disregarded. All delicacy, all sympathy, all sentiments common to the rudest specimens of male nature was violated, and to give a climax to these atrocities, they were perpetrated in the sacred name of friendship. Gentlemen, man, though fallen, is not all evil. A ray of divinity, a portion of the glory of his lost estate, still lingers about his heart and warms it up to noble action. The sentiment of friendship is born of this principle. It elevates the man above the suggestions of mere selfishness. It inspires the martyrdom of sacrifice. It prompts him to brave disease, danger, death for another. And this noble sentiment, which dignifies while it adorns its possessor, was degraded into a vile expedient for plunder, to gratify the rapacity of a bank. If its officers were ever thus exhibited, it would indeed be what one of England's sweetest poets ironically called it: a name, a charm that lulls to sleep, a shade that follows wealth and fame, and leaves the wretch to weep. My colleague, Mr. Bates, asked of these kind, gentle friends why, in the presence of strangers, they told the lady her character was blurred upon the streets. He asked what benign object moved their hearts to this affectionate disclosure. Was it gratuitous insult? Insult to one who, as a visitor and associate in their own domestic circle, was hailed by the endearing title of friend? Oh no, not that. The object was not so base as that. It was only to disabuse the public mind. Disabuse the public mind of what? Disabuse it how? Disabuse the public mind by seducing her through the wiles of her pretended friendship to own her guilt. Disabuse the public mind by enticing her to the surrender of embezzled and secreted gold in order to proclaim her doubly criminal. Surely, frenzy and fatuity never before mustered up sorrier logic than this. The truth is, gentlemen, this absurd mockery in the nature of things could not last long. The friends of the lady grew weary of the part they were playing, and suddenly throwing off masks and dominoes, they stood before her, the fully revealed inquisitors of the bank. Soft words gave place to intimidation. They surround their victim with images of terror, and appealing to the innate sense of delicacy, which never wholly abandons woman in her lowest degradation. They threatened to expose her body to the vulgar embrace of police inspection. I cannot believe that even the frenzy of the bank, which spread like an epidemic among all of its agents and instruments, could have driven these gentlemen to an extremity so lawless and unpardonable. Far as they did go, they would have stopped short of this enormity. It was only their design to subject her to a moral torture. They only meant to put modesty and delicacy upon the rack. They did not intend to inflict corporal pain. Their milder purpose was to lacerate emotions and tear to pieces only the finer fibers of sensibility. But if their real design had been what their words imported, they must have sunk lower than a bailiff's part to witness its execution. They must themselves have executed it. Cousins and Phelps, hardened as they are by daily contact with the degraded and the vile, lawless as they have become by hunting down desperate criminals, rude as they must be by reason of the rough customers with whom they have to deal, and callous to delicacy, as a policeman's life may well have made them, Cousins and Phelps would have recoiled from an act involving both an atrocity in law and a desecration in manners. Gentlemen, they did not intend to go so far. In very truth, they were delicate inquisitors, as Mr. Forbes informs you, and when they spoke the language of intimidation, their honeyed accents and sweet manner and gentle looks acted like an anodyne upon the victim's agitated nerves, and took from the scene all idea of a duress. The genius displayed in this delicate and difficult operation by bank inquisitors forcibly reminded me of a scene in the Midsummer Night Dream of Shakespeare. I take it that Nick Bottom, the weaver, furnished the model for bank action on the subject of duress, per minus. You remember, gentlemen, how the honest but unsophisticated villagers, represented in that play, were bothered by the lion's part in that most lamentable comedy and most cruel death of Pyramus and Thisbe. The difficulty was to play the lion's part and not frighten the ladies, but the genius of Bottom, fruitful in resources, suggested two expedients. First, a prologue, to be spoken by Snug the joiner, cast for the lion's part, his face half visible through the lion's neck, in words like these: "Ladies, or fair ladies, I would wish you, or I would request you, or I would entreat you, not to fear, not to tremble, my life for yours. If you think I come hither as a lion, it were pity of my life." And in case the soft words of this soothing prelude failed to quiet all apprehension, Bottom himself would seize the part, and by an aggravation of his part, roar gently as a sucking dove, nay, roar and twir a nightingale. I repeat it, the delicacy of the Spruce Street plays was borrowed from Nick Bottom, the weaver. It has been said of Shakespeare that he has described with matchless fidelity not only every animal now known to naturalists, but man in his whole nature, however modified by climate, by education, by habit or vocation. The poet did not live in an age of banks. There was nothing in the past to teach him how a moneyed incorporation might modify the character of man, and yet his universal genius had shadowed forth the image of a bank director without a memory and with a memorandum, in the person of Snug, the joiner, who, lacking memory, wanted the lion's part put down in writing. In full view of all the outrages on female character committed by the bank, Mr. Williams vindicates the forbearance of the prosecution. He tells you the female reputation is too sacred to be brought into court. Yes, gentlemen, the bank is fastidious on that subject. It does not drag women into court. It contents itself with plundering them of their property and blasting their characters out of court. The gentleman tells you of his own agony and bloody sweat during the examination of a witness. Why did he sweat? It was an examination of his own witness, not only a bank director, but a volunteer and busy agent in those scenes in which the gentleman himself was chief actor. It is Dr. Forbes who paints them. Has he exaggerated the picture? It is a false position which brings the agony. The gentleman put himself beyond defense. He voluntarily placed himself in that bog of which he speaks, in which every struggle only sinks him deeper, and which endangers all who come to his relief. Why, he asks us, did we parade his note to Childs, written, as he tells us, in the generosity of his nature? I answer, to show that while he writes from the generosity of his nature, he acts from the generosity of the bank, and that in this competition of generosities, the bank generosity always triumphed. This contest of antagonistic powers reminded me of the struggles to which the man was subjected, and he united in himself the characters of the epicure and the philosopher. He said in all the conflicts between his philosophy and his stomach, the stomach got the advantage. But the entire corporation is honest. All within the bank are honest men, incapable of uncharitable thoughts or wicked deeds. Some of them are honest because they come from Ireland and Germany, and some because they did not. Mr. Williams is the universal bank endorser and gives us specimens of his skill in biography. Perhaps hereafter he may write the lives of officers and directors, and then he will, doubtless, favor us with the history of their accumulations. The book may be valuable as teaching enterprise a lesson. Perhaps it may point the way to riches and form a valuable appendix to Smith's Wealth of Nations. Among other useful hints, it may, peradventure, show how fortunes may be made by grazing mules upon the barrens of our country at 5 bits a head. The book, gentlemen, may furnish information which we tried in vain to procure in this trial. The first director we questioned on the subject took shelter under the broad folds of the Constitution, which saved him from self-incrimination. When this city of refuge was pointed out, we deemed it useless to push the inquiry, for it was roomy enough to take in the body corporate. End of section 34. Section 35 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 15. Again, gentlemen, Mr. Williams has deemed it politic to tell you that the officers and directors of the bank are not prosecutors of Mr. Childs. They are his friends, who come here reluctantly, with deep sympathies in his behalf, under the process of this court, and in the capacity of state's evidence. I know not how to reply to this, for there is something in it which stifles a reply. Why is the gentleman here? Why are his colleagues here? Whose money brings them here? Whom do they represent? A friend gave me an anecdote when this remarkable argument was uttered. I do not apply it. I leave to others the application, and I offer it as an illustration of the general character of state's evidence. A preacher, rating the sins of his congregation, threatened his hearers with the terrors of that judgment day, to which Mr. Williams has adjourned this cause, selecting from the mass a sinner taller than the rest, who gave no tokens of contrition. He said to him, "Sir, in the day of judgment I will testify against you. In that day I will be a swift witness against you." "Very likely," replied the wicked one, "for I have always heard that the damnedest rascals turn state's evidence." Gentlemen, if indeed these be friends of my client, God save him. They come to crush him, to save themselves from suspicion, from prosecution, from damages for false imprisonment, from damages for malicious prosecution, from damages on the attachment bonds they have signed in the other wing of this building, and from the retribution of public opinion. They know if they fail here, a day will come, not distant from the hour in which I speak, when a new frenzy may seize the bank and shatter every nerve of cupidity in its complex organization. That day, for aught I know, may, like the 11th and 13th day of August, be the era of sudden conversions, and loose friends shall be fast once more. The choicest subject for eulogy is found by Mr. Williams in the person of Mr. Hirschberg, the specie teller and keeper of the keys of the vault. He calls him Honest Hirschberg. And why so honest? Because he was born in Germany and breathed the pure air of her mountains. This beats the baptism of Achilles in the fable Styx. One unhappy heel of the Grecian warrior was left unwashed by the charmed waters, and became subject to mortal touch. But German sunshine bathed the infant Hirschberg in every part, and rendered him impervious to ill forever. I had not known that German air was the moral elixir of mankind. I take it, gentlemen, there is no statute against embezzlement in that country, and the hangman's office, like a cashiership and bank, must be a sinecure. If it had pleased Providence to place the Garden of Eden, not as is supposed, on the banks of the Euphrates, but on the Rhine, how changed perhaps had been the destiny of man. My client, gentlemen, was not so happy as to see the light in Germany. It was his misfortune to be cradled in the land of Washington and Madison, of Franklin and Jefferson, and the sunshine of his native hills, the hills of freedom, brought him no exemption from the errors of the fall. There is a German on this jury, and it may be a son of Aaron also, and this may give the key to what has fallen from Mr. Williams. I respect the man who loves his native land. It is a natural sentiment in man, but I could not respect the intellect of him who did not regard this fulsome appeal to his pride of country as an insult to his understanding. What does Mr. Williams know of Hirschberg or Germany? He is a stranger to both. Of Hirschberg, he knows only that he speaks good German and bad English, and is specie teller of the bank. The advocate of the bank never grows weary of one theme, the friendship of the prosecutors for the man they prosecute. His last ornamental proof of this false fact is borrowed from the sunflower. Gentlemen, in my youth's summer, amid the sunshine of my native hills, I tested to my satisfaction the truth of Moore's beautiful lines. I found the poetry, but not the fact. I could never find the faithful flower following the sun below his meridian, and when he set, their faces were turned the other way. The directors, I grant, are fair specimens of sunflower friendship. He asked why these sunflower directors and officers did not turn against Judge Shirley's. And why was he not arrested? The gentleman thinks there is something in this, and so do I. I repeat his question. Why was not Shirley's arrested, the man of all others, having greatest opportunities to rob the bank? I go further, and ask why all were not arrested who had the greatest access to the vault. Common fairness, private and public justice, demanded this step, or if the director had not evidence sufficient to warrant arrest, why not start an investigation to this end? Gentlemen, the bank started wrong. Childs had been absent from the bank on the 10th of August. 3 months. Hirschberg, his successor, had carried the keys of the vault, one set of them, in all that period. The cashier always kept another set of keys, was keeper of the seal, lived with his family in the bank, had absolute power over all subordinates, and could, as Mr. Williams has fatally admitted, go to the vault alone on any night of the year and leave it unmolested. And yet the directors turned from these gentlemen, to say nothing about others, and take the affidavit of Judge Sherrills for the arrest of the defendant. I know little of this bank or its councils, but that I voted for its charter upon one express precedent condition. I bargained with the democracy, and they obtained my vote upon the bargain, and that was that they put Colonel O'Fallon in its directory. I trusted to their promises, and they fulfilled them and put him in. But I believe since then they have put him out. I know but little of the councils of the bank, but I can well imagine the confusion of the board on the 11th of August. There were not enough of them, free from suspicion, to make common cause against the rest. They were all involved, some because they kept the keys, some because they slept in the bank, others because they had access to the vault or had their hands in the gold. They cut the Gordian knot, which entangled them, by making common cause against a man who had been in the bank. They determined to give Childs a chance to defend himself, with sealed lips, while they would swear themselves clear on the witness stand. The first step of the bank was a blunder, and it has tottered on in blunders to the last. I am not the accuser of Judge Sherrills, nor of his lady, nor do I charge embezzlement on honest Hirschberg, not because he was born in Germany, but because I am not sure that a single dollar was taken, because they back out from lost gold and rely upon an argumentative, inferential arithmetical loss of something not defined. But if I were sure that the crime was committed, still I would not accuse him of it, nor any bank agent or officer, for the evidence does not warrant the charge. But when Sherrills and Hirschberg come here to damn my client by the force of circumstances, I point then to stronger circumstances against themselves, furnished by their own testimony. This is not unjust nor unlawful. I have another reason, and it is a weighty one. It is from the evidence more probable that the bank, if robbed, was robbed by outsiders. An important fact leaked out on this trial. I say leaked out because it lay snugly concealed among cashier and directors, till after 15 days swearing it dropped out of Cochrane, perhaps because he was an Irishman and could not hold back what was in him. The bank was notified of a meditated robbery, credibly notified so as to awaken the vigilance of its guardians. Cochrane is confirmed by Bolin, and Sherrills, brought to destroy Bolin, confirms the whole matter. The bank was to be robbed, and now, under what facilities is the question? Gentlemen, it is put beyond controversy by the evidence that the only step necessary to rob the bank from the outside was to bribe a mulatto girl, the slave and servant of the cashier, and she, in all probability, a street strumpet. It is but beyond dispute that whenever this slave would go to the porter of the bank and ask for the key in the name of Mrs. Sherrills, the key could be had. This was enough, all that any skillful burglar would ask. But if he wanted more, it could be had. The seal and the cashier's set of keys to the vault were accessible to the servant, in the room in which, daily, nightly, she performed her menial service. Gentlemen, why were these important facts kept back? They tend to exonerate all the officers of the bank from everything but negligence. But unfortunately, they tend also to acquit my client. Mr. Williams denies that any suspicion of Childs caused the February-March count. He labors to establish a thorough confidence in the man, to strengthen an argument founded on that confidence. How can he get rid of the positive evidence on this point? The evidence of Walsh, of Barnes, of Brandt, and perhaps others of the directors. What does he do with the emphatic testimony of Colonel Brandt, who says that he and Walsh dissented from the vote of confidence, and who also swore that suspicion of Mr. Giles was one among other causes moving to that count? True, Brandt is contradicted by the record, but which is false, the record or the witness? True, also, that Brandt involves himself in inconsistency. For, when pushed to know if he had not tried to induce the bail of my client to give him up and send him to prison, he said that he had not, but had only said to one of his securities, "Up to Saturday, the 10th of August, I would have gone bail for Mr. Giles myself." Why, then, did he refuse a vote of confidence? A question hard, I take it, to answer. But Brandt has as much right to be inconsistent as any other witness for the prosecution. Besides, it was only the coin in the charge of Giles that was counted. The paper teller passed untouched. His paper was not counted. It is manifest that the object was to ascertain whether the coin for which they held the defendant exclusively responsible was in the vault, in the quantity specified by the books of the bank. What ground will be ultimately taken by the bank in this prosecution, the defense cannot possibly know. For 10 days we all engaged in a hunt for lost gold. On a sudden, the cause took a new phase, and since the case is to last the period of a moon, we are to have all the phases of that satellite in its orbit round the earth. We get the grounds of the bank in driblets. My colleague, Mr. Blennerhassett, started in the dark. He was forced to make a speech for the bank in his own mind, and then answer it himself. I have heard Mr. Williams, and I try to answer what it is deemed safe for him to disclose in the way of argument. Mr. Bates will listen to whatever shall be considered politic for Mr. Leslie to give out, and when all our voices are hushed, a power above us all will present the actual strength of the bank. The skirmishing of the fight will have ended, and the corps held in reserve, the old guards of the prosecution, will, by an unexpected but decisive charge, end the day. Of my friend Mr. Geyer, gentlemen, I heard before it was my pleasure to know him. I was told that his intellect grasped all subjects with vigor, but exhibited a creative power in the field of circumstantial evidence. What I have heard I have witnessed, and this advocate, almost bending under the laurels won in a long professional career, is held back to present the cause of the bank when every other voice is stilled. There was a time when the accused couldn't know what was to be said against him, but that day is past. I trust there is a power in the land to bring it back again. It is a great point with Mr. Williams to show that the object of the February-March count was to prepare the gold for shipment to the East. Now, on this point the directory were divided. Some favored that policy and others opposed it. Among the latter was the director, Walsh, but I am willing to give the bank advocate his position, as far as he claims that the foreign gold was not to be used, and that Giles knew it. Does he not perceive that this argument destroys another great argument for the bank, that the foreign gold was sheltered and screened by the American gold, so as to prevent access to the former? On this hypothesis, there was no motive to render it difficult of access. It was capital not to be resorted to, and the fact excluded a guilty desire to put it behind entrenchments. This is not the only instance in which the gentleman has answered himself. He told you that one remarkable circumstance against defendant was the fact that he was present at every count of the coin in his charge, and yet before he concluded, he gave you many excellent reasons why it was proper he should be there. Absence or presence at the countings, or both, are made the evidence of crime by this ingenious advocate of a shifting prosecution. If absent, the defendant would be guilty of neglect of the bank and of injustice to himself. If present, he is there to practice a fraud upon the counting committee. I know not how to answer these arguments, but by saying they amount to a suicide in logic. But there is another circumstance which, in the opinion of that gentleman, bears heavily against my client. Mr. Child's accounts were always found to be accurate. It is said to be wonderful that this should be true. I see in it nothing remarkable, unless it be remarkable fact that the bank contained one officer who was at the same time accurate and honest. Ability as an officer and integrity as a man are generally considered adequate causes to bring about correct accounts. Indeed, I know of no other safe guide to such results. He tells us that Hirschberg blunders in his countings, and 'tis proof of his honesty. To be accurate is to be criminal. Then God help the painstaking and the careful, for they will need his aid. This overturns law and custom, and introduces a new rule of evidence. If a man walk the slack rope, 'tis proof of his intoxication. If he staggers on the streets, 'tis evidence of his sobriety. The argument furnishes an admirable shield to cover scoundrels. A legislative committee go to the bank to examine its condition. They go to the cashier and to the minutes of the board to ascertain how much coin ought to be in the bank. They descend to the vault and count and weigh it, and find what ought to be there. This is proof of the guilt of Childs. Suppose they did not find it. Suppose they found it missing. That would establish his innocence. Gentlemen, before our adjournment, I noticed some of the circumstances pressed upon your consideration by the advocate of the bank, Mr. Williams. I did not notice them for any intrinsic force in them, but because they were magnified by the gentleman's mode of treatment, as the liver of a goose is said to swell under the operation of a French cook. Let me pay some attention to a portion of his bitter invective before I pass on to the remaining links of his chain of circumstantial evidence. He complains loudly, not only that the scenes of Spruce Street are brought before you, but that we did not introduce the unfortunate victim of those scenes as a witness on the stand. Gentlemen, I appeal to your hearts for approval of our conduct in both respects. My client could not fail to see that the outrages she endured was suffered on his account, that her character was blighted by the bank to crush him, and that being the innocent and unconscious cause of her wrongs, it was his duty to vindicate her. We, as his poor advocates here, feel it to be ours to expose, if we can, the origin and the authors of her wrongs, and to restore, as far as may be, a reputation foully, cruelly, and unjustly tarnished. We do not bring her here. We would save her the agony of this unseemly ordeal, but we will defend her here, though that defense should rouse the vengeance of the bank and all its advocates. Why was she not dragged here by the bank? What sentiment of delicacy would restrain it? Her name was on the list of bank witnesses, and she was summoned by the bank. Why was she not introduced? The bank had a motive for its action, but that motive was not delicacy. It would immolate her here without remorse, as it crushed her elsewhere without compunction. Why was not the gentleman himself put upon the stand? Why did he shrink from a cross-examination? He was chief actor in most of these scenes, and sole actor in one of them, and that the most secret of them all. Why did he not take the stand? He found fault with the picture drawn by the volunteer director, who accompanied him on the expedition, and was part of what he saw. Why did he not come to retouch it, to soften shades, or bring out into clear relief the parts left too obscure? Perhaps, gentlemen, if he had taken the stand, we might have learned what we in vain inquired of others, who it was that gave information to the bank of improper intimacy between the lady and my client, and when, and who suggested the plunder and the search. The gentleman found it more prudent to speak than swear, to asseverate than give evidence. The counsel argues that it is a remarkable circumstance that, The loss was ascertained at the first count after defendant left the bank. The argument is remarkable, but the circumstance is a fiction. The entire statement is untrue in point of fact. Childs resigned in April, left the bank on the 5th of May, and the semi-annual count by committee was made in June, and the alleged loss was not ascertained till the 10th of August, and when discovered, there was no count. The discovery was made by act of providence, not by count. It was the finger of God that moved the heart of an honest German to put his hand on box number 30, which wrought the discovery. Mr. Williams has breathed the atmosphere of the bank, and his memory fails him. He has forgotten the revelations he made at the council of the deity concerning box 30. He asks me, gentlemen, how 10 thaler pieces got into box 57. I answer him, the counting committee of the bank put them there. They got into box 57 just as they got into box 5. There is no mystery in it, nor crime. They got there as guilders, sovereigns, francs, and doubloons got into those and other boxes. The committees counted the foreign gold before the American coin, but they did not exhaust any denomination of foreign coin before proceeding to another denomination of foreign coin, and that is the conclusive answer I give to his question, put to me with an air and manner which implied difficulty to answer. In connection with this question, he told you there were only $220,000 of 10 thaler pieces in the bank at the December count. How does he know this? There is not a syllable of evidence in the cause of that subject, as I before explained to you. Christie's arithmetic, not Cocker's, Mr. Geyer, was all the evidence offered on that point, and the court decided it was not a good textbook here of law or evidence. It was ruled out and got into the hands of Mr. Williams, and he makes his speech upon its authority, or he has confounded in his memory a rumor heard in the bank with what he did not hear in testimony. But if it had been read in evidence, what would it amount to? Had they shown what was the increase in the bank of that kind of money between December and the last of March? They tell you such coin would be received by the bank with alacrity, but not paid out. This would account for its accumulation, and the merchants tell you in their testimony that such coin finds its way into the bank and does not enter their counting houses. As to the emigrants who bring it here, they come at all seasons when the river is open, in great numbers, and deposit their wealth with the bank or brokers on arrival. Mr. Williams has thought proper to burden the case with his personal griefs. He is hurt when auditors smile. I should not notice his remarks but for the imputation which they convey. He told you men were hired to come here and laugh at him, if I may supply the ellipsis. Hired by whom? Does he mean by my client? As one of his advocates, I say that, in my opinion, it would have been exorbitant in bystanders to take pay for such service, if tendered. They might, as reasonable men, consider themselves amply compensated by the amusements offered. Men spontaneously and naturally laugh at the ridiculous, and if the gentleman has voluntarily placed himself in a false position, he should use philosophy and bear the consequences. But he insists that the money could not have been taken by anyone but the defendant. He exempts Charles because, he says, that though he had at all times a set of keys to the vault, he never used them, except on a few occasions when the specie teller forgot to bring his. He discharges Hirschberg from all imputation because he was born in Germany. Gentlemen, while I am not satisfied that foreign birth is a conclusive test of honesty, I do not hold it to be any proof of crime. I bear Ireland and Germany no ill will. I have felt a deep and true sympathy for them in all their wrongs. I have watched their struggles for liberty with the lively interest that springs up spontaneously in the heart of an American, and my hope has been and is that Germans, Irishmen everywhere, may rise to the native dignity of manhood, and throw off the incumbent weight of despotism that oppresses them. If I do differ from them as to some of the means of making steadfast the structure of liberty in my native land, I have not lost one touch of sympathy for my kind elsewhere. Gentlemen, I find it difficult to answer arguments drawn not from the light of reason, but from knowledge of the counsels of the Almighty. Mr. Williams has monopolized the part of vindicating the ways of providence to man. He tells you when the deity stoops from his high estate to regulate the affairs of the bank. Hirschberg descends to the vault as an instrument of providence to pay off the check of Bacon and Page for $40,000. To me, this matter seems as mere business transaction. He went down not for box 30, but for any box containing an aggregate of sovereigns suited to the payment to be made, and he saw a box better suited to the payment than box 30, but it was more inaccessible, and he took the other. The box not taken, the box most adapted to his payment, was more entrenched, more difficult to access than the one he did take, and yet it exhibited no deficit. What becomes of the argument about entrenchment, the great argument of violated boxes being hidden, sheltered, and so obstructed by a criminal design as to conceal the violation? But again, and I wish you to mark it, Hirschberg went down not to count or ascertain the number of bags of gold in any box, but merely to find an aggregate suited to his purpose. He carried with him the memorandum of the loose gold he had counted, and he looks for a box, the aggregate of which would make up the sum of $40,000. It is unreasonable to suppose, especially in the absence of all testimony on the point, that he went down to study or memorize the endorsations on the boxes as to what committee counted and what each man counted, or the number of bags they counted and put into a box. He went for an aggregate sum in sovereigns and for nothing else. If even he had read the entire memorandum on the box in the vault, its contents would have slipped his memory before he reached the top of the stairs. Recollect what passed in your presence. Helfenstein, a director, testifies on the stand with the box before him. He reads from the endorsation on it. He is questioned about the endorsation, recurs to it with his eyes again and again, and speaks from the vision. I took the box from him and asked him to tell the jury, if he could, whether the endorsation was on the side or top of the box. You know that if his life had hung on the answer, he could not give it. Well, Hirschberg carries the box number 30 upstairs and tenders it in payment, informing the young men who brought the check that he would not correct any errors found in that box. This was the first introduction of a new rule. Before that time, in all the money transactions between the bank and the house of Bacon and Page, boxed coin was taken without being counted, under a rule, which was reciprocal, that errors should be corrected, if of excess to be refunded, if of deficiency to be made good. This rule had, from the beginning, been universal. But Hirschberg says, I will not correct errors in that box. Hirschberg retires to the vault or behind the counter, and the box is opened by the young man in his absence. Before one bag is counted, Hirschberg returns and says, Where is the other bag? Mr. Williams, feeling the force of his testimony, says there was the top of the box before Hirschberg's eyes, and he read the call for 5 bags and saw only 4. But there is no evidence of this. Hirschberg does not say so in all his testimony. He utterly fails to account for his intuitive knowledge of the missing bag. And Reed, who opened the box and began the count, represents Hirschberg as inquiring for the 5th on his approach to the spot. Suppose these circumstances had appeared in evidence against Giles, how damning would have been their force! How soon the lightning of Mr. Williams' eloquence would have flashed upon such dark and guilty indications. But this is not all. Who prepared and brought here a fraudulent map of the vault, a map made to convey and impress a false idea? Mr. Hirschberg is on the stand as a witness. After he has been examined on various subjects, Mr. Haight takes from his papers a map and has it sent by the marshal to the witness. The counsel tells him there is a map of the vault, and he wishes to know of the witness if it is correct. The witness answers in the affirmative. In the meantime, I obtained a sight of the map, and before the witness was turned over for cross-examination, I denounced the map as fraudulent in your presence. The fraud was evident on the face of it. It did not give the contents of the vault. It was confined to the relative situation of the foreign and American gold, and shut out from view every relative position of the silver and gold to the large chests which were in the vault on either side as you enter it. It presented the vault as empty, save the box gold, and omitted everything calculated to show there was no design to render the boxes containing the foreign gold inaccessible, and to give force to the idea of the alleged entrenchment of the foreign gold behind the American gold. This map gave not only a horizontal projection of the boxes, but a perspective view of them. The map was prepared, carefully prepared, to show a guilty design in placing the boxes in the vault after the count of February and March. I ask again who prepared the map for evidence against Childs. The answer is Hirschberg. By cross-examination, we learned what he had no right to suspect from the manner of its introduction here, or from the examination in chief, a close connection between the witness and the map. Gradually, and step by step, we ascertained that it was all his work, done at his instance, without the instruction of the board or of any authority in the bank, executed under his dictation, the artist, Ottawa, who drew it, being utterly ignorant of what he was drawing. It was a drawing, not of what the artist saw, but only of what he heard from Hirschberg. Gentlemen, why was this thing done? Why did this man, during the progress of this trial, put himself to the trouble of preparing a map in perspective of the foreign and American gold? It was not a map of the vault. It was a map of the gold. Why did he do this thing? If he had made or procured a fair map of the vault and its contents, from whatever motive, we could not complain. But it is a circumstance worthy of comment that a false and fraudulent map should be prepared by him and brought into court to impress a false idea. It was not only a map made by hearsay, but the hearsay was in November, and purported to give the position of boxes in May last, and this from the memory of a bank officer. You know how testimony coming in the character of a map is likely to impress us. It presents the idea of accuracy. It smacks of care and attention, and excludes the notion of a guess. In all sincerity, did not your minds recoil from the imposition when you learned the history of the drawing? A map, a perspective, made upon a hearsay. Well, all this is done by the man who has carried the keys of the vault since the 5th of May last, who would not correct the errors in box 30, who by a kind of intuition discovered there was a bag missing out of it, who could see from a distance a memorandum calling for 5 bags on the top of the box, when the young gentleman who opened the box and saw nothing to suggest a deficit, and who was the first to break a long-established custom of the bank without a suggestion of change by the cashier or the board. End of section 35. Section 36 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 16. But this is not all. I am not yet done with Mr. Hirschberg. His next step is to call attention of the several inmates of the bank to the peculiar arrangement of the boxes, in inverted order as to numbers. He is busy on this point after the 10th of August, but never before. In the whole period of his tellership in the bank, from the 5th of May to the 10th of August, he never suggested to anyone that arrangement of boxes and market. No one but Mr. Hirschberg ever saw them in that position until after the bank was in frenzy about a loss. And it does so happen that upon this important point, the arrangement of the boxes, Mr. Hirschberg is directly contradicted by the man who placed them in the vault. The contradiction cannot be reconciled. The conflict is direct and positive. No charity can harmonize the evidence. One witness must be rejected. These are some of the circumstances which I said I would refer to against Hirschberg, brought here to condemn by circumstances my client, and the reference is just and lawful. They may in some small degree account for the chill of death which came over Mr. Williams at the thought of Mr. Hirschberg's guilt. At the period of the February and March count, when these boxes of gold were placed in the vault, Mr. Boland was the porter of the bank. He served in that capacity for about 2 years, was recommended to the board as a man of trust and fidelity and honesty by one of the directors, Mr. Christie, filled this post of great responsibility and trust to the entire satisfaction of the bank, and retired from it on the 15th of May last. The owner of real estate in this city, and called on business to Michigan, he leaves to prosecute it, making Mr. Christie his agent, touching the tenancy of his property and collection of his rents. Contingently, his business might carry him to Ohio before his return home. On the 10th of August, he had returned to the city, and the director had no certain knowledge of his whereabouts, for he might be in Ohio or Michigan. In this condition of things, the board resolved to send for him for the purpose of testifying against Mr. Childs, and they appoint Mr. Christie the agent to bring him back, at any expense, to be used as a witness in the prosecution. Cousins is employed to go after him, but as it was impossible to foresee the trouble and expense of reaching the witness, the compensation of the agent was not fixed. Prior, however, to his actual departure, a letter was received by Christie from Boland, apprising him that Boland was at Cleveland in Ohio. Cousins was sent immediately by the bank, was furnished with $100 to pay expenses, and bore an open letter from Christie to Boland in behalf of the bank, requesting his immediate return to sustain by his evidence the prosecution against Childs. On his arrival, he was closeted with the bank and consulted by directors at their houses. In this way, he ran the gauntlet of the entire directory, so that, at great expense and after a circuit of travel, embracing 2 or more states, this witness was brought here to swear away what is dearer than the life of the accused. If, then, Boland be paid for the actual service done the bank, his compensation should be small. But if he be paid for service rendered to truth and law and justice, if he be paid for service rendered to innocence oppressed, if he be paid for rescuing a man deeply wronged from the powerful, vindictive, and relentless prosecution, I know no sum that can fill the measure of his just reward. The witness came, but could not testify as the bank desired. The bank declined to use him. We summoned him for the defense, and ran the hazard of his testimony without knowing what it would be. We knew only this: the bank did not believe his evidence would sustain the prosecution, or it would have introduced him. And now to the important facts developed by him. He placed the boxes in the vault, placed them in their natural, not inverted order, and left them in that order when he left the bank on the 15th of May, 10 days after Hirschberg became specie teller. If this be the truth, the boxes were changed. Changed by whom and for what? Not by Childs, for he was not in the bank. There is no escape for the bank unless Boland be destroyed. He must be proved a liar, or the prosecution dies. When these facts appeared in evidence, you witnessed the tremor of the bank. Mr. Geyer invoked the highest powers to meet this exigency of the corporation, but in vain. The last desperate chance was to muster up the whole force of the bank and bring it in a body to slaughter the witness. They are driven to the sad necessity of attempting to show that the witness is unworthy of belief under oath. Oh, if he had sworn for them, sworn against Childs, they would have found in him a marvelous proper witness. They would have defied us to impeach him. Christie would have backed his unsullied integrity, and every director, every officer and subordinate of the bank would have testified to his unimpeachable honesty. A bank, gentlemen, stops at nothing. It is willing to put itself in the shameful position of insinuating that it placed in a post of great trust and high responsibility, and kept in it for years, a scoundrel unworthy of belief in a court of justice. Mr. Williams insinuates that Boland has been suborned. I repelled the insinuation by saying that, if capable of subordination, he would not have been our witness. If he had not been, as Scott has said of Taylor, perversely and obstinately honest, the bank would have put him on that stand to send Childs to the penitentiary. The witness comes certified by the seal of the bank. He has brought 500 miles to be a witness against the accused, and at great expense. Mr. Williams tells you he is not worth a pinch of snuff. He forgets the witness cost the bank much more than that, and his evidence is priceless to truth and justice. It was easy to foresee that Boland would be slain if the bank could kill him, for he bears no sex or condition, and knowing this, I called upon the prosecution to impeach him by bringing in the directors and guardians of the institution, to say nothing of his neighbors, to swear that he was unworthy of belief. Gentlemen, the sentiment of delicacy and self-respect was not so extinguished, even in a bank, as to take a hazard so desperate. They felt that to strike Boland, that wise, was to strike themselves, and they fell upon the policy of undermining a fortress, which they dare not storm. Gentlemen, I have been attempting in my remarks to teach the bank a lesson in justice and charity. I have pointed out to some of its officers and witnesses the cruelty of jumping in the dark to fix crime, infamous crime, upon my client, and without accusing any man, I have shown to them that if the object was to gather up circumstances of suspicion, they need not have wandered out of the bank to find a man on whom to cast them. An effort has been made to fix in Childs the possession of the seal used for closing up the 57 boxes of foreign gold, but it ends in a total failure. The only proof on the subject is that at the termination of account in the last of March, immediately after the seal had been used by the committee, and before all of them had retired, the defendant handed the seal to Mr. Engelrod, a director and one of that committee, saying to him, "You had better take the seal with you as the cashier is absent." Mr. Engelrod took the seal and carried it home with him. Now, it is manifest that, but for this act of the accused, the seal would have remained exposed to the inmates of the bank during the evening and night, and the next day to all persons who had access to the cashier's room, so that his prudence and care, supplying while rebuking the negligence of the committee and the cashier, were brought to sustain his guilt. Two circumstances are conclusive to show that the momentary possession of the seal by Childs could not have enabled him to use it to violate a box. First, there was no time, and second, it was too late in the general counting. It was late in March. Box number 37 had been passed, and it is not pretended that any box beyond that was violated by anyone. Boland testified to the same fact and says that, at the conclusion of the business of the day's count, after securing and sealing the boxes counted on that day, Mr. Childs picked up from the carpet the seal and handed it to Mr. Engelrod. You will recollect that the boxes were sealed upon the floor, which accounts for the seals being on the carpet. I passed from this subject at present, but shall probably recur to it before I close, when I touch upon the manner in which Boland is sought to be contradicted. I approach now the great theme of the wax, and I intend to seal up the bank with its own wax. Mr. Williams tells you that every box from which a bag was missing shows palpably on its upper seal the violation of the box. Marshal, bring me box number 30. You were told by him that any man can see it upon a close inspection. The nominal cashier told you when on the stand that some of the directors thought they could see a difference in the seals, but he grants that it required better eyes than his to see it. Among the directors who were clearest upon this subject was Mr. Heiskell, who thought that no man could be mistaken on the subject. While he was on the stand, I resolved to try him, and concealing the number of the box, I submitted to his careful inspection the providential box number 30. You witnessed, gentlemen, his minute inspection of that seal. You saw how, with microscopic glasses, he viewed with long and anxious speculation the seals upon that box, and then declined to hazard an opinion whether the seal had been violated or not. He could not determine the question, would not risk a guess. I tried the witness, not because I deemed the matter material, but because I wished to illustrate the effects of bank atmosphere. In the bank, surrounded by the men who make war on the defendant, the witness would have seen a difference, or thought he saw, for there an opinion might be safely advanced. But here there was peril in it, and the witness determined not to be caught. Mr. Heiskell, perhaps, suspected that I was putting his opinions to a decisive test. He may have feared that I presented for his inspection a box not violated, and lest he might be caught, he took the only seeming path of safety, and that was to have no opinion at all. What was quite palpable in the bank became invisible here. If I understand that argument made upon the wax, it is this, involving 4 propositions. First, that all the boxes were sealed with the same wax. Second, that the seals of 16 boxes were violated and resealed with different wax. Third, that this latter wax was of a darker scarlet than the wax of the original seals. And fourth, that the wax obtained by the accused from Fisher on his second call for wax answered in color the wax used to reseal the 16 boxes. The conclusive answer to this argument is given in the fact, established by Fisher himself, that the last wax got of him by Childs was of a brighter scarlet than the original wax. This answer is decisive, but the whole argument is an assumption. There is no proof in the clause that the 57 boxes were all sealed with the same wax. The reasonable presumption is the other way. Had the bank no wax on hand before, and at the time they began the count in February? Was the wax used ordinarily in the bank just out? This was not so, or Mr. Williams would have had the fact in evidence to furnish another act of providence on behalf of the corporation. Boland's testimony confirms this. He swears to 2 parcels of boxes of wax, and he testifies to the surplus left after the counting and sealing were over, and tells where he placed it in the bank and where, moreover, he adds, it may in all probability now be found. The directors made no arrangement or provision for the wax. They used such as was handed to them by the porter. When a box was ready for sealing, and not one of them ever thought of taking care that the wax used in the sealing should be of the same kind. They knew and cared as little about this as they did concerning the kind of candle that melted it. Indifferent on the subject in the beginning, they were wholly inattentive to it when each day's counting was over, and they left their materials to be put away by the porter, ready for the operations of the next counting committee. If the bank had wax on hand, and the amount was replenished by another parcel, not one of them discriminated between the parcels, but used the wax as handed, nor if any wax was on hand, when they begun, did any one of them look to see whether all of it was of the same shade. It is thus manifest that the basis of the whole argument is a bald assumption. But, gentlemen, let me tell you a secret. Do you know that the bank has resealed the top seal of 41 of the 57 boxes, and thus obliterated every comparative test between the upper and lower seals of those boxes? Do you know that it has wiped out every trace by which we could compare the boxes alleged to have been opened with those confessed to be untouched? This is true, and it is a remarkable step. I asked one of the directors why it was taken. He admitted it was very indiscreet. Gentlemen, why is it that the indiscretions of the bank are always against my client? They never blunder in his favor. They carefully preserve 16 seals and has carefully destroyed 41. Well, the bank resealed 41 boxes. Where did they get the wax? No director tells. Was it in the bank? Then there was a large surplus of wax left after sealing the 57 boxes. And there is a fact of much importance. How much? Now, Mr. Geyer, you have a chance for arithmetic. Mr. Williams argues from what he calls a little act of providence, namely, that it just takes 50 cents of wax of 5 sticks to seal 16 boxes. And if this be so, how many sticks are required to seal 41 boxes? Work this sum, and you have the surplus left of wax after the original sealing. With this result, the product of science, let us see how the wax argument of the bank stands. You observe the fact to be established is that Childs broke the upper seal of 16 boxes and took out a bag from each box and resealed the boxes. What wax did he use in the resealing process? The 5 pieces bought of Fisher is the argument and reply. Recollect, gentlemen, what is said by the bank and its advocates of my client. He is represented as a man of uncommon shrewdness, always cool, self-possessed, circumspect, wary, and clear-sighted, a magician of unparalleled powers, who has fooled every counting committee of the bank and every legislative committee sent to examine its condition and count its coin, a man so astute as to baffle and deceive everything but divine providence. Now, this argument requires that my client should go to the mantelpiece in the cashier's room, take the seal, lying by the surplus wax, leave the wax untouched, ready provided to his hands, the very wax used in the original sealing, and start out upon an expedition to procure wax suited to his end by purchase from a bank director who counted perhaps the very coin he is about to purloin. Fatuity, brainless folly, could not commit an act more senseless. Gentlemen, my client is not a fool, and my argument is not only an insult to his understanding, but to yours also. I know that prosecutors take great liberties with the human mind. The accused becomes as suits their policy, a wise man or a fool. At one moment, he is endued with the highest powers of discrimination, and in the next he is brainless. Indications of innocence are ascribed to guilty foresight, and acts which sane intelligence can't commit are put down to the mind's eclipse. I know all this, but I know also how difficult and how unnecessary it is to answer such suggestions. Mr. Williams thinks it is quite impossible that a gentleman could innocently buy for his own use 5 sticks of wax. 50 cents is certainly a large expenditure for so useless a commodity, but as a small palliation for so great offense, I suggest to him that my client was then not only a gentleman, but a member of several societies, requiring the transmission frequently of large packages, which might demand the use of wax. It is difficult to doubt that the bank had wax on hand before they begun the count in February and March, and that they have it now. The wish to destroy Boland is the universal sentiment of the corporation, and it is natural, for he has destroyed their prosecution, and he told them here in open court where he put the wax in the bank and where they might find it now. Do you suppose, gentlemen, they have not looked for it? If they found it, we of course would never hear of it. But if they could not find it, we should have been apprised of the failure. They would beat down his testimony at every point worthy in their power, and we learn by what they do not attempt, where Boland is invulnerable. The omission To assail him is evidence that they cannot. His testimony bears internal evidence of its truth. The duties he performed make him an able witness. He speaks of what he had a right to know, and of what he may well recollect. It was his business to prepare the room of the cashier with the materials to be used by the committees, and when they were gone, it was his business to gather up and place away what they left. And thus it is he is enabled to speak distinctly of facts which were dimly retained in the memory of the directors or altogether forgotten by them. If Boland were disposed to lie for the benefit of the accused, it would have been easy for him to say that the two parcels were of different wax. But he does not say that. All the wax was red, and he did not examine it to find different shades. But he is clear and distinct and positive that there were two parcels lying on the mantelpiece day after day during the count, and they were handled by him and put away. It is said by Mr. Williams that if Childs had asked Fisher for a better wax, he would have answered, "I have not got it." Then he would have answered a falsehood, or else what he swore here is false. For he said, as a witness, that the wax Childs got the second time was a better wax and of a brighter scarlet. Gentlemen, remember the phases of this director's evidence. In the first place, he told you that the second wax might have been the same as the first, or might not. He could not tell. But this would not do, as the seals were different. The wax should be also. The doubt gradually ripens into certainty, but unfortunately for the bank, it is of the wrong color. A remark made by Mr. Charles at the opening of the boxes, entirely correct in itself, and concurred in by others present, is presented by Mr. Williams as a circumstance against the accused. When some one of the directors thought he saw a difference in the shade of the seals, my client observed that more or less smoke in the burning of the wax might make some difference in the color. Mr. Clark, the paper teller, says that others concurred in the observation, and he says also that the next box examined gave more decisive indications of being smoked. As an argument, it is smoke, and I notice it only to show the gangrened vision of the bank, which sees in everything, however natural and just, indications of guilt. Among those who concurred in the truth of the observation was Judge Shirles. Perverting as he advances, Mr. Williams says that Mr. Childs besought Hirschberg to become his successor. Who said that? What witness gave color even for such an idea? Hirschberg knew that Childs was about to retire from the bank. He wished his place, and he found in Mr. Childs a friend. But my client cannot perform an act of friendship to an honest German, flying from the moral atmosphere of his native land to the corrupting air of our own unhappy clime, without being indicted for it. Mr. Williams can act from the impulses of a generous nature, but he denies to my client all such noble promptings. My client is made alien in heart to the foreigner, while the cosmopolitan yearnings of the bosom of Mr. Williams impel him to kiss every German he may meet. Evil to him who evil thinks, and the man most apt to distrust the friendship of others is not aptest to be sincere in his own. Hirschberg wanted the place of Childs, and Childs gave him some good advice to attain his object. His offense had this extent, no more. How was it with the platoon of strangers admitted to offices in the bank since the retirement of my client? Were they recommended? Had they friends, political or otherwise? And does the gentleman find in their introduction to the bank, by whomsoever made, a guilty design? Gentlemen, if no other good shall result from this investigation, and out of so much evil some good should arise, it will open to the public mind, and I trust to the public authorities, the injudicious, irregular, and unsafe manner in which the affairs of this bank have been and are managed. The cashier of the institution, the lawful and exclusive keeper of its capital, has been, by the unwritten prescription of its directory, absolved from all knowledge of or responsibility for its funds. The directory have not condescended to consider it a part of their duty to see to the safety of either coin or paper, and by simplifying process, which loses sight of all proper checks and balances, the practical responsibility for the whole capital of the bank is thrown upon two men, called tellers, one of whom is responsible for all the paper, the other for all the coin, to conduct the daily business of the bank, embracing the payment or reception of $50,000. The tellers have access to and are held responsible for all the money on hand, and not they alone have access, but almost every subordinate agent in the bank. The vault in which the money is placed is open to all but the cashier, who is said to avoid it, as having no business there, and the directors are careful not to be seen near it as a board, and never approach it except by a committee of 2 or 3, twice a year, when a compulsive visit is imposed upon them by the charter. The board, or at least several of the directors, have been informed on this trial for the first time that the cashier had a set of keys to the vault, and others who knew the fact by some loose information could not account for it, except by the supposition that it was to remedy the possible forgetfulness of the specie teller in not bringing down his keys from his residence at the opening of the bank. The capital is placed within the reach of those, many of them strangers too, who ought never to see it, while those who are trusted and held responsible by law are said to be strangers to the sight of it. The books of the bank are likewise in confusion, and cannot be made to agree by its accountants. It is said by Mr. Williams that there was an improper design couched in the remark of Childs to Hirschberg, that half an hour would be sufficient time for turning over to him as his successor the gold in the vault. There is no ground for the suspicion of an improper motive. You will remember that all the loose coin had been counted by Hirschberg, and unless the boxes were to be opened and the gold counted, half an hour was ample time for what they had to do. It is not even pretended that this was expected or desired by either party, for it would have occupied them a month, and was contrary to the design involved in sealing the boxes by the board, whether that design was to ship the coin east or keep it in the bank unused. Mr. Hirschberg stated that he did not consider himself responsible for any but the loose gold, from the fact that the committee had counted, boxed and sealed up, and packed away the rest, and doubtless Childs took the same view. End of section 36. Section 37 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 17. One argument touched by Mr. Williams will be pressed by Mr. Geyer. It is the main ground upon which he will place the prosecution. He will insist that the semi-annual and legislative committees and the entire board in February and March were deceived by being entrapped into a recount of money already counted by them, and that Childs was the only man who could have deceived them. Thus, when Jackson and Ellison counted and weighed the gold in the vault, or a portion of it, placed that portion in the gold chests, locked them, and took away the key with them, and resumed the count and weigh next day of the remainder of the coin, it will be said that in the interval, Childs, by a false key, opened the chest, took out enough to cover his defalcation, relocked the chests, and made them recount the money abstracted, and that no one but Childs would know how much to take out. The vice of this argument is that it begs the whole question. It assumes everything that is to be proved. It assumes the defalcation, and it assumes the deception. It is nothing but a series of guilty guesses, without a shadow of proof. The guesses are cruel, unlawful, wicked suppositions. Prove the false key. Prove that Childs had it. Prove that he opened the chest. Prove that he took out the money. Prove that he deceived the committee by making them recount it. and then you will find it unnecessary to use your other proposition, that he was the only man that could have done these guilty things. Shall any man be damned upon a surmise? It is monstrous. Who made the false key? Was there a false key to the chest? Whoever saw it? Was it ever in the hands of Giles? If so, when and where? Was the chest opened in the interval? If so, bring the witness. Have you such a witness in the bank, or can you bring one in all the states you traverse to get rolling? Mr. Williams insists that the paper teller, Mr. Clark, is the most honest man in the world, and the friend of Giles. I do not impeach his honesty, and he may be a friend of my client. If so, it is something in his favor, that despite this prosecution and against the esprit de corps of a bank, he yet enjoys the friendship of the most honest of men. I have some reason to know what Mr. Clark thought about the haste, precipitancy, and cruelty of this bank war against the defendant, but waiving that as not being in evidence, I rely on the testimony of Mr. Clark to destroy all idea of a paper defalcation. He says he would have found it out if paper had been taken by another, and that the first semi-annual committee would have found him out if he had taken paper himself. He says the paper of the bank is safe, and with a candor worthy of imitation, he says that of all the officers of the bank, he is the one least checked. The books of the bank, the reports of the committee, the sworn statements of the cashier, the records of the board, all prove no defalcation in Giles, and we might fill a bushel basket with the affidavits of bank functionaries to this point. But Mr. Williams sweeps away the entire mass by a dash of rhetoric, and says it is all deception. The counsel, in the ardor of his friendship for my client, says that Mr. Giles and Mr. Bates are the husbands of all the widows in the land. Gentlemen, it seems to be a hard thing for this bank or its advocate to be just. Elijah Hayden made some years ago a conveyance of his property, consisting of real estate in this city, for the benefit of his wife and Mrs. Whitlock, her adopted daughter, adopted 25 years ago. He constituted my friend Mr. Bates trustee to enforce the trust. By the provisions of that conveyance, the beneficiaries were secured the enjoyment of the property, were entitled to collect the rents and profits, and in all respects to enjoy the estate free from the molestation of the grantor. And at last, the estate descended to the only child of Mrs. Whitlock. This estate, as you have learned by the evidence, produced from rents exclusive of the house occupied by the ladies, $1,500 per annum, and for several years these rents have been collected by the defendant as the agent of the beneficiaries. You have heard from Mrs. Corbin the circumstances under which her money was invested in real estate by the defendant, and upon these facts, the counsel declares Bates and Giles are the husbands of all the widows in the land. Under the advice of Mr. Bates, the original title deeds to this estate and documents connected with them, such as tax receipts, etc., were sealed up and placed for safekeeping in the bank as a special deposit, endorsed as such, and required by the endorsement to be delivered to either of the beneficiaries or to Mr. Giles. That is the violated packet, plundered from the vault and carried to the grand jury at a period of time when, perhaps, the fate of the prosecution hung upon a balance. Gentlemen, if the bank did trample underfoot the Bill of Rights, the Constitution of the state, and the general laws of the land, they ought at least to have respected the laws of the bank in their own contract. But in the general frenzy, they ceased to be a law unto themselves. The packet was violated. You were told by Mr. Williams that it penetrates without difficulty a bank statement of its affairs, that even suspense account is no mystery to him, and that it readily perceives how the clear profits of the institution may exceed by $100,000 its gross profits. He is modest enough to inform us, however, that he attributes this not to any particular acuteness original with him, but to the result of education. In this light, with which common men are not furnished, he has made and presented to you an account of the property, liabilities, and resources of my client, which beats even suspense account. There is nothing like it. It eclipses all bank arithmetic, and I asked a copy of it when he concluded his speech, not only to study the abstruse, but to preserve the curious. I have not time to study the document now. I hand it over to my colleague, Mr. Bates, for his grave consideration, as a paper tasking all the talents or taste which he may have for the difficult and abstruse. My colleague will perceive that the first step in the account is a blunder of $1,500. By that document, Mr. Williams has made my client rich. I submit as a practical argument in answer to his figures that from the sum of wealth they put down, the bank may deduct $25,000, and the corporation may have the property by paying the balance left. Here is a fine chance for a fortune. Who will take it? When the counsel came to the foot of his account, showing the imaginary opulence of my client, he exclaimed, "Gentlemen, we have not found out half of the wealth of Giles. Where, I ask, is the other half? Where can the bank yet look and search? What place so dark, concealed or sacred that the bank has not already penetrated? Its Argus eyes, its Briarean hands have looked and felt everywhere. Every bank, every broker shop, every stock jobbing establishment has been ransacked. The west, the south, the east has been explored. The dens of the police have been entered by the bank. Spies without number, all the Union over, have been peering for lost gold, peering in every haunt of vice, every avenue of exchange, and here at home in the city, around us everywhere. The bank and its instruments have been night and day practicing a sleepless and lawless vigilance. They have haunted the tombs. They have gone to the grave of a sleeping sister. They have raked the ashes of his dead children to find their embezzled gold. Where? Where shall the bank go next to find what it is not yet discovered? What other unprotected widow shall be plundered for the benefit of the bank? No, gentlemen, you have performed your task. You have discharged your whole duty. You have been faithful servitors. If you have not found what you sought, it is because the thing sought was not lost, or because you have not looked to the guilty party. It is a fact almost beyond belief that this bank has never directed a single energy of its mighty powers elsewhere than at Giles. With a desperate hardihood, it has fixed its gaze on him alone, and has sprung upon him as the catamount springs upon its prey. I have abused your patience, gentlemen of the jury, and exhausted my strength, and passing other matters of interest, I will hasten to a conclusion. I come now to the testimony of Bolin, and to the motive which the bank seeks to destroy the witness it took such pains to procure. The important facts sworn to by this witness are, first, access to the bank by leaving down the bar under the orders of the cashier. Second, by procuring the key under an actually pretended message from the lady of the cashier, sent by a mulatto servant who lived at the bank. Third, the situation of the boxes of foreign gold, ranged in their natural, not inverted order, in numbers from 1 to 57. Fourth, that he was directed by the counting committee and by the defendant not to place the American gold on the foreign, but to put it in front, in separate piles, and that in doing this he separated the foreign and American coin, as far as the space would allow, by placing the latter against the chest. Fifth, that when he retired from the bank on the 15th of May last, the 57 boxes of gold were in the same situation in which he placed them. These, gentlemen, are the most important matters in the cause, for they prove a change of the boxes after he left the bank. The less important facts detailed by him are, first, The 2 parcels of wax were in the cashier's room during the February-March count. Second, that while the count was going on, some members of one of the committees complained that the wax was thin and ran into the box, making it difficult to seal the box, and requested other wax, and that accordingly Childs did procure another parcel. Third, that he saw Mr. Childs pick up the seal from the floor and hand it to Engelrod, requesting him to take care of it, as the cashier was absent. Fourth, that he informed the cashier that during his absence his wife had sent for the key and entered the bank, and the cashier inquired of him what she wanted in the bank. Also the reply he made to the question. Fifth, that after all the boxes were sealed, he placed the wax remaining at a certain place in the bank, where he supposes it can now be found. You will bear in mind, gentlemen, that in the important facts developed by this witness, the bank has made no effort to contradict him. It exhausts itself in endeavoring to show error in mere trifles that cannot affect the case if found either way. The direction he received from the counting committee stands unimpeached. The position in which he left the boxes 10 days after Hirschberg took charge of the vault is not contravened. Even Hirschberg is not called to disprove this pregnant fact. No attempt has been made to dispute what he says he did with the wax left after the count was over. Nor has Judge Sherrills been able to deny the conversation he held with the witness, touching the entry of his lady into the bank during his absence. The witness is therefore confirmed in these points of his testimony. The silence of the bank fortifies the witness. And now in what does the bank seek to negative his statements, and how? Mr. Engelrod is brought to prove that Boland was not in the cashier's room when Childs handed him the seal and bid him take care of it. And the directors in a body come to show that they do not recollect any occasion for more wax. It is in these matters and by this mode that they seek to impeach the witness. It is not lawful to impeach a witness who recollects an incident by another who says he does not recollect it. But the effort to destroy a witness by the forgetfulness of a bank director, a director of the Bank of Missouri, is enough to start a smile on the face of a marble statue. Gentlemen, these directors have secured to themselves the immortality of a proverb. They have robbed the fly of one of its distinctions. Heretofore, men have said, no more memory than a fly. But in coming time, they will say, no more memory than a bank director. Without a memorandum or a box, a bank director is a fish out of water. The mode, too, in which they reach the oblivious commands our special wonder. Take an illustration. Dr. Forbes, a director, hears a paper read at a sitting of the board. Among other things, that paper states my client was worth $2,000 when he left Maryland to come hither. That gentleman remembers the sum. He goes before the grand jury that found this indictment against Childs, and swears that the sum was $2,000. He is put upon the stand here, and he says he is of the opinion that the paper read stated my client to be worth $1,200 when he left Maryland. I asked him if he did not swear differently before the grand jury. Yes. Did you not then say it was $2,000? Yes. Was not your memory distinct as to that sum? Yes. Why have you changed it? I conversed with Mr. Austin. Did Mr. Austin ever see the paper or hear it read? No, sir. And your recollection changed after talking with Mr. Austin? Yes, sir. And settled down on $1,200? Yes, sir. Now, gentlemen, the most amusing part of the whole affair is that this Mr. Austin swore in your presence in this cause that he had no knowledge of what my client was worth when he left Maryland. The director's memory retains the sum of $2,000. He prints it deeper by an oath. He talks with a man who never saw the paper nor heard it read, and is wholly ignorant of the subject matter, and straightway the director deducts $800 from the amount. If he had met another man, as ignorant of the whole affair, and talked with him, the whole $2,000 might have slipped from his memory forever. It is remarkable, gentlemen, that the metempsychoses of the recollection of the witnesses, so frequently displayed in the progress of this trial, never work a change for the benefit of trials. The chapter of accidents is always against him. I have heard of a speculative philosopher who ventured an ingenious theory to illustrate the phenomena of memory. His suggestion was that the memory in its structure was a sieve of unequal apertures, one half fine and the other coarse, so that on one side the smallest incidents would be retained, while on the other the largest facts would fall through and be lost. I recommend the evidence furnished by the bank on this trial as a striking illustration of the truth of this theory. The attempt to discredit Boland by the evidence of the cashier and his lady is a total failure. Boland swore that the lady sent for the key on 2 Sundays, in the absence of her husband. She admits she was in the bank on 2 Sundays, in the absence of her husband. She recollects of sending for the key on the first occasion by her mulatto servant, but is of opinion that she entered the bank on the other, without the key, the bar having been left down by the order of the cashier. She thinks these visits were about 12 months since, and Boland thinks they were about 9 or 10 months ago, and either of them may be mistaken as to time. But the important fact of access to the bank by sending for the key in her name is established. She confirms, too, the habit of her husband in going into the bank on the Sabbath, and his mode of access. The cashier's evidence in rebuttal only makes the matters worse. He recollects only 2 occasions on which he went into the bank since January. Even these he did not recollect when he was examined in chief. And since he came on the stand the last time, his memory has been refreshed as to another occasion when he was in the vault, previously forgotten. Questioned moreover by Mr. Bates as to still another visit to the vault. He does not remember, but he does not deny. He fortifies Boland also by confessing the knowledge of the threatened robbery of the bank, a subject upon which he and the directory preserved a dead silence, till the fact leaked out of Cochrane. He proves also access to the bank by others, for he found 3 young men in the bank on a Sabbath of this year. If Boland had forgotten or confused in his memory any of the events which transpired while he was porter in the bank, they are the last men on earth who should attempt to discredit him on that account. You have seen them day after day in this trial, come back to count, to correct blunders made in their own swearing. But it is said that Boland read the newspapers containing the published evidence of this cause. If that discredits him, then all the witnesses of the bank are unworthy of belief, for they all read the papers. Did they not read them, notwithstanding the order of separation, by which it was designed to keep each ignorant of the other's swearing? Did they not confer and consult together, and muster up in the bank and out of it all the evidence gathered from every quarter, and did not Colonel Grant move and carry in full board the proposition that they had now sufficient evidence to issue an attachment against the property of Childs? Yet Boland is to be discredited because he read the newspapers. But he conversed with Childs. I had supposed the prosecution would take special care to avoid such inquiry. Suppose it were true. Could the bank complain? Do they, in virtue of its corporate character, claim a monopoly of conversation with a witness? Did they not send 500 miles from Boland to converse with him? Were they not closeted with him in the bank again and again? And did not every director converse with him? Conversed with him on the subject of this trial? Conversed with him to know how much and what he would swear against Childs? In the face of all this, in the face of Christie's letter, and the verbal message borne by Cousins, they have the hardihood, I say hardihood, to object that Childs should converse with him. But Childs did not converse with them as to what he knew or would swear. He observed a delicacy and propriety on this subject, which the bank has not followed. An effort was made to show that Charles had written to him before he received Christie's letter, but it was a total failure. He knew not where to write, had he desired to write him. Christie only learned through the letter he had received from Bolin. The next maneuver was to insinuate that some man, a man of straw, created by the mind of Dr. Geyer, had beaten police and bank vigilance and reached Bolin as an emissary of Charles before the arrival of Cousins at Cleveland. The last exhibition of Mr. Geyer's ingenuity was to make it appear that on the arrival of Bolin in this city, he fell into the hands of the defendant before he reached the bank. But the proof was positive against the suggestion. Gentlemen, I dismiss this part of the case. I leave the witness strengthened by attack. The effort to destroy him, made with the entire forces of the bank, recoils upon the prosecution and establishes both the importance and the truth of his evidence. I deem the testimony of Mrs. Sherrills important, but not to show crime in her. I am quite sure her visits to the bank were not to embezzle its gold. Her testimony is important to us, to show how easy it was to rob the bank through the instrumentality of a Negro servant. It will be said, perhaps, that no outsider robbed the bank, and the argument will be, no outsider would have taken a single bag from a box of gold, and he would have left behind him some mark of violence. These plausibilities are met by others quite as plausible. As to external violence, that never is made but from necessity. In this case, the easy access did not require it. As to the mode of aspiratation, that is more plausible, but it is not conclusive. A box of gold is a difficult load to hide. There was a watchman at the bank. He would have to be entertained by an accomplice, and the city police and strollers at all hours guarded against. It is not every thief who is so unwise as to cut open the golden goose, and besides, it was of the last importance to gain time to secrete the treasure. This is the great labor in a stupendous robbery. Want of time led to the detection of the Nesbit robbery. The case of the robbery of the City or Canal Bank of New York illustrates what I have just said. In that case, there were no marks of external violence. Boxes were violated and resealed. The inmates of the bank were implicated because of this, but the robbery was accomplished from without. Gentlemen, we might rest the case upon the absence of proof against our client, but there is evidence, affirmative evidence, of his innocence. The bank has chosen to give the life of Charles in evidence, and that life from boyhood's apprenticeship up to the present hour is proof against the deed imputed to him. It brings his life up to the present hour, for, though brought to this criminal bar and put on trial, standing amidst the mighty throng which fills this temple of justice, and before you, a man accused of crime, he is yet, in your judgment, as in mine, in all the qualities that may make a man, the equal of the loftiest among his accusers. He has not forfeited in an hour the rich treasure of a name, won by a life of honest toil. He is not surrounded by troops of friends, and has the sympathy of the just. His laurels were not won in a day, and shall not perish in an hour. Thank God, accusation is not crime, nor malice proof of it. The court will tell you this is a cause in which character is a shield. If in a case like this a man could not fly to his character, as to a plank in shipwreck, a good name would cease to be the valuable thing it is. Besides, he has never been too proud to work. He is a man of toil, and the man who works is not the man to steal. There is something in toil, daily toil, which exempts man from the tendency to steal. The thief is born of idleness and cupidity. Hard, honest, daily toil begets no such offspring. Again, the bank, with all its vigilance and inquisitions, its search and lawless confiscations, has never found $1 of its funds. This is decisive. There is no instance of a loss so stupendous without a discovery of some portion of what was lost. The efforts to go into business on a limited capital, the uniformity of his statements touching his means and resources, is proof of his innocence. The contracts he made with his workmen and the mode of payment is proof to the same end, and is bearing before you in amidst every stage of the storm of persecution which beat around him, is the bearing of a man deeply, foully wronged. I cannot close my remarks without calling your attention to one of the many means resorted to by his accusers to manufacture public opinion against the accused. Public opinion, a powerful tribunal in all countries, is omnipotent in ours. To turn the tide of public opinion against my client, Colonel Brent cut loose the tongues of the directory, tied up a string of the charter. The bank cries, havoc, and let slip the dogs of war, and at once in full cry. Tray, Blanche, and Sweetheart open on the track of Childs. Was the resolution dissolving the injunction of secrecy necessary to obtain information? No, but it was deemed necessary to impart it. You see, too, the facilities of the bank to get up a prosecution. One of the directors was a member of the grand jury that found this bill. He could sit for 1 hour amidst a bank conclave, and in the next appear as one of the lawful inquisitors of the country, while the forces of the corporation, divided into detachments, were marching through the streets imparting knowledge, gendering suspicion by significant innuendos, and fanning into flame every element of excitement in the popular mind. Why was not the defendant tried before Justice Butler, under the provisions of our statutes? I will guess. There is an action known to our laws by the name of false imprisonment. If he had been tried and discharged by the justice, a heavy responsibility rested on his accusers. If, however, the grand jury could be coaxed to find a bill of indictment, some shallow lawyers think it a defense to the action of false imprisonment. It was, therefore, deemed a salutary step to transfer the jurisdiction from the justice and to apply the grand jury for a bill. That tribunal catches the very whispers of society, and amidst an excited community, the bank determines it should hear enough to inspire action. It cannot be denied that the bank was at this work, and it did make public opinion. Hogan and Gay were not the only persons who heard that a large amount of the gold of the bank was found by search at Mrs. Hayden's residence. The rumor was rife upon the streets. It could be heard at every corner and every spot of the city, where men do congregate. Who published the falsehood? The directors and officers and agents of the bank, or their instruments, the police? In either case, 'tis the same, for the police were the hired agents of the bank. Slanders, connecting the name of Childs in guilty association with one of the ladies, were blended with the discovered gold, and the packet, the violated packet, taken from the vault of the bank to the room of the grand jury, was exhibited to show the guilt of the triumvirate, Mrs. Hayden, Mrs. Whitlock, and Nathaniel Childs. Mr. Geyer, seeking to palliate, when he could not justify the confiscation and plunder committed by the bank, will tell you the trust deed made by Elijah Hayden was not put upon record. What of that? A record is only constructive notice. The bank had notice in fact. There was possession by the ladies, open and notorious possession for years, which is noticed to all the world. And there was Owings, the collector, collecting and paying rents. The bank is without excuse. It made the confiscation to give color to the slander of criminal intercourse. The packet in the bank was notice. A gross perversion of the paper read to the board has been attempted. It was not the design, nor the effect of that paper to show that Childs was worth. Its intention and purport was to show what his real estate, unimproved, had cost him, and this cost was put down at about the sum of $8,000. Every director knew that the residence he occupied at the time on 15th Street was worth nearly double that sum, to say nothing of his property on Franklin Avenue, worth $6,000 or $7,000, so that the paper could not have been satisfactory to the board if it was considered as showing the worth of the defendant's estate. It purported further to explain a fact quite well established by the evidence here, that he held for Mrs. Corbin the legal title of several parcels of real estate in which he had no interest, and the bank was not then so unjust as to make him a criminal because his property had risen in value. The attempt to falsify his statement, as the court said, must recoil upon his accusers, and I trust it has been in the breast of every juror, in England and America, before a man can be called upon to account for the possession of stolen property. The possession must be recent after the larceny. But Mr. Childs has been called on here to go back to the period of his youth, when he was a prentice boy, and account for property not stolen. Through that ordeal, hard as it was, he has passed unhurt, while the first director of the bank, whom we questioned on the subject of his acquisitions, flinched from the inquiry as if stung by a wasp. He sought a balsam for the sting in the medicine chest of the Constitution, provided for unquiet consciences, and we trust he found it. I have just seen a book brought in and dog-leaved at the head of circumstantial evidence. I know the object. It is to form the subject of eulogy. Circumstantial evidence is to be made the theme of panegyric. It is to be held up before you as the severest test of truth, known to the law. Experience and reflection teach me, with all the guards and restrictions thrown around it by the law, it is of all evidence the most treacherous and unsafe. Examine its nature, and you will find it is, at last, only a process of reasoning. It is nothing more than reasoning upon the supposed dependency of one fact upon another fact, because it is reasoning, human reasoning. Therefore is it treacherous. Unfortunately, what renders this kind of evidence treacherous is exactly what makes it captivating. It panders to the native pride of intellect. We are delighted with our own progress. We spin, like the spider, the intellectual thread on which we move, and we are charmed that we make, as we advance, the cue that leads us through the labyrinth. Juries in the box, judges on the bench, men everywhere feel, if they do not own, this fascination, and it has led men astray all the world over. Just as beacon lights are put up on the ocean to warn the mariner of the rock on which some gallant vessel has been wrecked, so these melancholy records are placed in the law books to warn courts and jurors of the innocent blood shed by circumstantial evidence. If man, finite man, could take in the infinite combination of circumstances, if he could always see when facts, seemingly dependent, are really independent, the danger would be lessened, but this is impossible. If circumstantial evidence were personified, it should assume the form of a beautiful woman. Her brow should be the brow of Minerva, her smile the smile of Venus, her voice the voice of the siren. She should be clad in the white robes of innocence, but on her garment should be seen gouts of blood. Her steps should be the conqueror's tread, but behind her should be the conqueror's desolation, and in the background, haunting her footsteps, should appear the shades of unquiet, perturbed spirits, ranged in groups of 12, representing the juries which have been led astray by her knowing brow, her treacherous smile, and her yet more seductive voice. For the consolation of Shirles and Hirschberg, and all others implicated, be it spoken that good men, innocent men, may be, and have often been, surrounded by circumstantial indications of guilt, stronger, far stronger, than can be found in all the evidence brought to sustain this cruel prosecution. Gentlemen, in the prosecution of the war against my client, the bank has achieved many triumphs. It has gained a victory over the Constitution and the laws. It has trampled under the foot the holiest, most sacred sentiments of the human heart. It has assailed my client as a minister, as a husband, as a father, as a citizen, as a man, and in every way it has touched him nearly. It has hurled him from the sacred desk. It has shivered the household gods around his home. It has pierced with agony the breast of his aged father. It has brought travail to the bosom of his mother and children of the same womb and loins. His brothers and sisters, they too have been stricken. It is sent by the lightning, the story of his shame. And what the lightnings bore, the press has blazoned in all the pomp and topography. Throughout his native land and abroad, he has been held up to the gaze of his fellow men as a criminal. Yes, I own it. The bank has had its triumphs, but there is one more fortress yet to storm before its victory can be complete, and that is the bulwark furnished to innocence by the Constitution of the state in the breasts of 12 honest jurors. If this last stronghold be not carried, justice, truth, innocence will have triumphed, and not the bank, and then the hour of retribution will have come. Gentlemen, when my client shall sleep the sleep of death, when his dust shall go back to the earth that gave it, when he is laid by the side of his sleeping sister and his dead children, shall his remains mingle with theirs in honor or dishonor? That is the question. End of section 37. Section 38 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 18. Mr. Leslie for the State. Mr. Leslie, the time has now come for me to discharge the remaining part of my duty as one of the counsel for the state, which was to comment upon the law and the evidence, and aid the jury as far as my limited talent would go, in arriving at such a conclusion as the evidence, when applied to the law of the case, demanded at your hands. But, gentlemen of the jury, I regret, as you do, and as this large audience of ladies and gentlemen will, that we have come to that part of the case when from necessity the scene is changed from silvery words, impassioned eloquence, poetic fancy, and imagery that stirs the soul, to the cold, dull argument upon the law and the evidence which my position as counsel for the state makes most proper, and which for the want of oratorical powers I am forced to, if my duty did not require it. The learned gentleman who last addressed you has not the physical power to meet his intellectual, even-handed, and the physical has given way because of the unexampled and unreasonable calls which the intellectual has made upon it, and the entertainment is therefore over, and all who were here to listen, myself and colleagues included, are disappointed that the curtain has fallen. I wish that it had not so happened, for I am always charmed and instructed by the speeches of the learned gentleman, Mr. Wright. Gentlemen of the jury, although it is not my fortune to be touchingly eloquent, and in the discharge of my professional duty, and able to embellish my work with fancy and the pathos of poetry like the counsel for the defense who has preceded me, I am not the only one of my profession thus wanting, and this gives me some consolation. From my acquaintance with the learned gentleman, I had hoped that in conducting the defense they would have occasionally referred to the law and the evidence, and not have all the time struggled to divert the attention of the jury from the issue they are solemnly bound to try, and to carry off their minds into a region of fancy, choicely selected from their own extensive travels. Gentlemen, in no instance yet, to my knowledge or belief, have the counsel for the defense alluded to a fact worthy of the serious consideration of the jury, or advanced an argument that weakens the prosecution or strengthens the defense. Day after day, Gentlemen have been occupying the time of the court in the consideration of extraneous matter, and calling to their aid forensic display of a high order to carry you, gentlemen of the jury, from the real question as stated in the indictment. Such displays were laudable enough, pleasant to the audience and creditable to those by whom they were made, and ought to have just their true worth and no more, and by the jury to whom they were directed, made to take a miscellaneous position to be disposed of in some leisure time. Gentlemen of the jury, you, and not the counsel for the state, have the responsibility of this case, and in your deliberations upon it, the manifestations of friends or, if it suits better, of public opinion, as witnessed in the crowd attending, while the defendant's counsel were addressing you, should have no influence. You are responsible to public opinion of a different character and manufacture, a public opinion as to the manner you discharge the high duties of jurors upon the law and evidence, and the correctness of the conclusions you come to as part of the judiciary of the land, which public opinion and its salutary influence upon the legal tribunals of the country is an ornament and a safeguard, and peculiar, I am proud to say, to our institutions. Again, I say, gentlemen of the jury, the responsibility of the case rests upon you alone. It does not rest upon counsel engaged in it, either for the prosecution or defense. It does not rest upon public opinion. I mean that floating, careless, undefined public opinion, manufactured by feelings which are derived from outward influences. And it is a fit and apt question for the jury to ask themselves what such public opinion as this is has to do with the merits of the case. It does not rest upon the laugh or the sneers of counsel, or the jeering of friends, such as that which was so extraordinarily exhibited in this court, but that serious, weighty public judgment to which all causes, whether civil or criminal, are justly subject, and to which you, the jury, the triers of this case, are amenable, and from which you cannot escape. The counsel for the state are not responsible for your verdict. You are the triers, and we the machines to help the jury to such a verdict as the law and evidence demands. I say this because I desire to know if appeals to human passion, such as you have heard in your judgment, outweigh the facts as proved by the state. It is not for me to know whether it is so or not, but I know there is a responsibility which cannot be dodged in dealing lightly with evidence of the serious nature here adduced. The novelty of the mode of trial adopted by the defense, the extraordinary and strange arguments used by counsel during the course of examination, and the kind of evidence introduced by them, leave a speaker for the prosecution in an awkward situation. If the case had been conducted differently, if extraordinary efforts had not been used, and strange arguments resorted to, I could have hoped to finish what I had to say in 1 hour. But these things have imposed upon me a more arduous task than I had anticipated. The deserved reputation also of the counsel who have preceded me for the defense would leave me derelict in courtesy to them if I did not pass upon some of the numerous and extraordinary positions which they have thought fit to assume to effect the discharge of their client. Gentlemen, the question to be decided was, not as the counsel had labored hard to show, whether a search warrant was issued for gold and no gold found, not that certain gentlemen, by an inquisitorial proceeding, procured certain papers from a widow on Spruce Street, not that Hogan or Gray or Anderson or any other person were restrained of their liberty by the procurement of this hideous monster, the bank, but whether the accused is guilty of embezzling the funds of the Bank of Missouri, a question in which the state of Missouri is plaintiff and Nathaniel Giles, Jr. is defendant, and these other matters, lugged in during the examination, being foreign to that question, should be entirely disregarded. After stating what constituted embezzlement, in order to enable the jury to be the better prepared to apply the evidence given on the trial to the law and pass upon the question they were empaneled to try. Mr. L. proceeded to notice the question so triumphantly put by the defense. What did the loss consist of? In answer referred them to the indictment and evidence. No gold, no paper gone, say they, and triumphantly declare that nothing is gone so far as the evidence in this case had given them the least information. He regarded this as a ruse on the part of counsel to call the attention of the jury from the offense charged in the indictment. In following out this plan of defense, the counsel say that Clark, the receiving teller, had, in answer to their questions, stated that not a dollar of paper money had been taken from the bank, an unjustifiable perversion of his testimony, and hence it was ridiculous to prosecute their client on the paper branch of the subject. Farther on, yet true to the policy first adopted, to keep away from the case and produce as much confusion as possible, under the pretense of having a legal question for the court, they had availed themselves of every opportunity to address the jury piecemeal upon all the matters that they thought belonged to the case on their side, and then generously proposed to submit the case without argument after the examination is closed. And because the state insisted on argument with the same generosity, they accused them of some after-trap to be sprung upon their client in the argument of the distinguished counsel who is to close the case. Mr. L. hoped that from this time the case would be tried without regard to extraneous matters, and by such rules of law and evidence as will lead to a satisfactory verdict to the state, and accused, and the jury themselves. He hoped the time had come in this inquiry when everyone would march up to his duty manfully and professionally, when everyone would forget that they were trying anything but a case of embezzlement, under the laws of the land, and upon the strength of evidence which was before the jury under the sanction and permission of the court. Mr. Leslie proceeded to notice the complaint made against the use of a memorandum by the witnesses in order to refresh their memories in a matter of figures and fact, and dilated at length on that point, and said it was a fault from which the counsel themselves were not free, as had been demonstrated by the frequent occasions they have had to refer to their own memoranda of what witnesses said on the stand, and he thought the charge of loss of memory against these directors, who were witnesses, came with very ill grace from those who displayed so great a want of that faculty. But this is not a tithe of the complaints which have appeared from the beginning to the end of their arguments. They complain, loud and long, that they are compelled to grope in the dark. They spring a debate themselves, and complain of oppression, unfairness, and iniquity. They say they fear that a trap will be sprung upon them, unless they speak untiringly to an intelligent jury and before this unusual audience. But has the defense less material to go upon, less evidence for information than the counsel for the state? No, this is all out of the way stuff, paraded for the chances of its effect upon the jury. In this, their straitened position cast ridicule upon the indictment, and this too, while assuming that they are arguing the merits of the case. Such, of course, market, gentlemen of the jury, is indicative of weakness in the defense. Everything but the merits of the case is brought into requisition. The sympathy of the jury is appealed to, and the character of men not within the bounds of this inquiry, wantonly assailed for want of something better to address you upon. Tears have been shed upon the occasion, whether by collusion or not, I am unable to say, and I do not say that such things as tears are censurable in this case. They are a part of the glowing picture which counsel have drawn for the jury, and perhaps were a part of the audience, maybe because it was felt they were needed. The offense charged against the accused, committed by whomsoever it was, except the outsiders spoken of, must of necessity rest upon circumstances. Hence it was that he again asserted that the jury had a responsible duty to perform and to aid them in discharging it. He should endeavor to bring before their minds the evidence relating to the case. He contended that the state had proven by testimony, unimpeached and unimpeachable, just what the counsel for the state said would be proven before the witnesses were brought to the stand, to wit, that the sum of $120,921.62 had been taken from the bank. It had been testified to, day after day, for nearly a month, and not one single thing to invalidate the testimony, as far as this fact goes, had been attempted by the counsel for the defendant. Then there were two important things established upon which rested this whole case, and to which belongs all this circumstantial evidence. He desired the jury to see how they had been met, and what use had been made of them. These directives state they saw the money go into the boxes in the February and March count, and when those identical boxes were afterwards examined in August, it was found not to be there. The question then arises, how was it taken, and who took it? And here the law of embezzlement will be easily seen as differing from the law as to other crimes. Here also comes in play circumstantial evidence for you to give its true value and applicability. I ask what became of the triumphant declaration that there was no such sum of money there, as these witnesses testified to, and that it was a cruel persecution on the part of the bank and its directors and persons employed in this case. How fickle was the memory of the counsel who last addressed the jury, when he asked the acquittal of his client upon the ground that nothing was gone. Who was it that brought the money out to be counted? Who marked the amount on each box? Who carefully ticketed each bag? Who made a memorandum and compared it with the number of bags and aggregate amount counted each day, and the aggregate amount counted and placed in these boxes? Who carried it to the books of the bank, and who settled with his successor for that amount, but the defendant? Were these things so trifling that we should not give them fair examination? Can the counsel be so reckless as to argue in a manner which makes their client guilty of practicing legerdemain and telling a willful lie as to the amount of coin on hand? These were circumstances to be considered by the jury. One gentleman can do nothing to turn the current of circumstances from the point of guilt, but indulge in fancy pictures of the imagination. It weakens their case, to bolster up which they resort to a hue and cry against the bank, to the proceedings on Spruce Street, and by these means endeavor to turn the jury from the main facts in issue. Mr. Leslie proceeded to comment on the forensic displays made by defendant's counsel, which he contended was not for the want of facts in the case upon which to argue, but an inability to meet such as had been presented by the state. If the defense had met any of these facts by evidence, he did not know it, but supposed he would be informed of it by the learned counsel who was to follow. If any had been given, it was of so mysterious a character as to escape his observation. He made the proposition for sake of argument, and would assert it, that there was no evidence on which to found a defense, that the case stood without testimony on their part, and there was nothing to lead the minds of the jurors to an acquittal. It had been said by counsel, and met with hearty response from bystanders, that blunders, mistakes, or dishonesty on the part of all in the bank except the accused was the cause of this trial. Blunders, etc., on the part of all of them, from the commencement of the institution, and these call pointedly to your minds by way of accusation. How is it they were not found out sooner, by inspection from day to day and time to time, and while the party on trial was connected with the institution? They are to be accused because they have not looked about right and left, and acted as if every man would steal and run away, and because they have not so conducted, the defense cry out that the almighty power of the bank, in this case, is corrupting the streams of justice bribing the jury and the bench. Such had been the course of proceeding by the defense. But he and his associates had conducted the examination with a view to ascertain the facts. They had asked no questions of a frivolous character, and laughed at them for effect. They could not be charged with doing anything more than was necessary in order that the jury should be put in possession of the case, and then of lending a helping hand to apply the facts to the law. They had heard no counsel on the part of the state talk about hanging the jury, but they say we want to hang the jury and will be satisfied with this, and at this point they cry for an acquittal from the box. These things have been stated so often and argued upon so long that some of the counsel begin to believe that there is some truth and sense in them. They appeared as counsel for the state, not to win a case, and he hoped no one would seriously think otherwise or be foolish enough to charge otherwise, but to aid in the administration of justice, and that without extraneous influences. If Burt McKay or some less notorious characters were here on trial upon this charge, none of these extraneous influences would have been brought to bear upon it, but with united voice the jury would be called upon to rise up and praise such an institution as this bank for bringing by her agents so confirmed a thief to justice. He hoped they would make no difference as to men. The institutions of our country, when calling for the punishment of those who violated the law, did not say Burt McKay, nor the man who preaches from the housetop, makes long prayers, or smites his breast. The jury was sitting there to maintain the laws of the land, and to give all the testimony in the case its proper weight and application without respect of persons. November 28th. Mr. Leslie resumed his argument and said, when the court adjourned, he was proceeding to call the attention of the jury to the body of the offense, and would try to follow it out, and in connection therewith he would comment upon the arguments of Mr. Blennerhassett and Mr. Wright, as often as he could find them or either of them in the vicinity of this most important part of the controversy. He deemed it a proper course to take on his part, in order to make himself fully understood by the jury, for the whole strength of the defense was undoubtedly shadowed forth by them in their respective speeches, and when their view of it was taken and compared with the arguments in behalf of the prosecution, it was presumable that the merits of the case would be developed. The body of the offense, in plain English, is the embezzlement of $120,941.62 of such funds of the Bank of Missouri as were entrusted to the defendant in his official capacity as specie teller. In other words, and without reference to the defendant personally, for he would avoid personalities when he could, it may be defined interrogatively as embracing the following. Was there any money at the bank taken? This is the same, gentlemen of the jury, that the very classical advocates for the defense have called corpus delicti, which term, together with the name of Williams, my learned colleague, and the bank ordeal in combination, has been piped so often that it tries if it does not sicken. My position as counsel renders it unnecessary, when addressing you upon the body of the offense, to name to you each witness and the particular evidence he gave upon the stand, because it is allotted to me, being midway for the arguments for the defense to the close for the state by Mr. Geyer, to test as well as I can the body of the defense upon principles of law, and the body of the offense by the same rule, which I can as well do by referring you to the evidence in solito as by careful detail. By this course, your time will be shortened, and my duty performed to the extent of my ability. Gentlemen of the jury, does not the testimony of the counting committee satisfy you that $120,941.62 in gold was brought forward by defendant in the February and March count, and thereby made to be, for all purposes of the body of this offense, actually in the bank, Are you not also satisfied that in August afterward, this identical amount of gold coin was not in the bank and had not gone out of the bank in the legitimate and ordinary course of business? I think that I can confidently assert that such is the state of things from the evidence. It is testified to by all, the Directory and the President, and thrice vouched for by the defendant himself. And if this is not full proof of the fact, it cannot be obtained by human testimony. I say thrice vouched for by the defendant, first by asserting at the end of each day, from 1845 up to the last February and March count, that there was a given amount of coin on hand, and this statement of his became an entry on the books, for the truth of which he was and now is responsible. Yes, responsible criminally. And under the indictment we are trying him upon. Through the defendant as specie teller, you learn, from the practical operations of this institution, that all persons whose right it is to know get their information of the money condition of the bank. I mean, unless they actually count the coin from time to time, and from day to day, and act altogether impracticable physically, and therefore morally excusable. It is, however, argued by the counsel that omitting this on the part of any officer of the bank who had a right to do so if he could and would is a material matter of defense. I suppose upon that high legal philosophy spoken of by way of compliment by Mr. Wright, as much as to say that if one man is careless of his duty, another has a right to steal or embezzle at pleasure in time or extent. End of section 38. Section 39 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Giles, Jr. for embezzlement. St. Louis, Missouri, Part 19. A leading and favorite theme of the advocates for the respondent from the beginning of this trial, as manifested by questions put to witnesses, by driblet arguments to the jury while pretending to address the court, and by the main effort of Mr. Blennerhassett and Wright, whose eloquent appeals I am now making a feeble attempt to meet and answer. May some controlling power of law or sense in the court and jury save the criminal and civil administration of the rights of persons and things from such specious stuff having any effect. But, gentlemen of the jury, I must make good my position that the defendant has vouched for and proved the body of the offense by his own acts. Secondly, the defendant has vouched for this money by bringing forward every part and parcel of it in bags counted by him, ticketed in parcels by him, noted and marked in his own book, which was just like the bank ledger before spoken of, which ledger he was the author of to all intents and purposes, as far as the coin of the bank is concerned. The defendant again, in the final close of the count of February and March, by recapitulation and testing the actual count of the committee by his own count in his books, settled with the counting committee and balanced the account in accordance with his own statements of the amount of coin in kind and value. Thirdly, he took a receipt for it from his successor, and upon that occasion pointed out to him exactly the amount in specific kinds of gold coin that he counted and ticketed, and after again being counted by the committee, whom you have heard testimony from, and put in boxes and marked by himself, were placed by him or under his direction in the vault, and so remained until Hirschberg took charge of the same. Thus has the defendant thrice proved that part of the body of the offense which relates to the said sum of money being in the bank up to the time that Hirschberg became the specie teller. A denial that the alleged abstracted sum has been proved ever to have been in the bank comes with an ill grace from the defendant, and requires an extraordinary amount of professional courage and impudence to make it a point of argument. It is a direct charge of wilful falsehood upon the respondent at the bar, and if taken and acted upon as desired and urged by the counsel, it will make damning proof of the guilt of the defendant, and show that the manner which has been suggested to you as to how the thing was done is sound and reasonable. But Mr. Blennerhassett and Mr. Wright stated in the commencement that so extraordinary was this case, they should throw off all restraint, cast aside their elegantly wrought veils of modesty, and abuse everyone in and out of the bank, except their sweet and pious client, and most faithfully have they performed their engagement in this particular at least. The first advocate, Mr. Blennerhassett, seemed impetuously to rush to a part of his argument where he could sneeringly pronounce the name of Colonel Brandt, ignorant of who he was talking about, but taking his cue from his senior associate, who during the examination seemed to see the travail of his soul in asking every witness on the stand if they knew Colonel Brandt, and then flourished by knowing looks after the manner of the schoolmaster who whipped his pupil with a peacock's tail, and rolled up his sleeves for effect, and having come up to the point, cried Brandt, bank, combination, inquisition, and then slid off into solemn accents upon the fiery ordeal his rigidly righteous client had just passed through. When men make bold and gallant strides in debate, it is good that they know well the point they are aiming at, and then they will save the mortification of defeat. Do you know Colonel Brandt? Is the significant question. I will tell the gentleman that before he was born, Colonel Brandt was fighting the battles of his country on the northwestern frontier, and resisting the oppression and revenging insults of the learned gentleman's own country, on duty as the forlorn hope, and by his brave action promoted to a high and honorable rank in the army of his native country. And let me tell the gentleman that the same man was on the stand as a witness in this case a few days ago, and on the very day when the audience was nearly doubled to see his immolation, as promised and threatened for several days before, and there, as he had been on the field of battle, with the change only that time and made upon his brow, ready to meet the assaults of his enemies, and at the first dash you gentlemen of the jury saw them wither like green weeds before a sirocco. It would have been wisdom to have left the matter where it was put by Colonel Brandt while on the witness stand, but as it had been designed to make a display of it in speaking, the counsel could not drop it without recomposing their speeches. The learned counsel, Mr. Blennerhassett, next takes a reckless flight into classic history, and compares the inquisitorial action of the directors of the bank and their unholy persecution of Mr. Giles to the action and proceedings and character of the Areopagus, a court held on Mars Hill, whereupon the sympathizing friends of the accused started their usual noise of approbation, and one and all by this mode exclaimed, "There's another capital hit. The directors of the bank have got the money, or at least they are no better than the judges of Areopagus. How mortifying it ought to be to make such comparisons and see such signs of acquiescence in this audience. Gentlemen, this Areopagus was the oldest of the Athenian courts of justice, and at the same time the most famous were its respectability, purity and love of justice, and it obtained its name from its place in meeting on the hill of Mars, near the citadel. It was established by Solon, and Aristides called it the most sacred tribunal of Greece, and Demosthenes says they never passed a sentence in which both parties did not concur. The jurisdiction of this court was murder, poison, robbery, arson, dissoluteness of morals, etc., the charge and care of helpless orphans. Gentlemen of the jury, you must pardon me for these digressions, made in running after counsel who had preceded me in debate. My only reason for so doing is to meet and expose everything that has been said or done with any show of seriousness on the other side. The next inquiry in the natural order debate is how the abstraction of this amount of gold coin was effected. In law, it makes no difference, so it was done by an agent, clerk, or servant of the bank, who had charge of the same in fact or in a fiduciary character. But it is highly important to examine carefully into the manner it was done, and to make the examination by the evidence in the case. This examination, if thoroughly made, will point also to the person who did it, with reasonable certainty. In the first place, it is incontestably proved that the opening and resealing of the 16 boxes, out of the 57 which contained foreign gold, was in some manner connected with, and part of the modus operandi of the abstraction. The only reasonable inference to be drawn from this is that someone who had access at pleasure to the vault did this work, and that it became a necessary part and probably the finishing stroke of the embezzlement which you are trying. If you will lay out of the question for the time being every idea that this money was taken by a forced entry from the outside of the bank, you will be able to more clearly to see the character of the operation inside, and upon the hypothesis so frequently stated to you by the counsel for the prosecution. The counsel for the state contend that there is ample testimony to support the proposition that this large amount of money has been taken from time to time for a series of years, in smaller sums and in such amounts as were best suited to effect the embezzlement, and cover up the artful method resorted to for that purpose, and that the leading or first step was, by forced balances, to bring black and foul lies upon the books, and then to work out the scheme according to the exigencies of the case, relying upon the manifest confidence which one officer of the bank had in another to help in the consummation of this strange and startling crime. Let us see how the thing could be done. You learn from the evidence of Mr. Clark that at the commencement of each day's business, Mr. Childs received a certain amount of the notes of the bank from him, and with which he stood charged by Mr. Clark until the close of the business of the day, when Mr. Childs would hand back the paper not used, and report an amount of coin in the place of the notes not returned to balance the account between the two tellers, which when done, an entry showing their transactions went upon the books. The testimony is also positive that in no instance did Mr. Clark, the cashier, or anyone else test the truth of the specie teller's statement by counting the coin reported by him as on hand, and the witnesses go further and testify that it would be physically impossible to do so. You will readily see, I apprehend, that under such a practice, any amount of paper could be taken for the private use of the teller without detection. The fact that the defendant, as specie teller, had the custody of the coin puts the whole matter in his own hands and without danger of discovery, unless by actual counting in his absence, or unless the bank should be called upon to pay out as much coin as would call for the whole or part of the $120,941.62. Neither of these things were likely to occur, as they never had from the commencement of the corporation, and therefore that chance might be confidently taken. The manner in which the several countings have been conducted year after year allowed the specie teller to have just as much counted twice as would meet the abstraction, he having a full and perfect minute of the whole amount embezzled. I ask you, gentlemen of the jury, if any person other than the defendant could from time to time have taken the paper of the bank to his own use, and ostensibly, by forced balances of coin, make it appear to be in the bank. Clark, the receiving teller, had nothing to do with coin. The bookkeepers had nothing to do with either paper or coin, but were the mere recorders of what these tellers furnished them for entry. Shirles, the cashier, could never have meddled with it, for if he had, Charles could not make up his account. The directors are as far removed from it as if they had no right in the bank at all, and nobody but Charles could have touched it up to the time of the February-March account, because, he said, as a man in whom there was confidence, he said, as a citizen who has no right to lie, he said, as specie teller under oath, that the money was there, and in some way or other made it so appear to the satisfaction of the counting committee. Then I asked, gentlemen of the jury, if it was untrue that the gold coin was there in the February and March account, because of the piecemeal abstraction made previously, or for any other cause whatever. Did not Charles, the defendant, tell the lie, practice the deception, and embezzle the money? This conclusion is inevitable, or legal logic and human reason is weaker than the bubble that breaks from its own inherent feebleness. Mark, gentlemen, that you have the high public responsibility of adopting or rejecting this conclusion, or the counsel for the state cease to have any responsibility after they have presented it for your consideration. Thus far, I have endeavored to show how the money might have been embezzled by forced balances of coin, and upon the proposition that it was out of the power of anyone to do it but the respondent, by himself or by combination with others, and that in either case he was equally guilty under the indictment. The argument upon the last proposition stops at the February and March count, or at the time his successor took charge of the funds. The trial of this last question is simple and short. If we commence in 1845 and end at the time the coin was turned over to Hirschberg, his successor, you will notice, gentlemen, that Mr. Charles has vouched for the amount of money up to that time, as much as he has ever vouched for a single cent of the funds of the bank during the time he has been employed in it. And if it suited his notion to take it in specie, he had the same power to force balances by false statements under this course of action as by any other. And it is equally true that no other person unknown to Charles could have done it, and the deceptive double counting was as easily done in one case as the other. Now, gentlemen of the jury, if you drop the outsiders, so-called, and find that the money was so abstracted before the February and March count, the testimony points to defendant with unerring certainty, and not one substantial thing exists to turn the current of the evidence from the point which all the circumstances, which are facts of themselves, rationally and legally tend, to wit, to the defendant as the guilty party. He asked the jury to go with him in the inquiry into the vault of the bank at the time Charles turned over the coin to Hirschberg, and stay there until they can, from the evidence, see whether an abstraction of the money occurred after said Hirschberg took possession of the contents of the vault. If the embezzlement took place between that time and the day Page and Bacon presented their draft for payment, then Charles is excused, and the offense must be fathered by outsiders, Charles or Hirschberg. But as all idea of violence to the vault or entrance into the building is negatived by positive testimony, we may as well drop the outsiders here as anywhere, and in doing so, we shall not be unkind to the defendant, as that was also his view, as expressed to Dr. Forbes, when he said there was no mistake about the money being gone, and that himself, Charles or Hirschberg, must be guilty. If Hirschberg took the money, it was by opening, abstracting, and resealing the 16 boxes so often mentioned, and then arranging them in the extraordinary position, as proven they were put up in, a proceeding wholly unnecessary, as he could gain nothing by it, in the line of concealment. But what is most absurd in any scale of reasoning is, that he, Hirschberg, should be the very man who first disclosed the abstraction, and that, too, when there was no necessity of it either before box 30 was brought up to be counted out to Page and Bacon, or after he noticed that it was minus a bag of sovereigns. In the first place, He would have been the last man to have selected that box, and if he had done so by mistake, it required nothing more than silence to correct the mistake. For the clerks of Page and Baker neither knew nor cared how many bags were in the box. Mark his conduct on this occasion, how diligent he was in pressing the matter to the point that opened up this stupendous fraud and exposed it in all its dark and criminal deformity. In view of the evidence, gentlemen of the jury, and the unassailed and unassailable character of Mr. Hirschberg, his manifest concern in dissembling conduct throughout, whoever suspects him for a single moment is unfit to sit in judgment upon his fellow man, either civilly or criminally. And now I will leave the vault of the bank, the place that the counsel for the defense dread more than all places in this case. They have a preference for the graveyard to this cold, stony, mildewed, gold-holding cavern, and it is with the utmost difficulty that you can keep them there long enough to count the 16 boxes that ought to have contained $120,941.62, more than they did contain. Yes, I will go to the ornamented graveyard, and there seek for, and perchance find, evidence of the crime we are inquiring into, and feel as happy in the excursion as he who caused the journey. Let me say to the gentleman, Mr. Wright, who has made so many tremblingly alive all over remarks upon the sanctuary of the dead, that we do not visit the sepulchre with cruel and unhallowed designs, but we visit it upon what we claim the purest principles of propriety and Christianity, and we visit it with the declaration that money criminally obtained from the living is not needed to ornament the resting place of the innocent and virtuous dead. It was incumbent upon the state to inquire without stint into the pecuniary affairs of the defendant, and to make such use of the discoveries as law and justice permits. The written statement given by Mr. Childs as to the extent of his property, and the fact of burning it, and that, too, by advice of counsel, is an indication of guilt. It certainly could not take the direction of innocence, for the innocent are not alarmed at their own mistake, while the guilty oftentimes overact. This is in the line of circumstantial evidence, and like everything else in this trial in the shape of evidence, tends, according to the legal rule, to support the hypothesis upon which we started. I, however, desire, as I am about to submit the case, as far as I am concerned, to remark that the technicalities of the learned counsel, which have been their whole defense from the start, are of strange manufacture and difficult to describe. In the early part of the trial, they seized a web that was left by a swarm of dancing flies, and to make a cord of defense out of it, they divided their strength, and applying it to each end, they pulled and twisted till the thread became so attenuated as to part in the middle, and the operators passed out of sight in the technical fog they raised around their own heads, and have never made their appearance since upon the solid platform of law and evidence. This need not have happened if this defendant, who has drawn around him the solemn vestments of religion, had been content with Christian love and herbs for dinner, instead of stalled oxen obtained by sordid wealth. Gentlemen of the jury, I have striven to the utmost of my ability to present this case before you, according to truth and professional propriety and duty, and if, in the humble discharge of this duty, I have said or done anything unkind to the prisoner at the bar, or have been in any manner uncourteous to you, the court, or my respected opponents, I humbly ask pardon, and now, in view of this whole case, as it stands in law and upon evidence, I leave the responsibility of a verdict upon those high principles of truth and justice which ought to govern you in this trial, and upon the solemn oath you have taken to do justice to the state and the prisoner. Give also, in kindness give, the defendant the benefit of sympathy. I admire, as you do, the eloquent appeals of counsel to the sympathies of the soul. I am happy because it shows they possess it themselves in a high degree. It ought to find welcome in the heart of man. It is a heavenly essence, distilled in paradise near the throne of God, and trickles down to earth on effulgent rays of light to make a blessing here. But cold and sordid crime must dam its general flow. Gentlemen of the jury, take this case and all its responsibilities. Mr. Giles said he would place the senior counsel for defendant, Mr. Bates, in possession of the general course or line of argument he would introduce. After disposing of the question relating to other persons suspected, he claimed to show it was impossible, consistent with the facts, that either of the persons in the bank could have taken the money at any time after Giles ceased to be teller. He would show by the facts of the case and then maintain that when the money was taken, it could have been taken by nobody but the accused or some person in collusion with him. He intended to point to the facility which existed for the accused to make abstractions from time to time, and so managing the counts at different periods as to conceal the amount missing. And in connection with this, he intended to refer to the specie books and ledger balances made up by testimony furnished by Giles himself, as showing the amount of coin on hand, which he cannot gainsay. Whether these accounts corresponded with the general accounts of the bank or not is a question with him. He would then refer to the specie book and show what appears to be a system of forced balances, commencing in 1847, and by reference would show that in a large majority of his weekly accounts, his foreign coin is in even thousands, notwithstanding its great mixture and amount, with 2 or 3 exceptions, besides those of the semi-annual counts and counts by the legislative committees, at which times it was in odd sums, but would immediately fall down to even sums. This was the case after defendants leaving the bank, from which period it began to be odd and so continued to the 11th of August. He would then advert, connected with that change in the account of foreign gold in 1847, to the operations of defendant out of doors, and would show that the statement he gave of his affairs was reasonable, but that, in the years 1847 and 48, he spent upwards of $10,000 in the way of building, which he paid in cash. He would then come to the December count in 1848, show how it was conducted, and that the 2 chests in the vault, purchased by defendant himself, had afforded him, at all these counts, the opportunity of changing the gold from the chests to the shelves so as to cover up any deficiency. Down to the December count, the committee appeared to have contented themselves by ascertaining the aggregate of coins. At that time, the American coin is entered on the specie book at $350,000, and the actual amount reported by the committee at $300,000, showing a discrepancy, unless the bags on the shelves contained American coin. He would show by the specie books, however, that the American coin ran down for some period before, so that it could not have well been American coin on the shelves. The shelf gold in December was $287,000, being 102 bags, almost as much in as many bags as was in both the chests. How it got there would be a subject of remark. In connection with this, he expected to show that a number of bags appeared not to have been assorted, and that the receipts were not so large as to require any time to assort them. The next circumstance he would show was that the number of bags in the vault of the December count exceeded by 82 the number of bags that were put in the boxes at the February count, and he alluded to that for the purpose of calling on the defense to explain why more bags were wanted during the February count. The next thing he would call the attention of the jury to was that defendant was called upon before the February-March count to arrange the coin, and if he did it before the count, then his absence can be accounted for, and if he did not do it, that matter can be explained by his counsel. If he did arrange the coin before the count, then why afterwards require more time during the operation of the count for that purpose? He would then allude to the conversation defendant had with Mr. Fisher. He would show the order of counting was thus. The committee counted the first 3 days successively, ending Saturday, then again on Monday and every alternate day thereafter, until the count was completed. That the arranging and placing of the boxes in the vault, the American coin in front of the foreign, was not by order of the directors, but by order of Childs. That 14 of the 16 bags abstracted appeared to have been abstracted, and the boxes immediately behind the boxes of American coin. That these 14 boxes contained 29 full bags of thaler pieces, and during the Monday and Wednesday countings, no 10 thalers appeared to be counted. At this interval, the defendant pled for more time to arrange the coin, and it was granted. And on the week after the counting commenced, about the same period that more time was asked, defendant purchased an additional quantity of sealing wax, that no full bags of thalers appear in the boxes again until the count on the following Friday, being the 6th day of the counting, when the first box counted on that day showed an abstraction of sovereigns, and the 7th box, counted on the same day, showed an abstraction of thalers. That the sub-treasury gold, which according to Child's statement was sovereigns, was taken up to be counted during the last 2 or 3 days of the count. That in all the counting there are but 58 bags of sovereigns found, and a great variety of other coins, among them a large amount of thalers, which run through the 57 boxes at intervals to the last box. He would then rely on sundry circumstances which gentlemen have mentioned, the fact that a statement of his affairs was made by Childs to the bank, which was subsequently obtained by him from Shirl's and taken away, under a promise to return it, that he did not return said paper, but destroyed it, without taking a copy, and thereby deprived us of the means of giving its contents from the paper itself. He would call Mr. Bates' attention to his running commentary, as published in a paper of this city, on reading a testimony from the minutes of the board, the report of June and July. On that day, Mr. G. was absent from the court. It appears from the newspaper that Mr. Bates took the aggregate on the 30th June from the specie books, and makes a difference between that and the report of the committee of $2,815.40. Although the difference appeared, he would call attention to the testimony of Mr. Barnes, who stated that, in consequence of the sickness of Mr. Hirschberg, the semi-annual count was continued until the 5th of July, at which time, by looking at the ledger balances, it would be found that the report of the committee corresponded. End of section 39. Section 40 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 20. Mr. Bates for the defense. Mr. Bates. Gentlemen of the jury, it may not be necessary for me, like all who have gone before, to compliment you on your attention during the progress of this cause. Your patience up to this hour indulges me to hope the same may be bestowed upon me during the remarks I may submit. None who have preceded me have abstained from telling you this was an uncommon, an extraordinary and novel case, yet one half of its mysteries have not been told. Mr. Guyer had just stated some, which you had not heard until the final ground was to be taken, and then you heard them but imperfectly. There were others, hid in the deep arcana of that gentleman's astute mind, which we will not hear while we have the right to reply, and so the real beginning of the prosecution will only be seen in its end. It was an extraordinary case, and a wonderful circumstance connected with it is that up to this moment the indictment had not been read, and not one of you in your conscience can say what you're going to decide on. There might be neglect in this, but it was not so. You have heard us implore often and over again that the case be conducted as other criminal cases are, but to no avail. Mr. Haight, when he opened the case, told you he held the indictment in his hand, but it was not worth his while to read it, that it was an indictment for embezzlement. He told you a little then and would tell you more thereafter. This case is imaginary. No particular charge had been preferred, and it claimed an origin in no particular quarter. It is not the state's case, but it is emphatically and alone the case of the bank. The representative of the state has long since yielded the field to a strong array of bank counsel. He would not have drawn such a fishing indictment as this, much less prosecute under it, containing as it does 6 vague and scattering counts, not one of which is good. Defective as it is, we were afraid to move to quash, standing on the ground of innocence, and determined to stand proudly on the ground of self-defense. We waived such a motion for fear of delay, believing this to be but a branch to a civil suit pending against the defendant. We know how this case was gotten up, and it did not need Mr. Sherrills, the cashier, to come here and tell us that the bank was frenzied at the moment the bags were missing from the boxes. Every act of the bank in regard to this prosecution has been marked by precipitate injustice and headlong madness. Yet the power of the bank is fearfully great. It pervades the community. When it speaks, society trembles. Now, it moves along like our majestic river sweeping away all obstacles. Anon it creeps, in insinuating rills, through the little glens of social life, silently undermining the fortunes and characters of men. The loss was discovered, and you heard by the testimony with what desperate haste the host of bank directors jumped to their conclusions. Walsh was sent for. Runners started to summon other members of the board, and a meeting was held. Childs was sent for, and he was there. The boxes were opened and diligently examined, and a number of bags found missing, as was then supposed. The president and cashier slipped out of the bank. The doors were locked after them. They proceeded to Justice Butler's and made the affidavit for arrest, leaping, evidently in the dark. With frenzied haste and little attention to truth and consistency, they swear to the actual larceny, the amount stolen and the time when. Childs was then locked in the bank. He was arrested without receiving any notice of suspicion against him, until he was told that an officer was at the door with a warrant. What more was done? A few days afterwards, the board of directors thought fit not only to endorse these proceedings, but took up the affidavit and approved the swearing of the president and cashier. What evidence had the board then as to the character and quantity of the coin said to be lost? At that time, Mr. Geyer had not been retained, nor his genius exercised in calculations to inform his clients whether or not they had lost anything, what they had lost, and when. What further? On the same day, they ordered that steps be taken for issuing a search warrant against Child's house, which was issued immediately. A day or so afterwards, Mr. Sherrills reports to the board that in addition to the search warrant against Childs, he had caused a search warrant to be issued against Mrs. Whitlock's house, and forthwith the board approved that proceeding also. These proceedings can neither be got over or around. They fixed the bank in one position respecting this abstraction, that the gold was actually carried off, and to this they should be held strictly. Now, they say that this is all a mistake, notwithstanding the swearing of the president and cashier, and the repeated resolutions of the board. The gold was never taken from the bank, but only transferred from box to box by some jugglery in the counting. Seeing their mode and manner of proceeding against the defendant, their disregard to the rights of women and society, their running in violence against the statute laws. He felt his indignation rise, and as he remarked on a previous occasion, did not intend to waste any delicacy in exposing the false, unjust, and cruel grounds assumed by this prosecution. And the prosecution were arguing the case as if the defendant had something to prove. Mr. Williams had stated, and Mr. Leslie had repeated the idea, and then asked, wasn't the money stolen? And if Mr. Charles did not get it, who did? Charles had nothing to prove, nothing to show. His accusers had. How could any man prove that he did not go into the vault of the bank and steal the money? It is not our duty to show this, and if we made the attempt, it would have been a failure. He would show by the charter and bylaws the relative and positive duties of the president and cashier. And if they had come anything near the gauge of their own duty, it would have been impossible for Charles to have purloined $1 from the bank. He meant to prove that, and he defied contradiction. So far from the specie teller being the only man unchecked, the only man free to steal, he would show that there was one man freer, that the cashier was the only man who had power by law to steal the money of the bank. In such an institution, defective as it is, somebody has to be trusted, and thus the charter and bylaws have made that man the cashier. And when he came to that portion of his argument, he would read the clause. In order to revive the failing memories of the directors, he would make it plain that it should not be denied, that it was the cashier's duty not only to keep the money, but every day to count and see that the accounts balanced, and if he found any error, to report it to the board without delay. That was the law, and if never practiced, it was a crime. And if it had been practiced, an embezzlement could not have taken place, because the balances would have been made every day. The cashier was keeper of the cash, and if in the discharge of his duty he had gone to Charles every morning and given him a certain amount of cash, and at the close of business settled with him according to his operations during the day, he would have been checked on the instant and checked every day, and there could not have been any default on his part without an association with whom he especially charged with the cash. In consequence of the late hour at which Mr. Leslie closed, he intended to throw out a few suggestions to the jury this afternoon, in order that they might retire and chew the cud of reflection during the night. December 6th. Mr. Bates asked whether up to the moment any of the jury knew what was to be prosecuted. Not a man could answer. There has been a broadcast insinuations made, then embodied in the form of a charge, and then brought into a bill of 6 counts. What it is his client was to be found guilty of, no man had told the jury, and so it became his duty at this late hour of the investigation to be the very first to read the indictment to the jury. It contained 6 counts, many of which, in his judgment, were bad in point of law for various reasons. Embezzlement in one form or another was stated in all 6 counts, and he contended that embezzlement and larceny were substantially the same, the one being the felonious taking of goods already in possession of the thief, and the other the felonious taking of the goods from the possession of the owner. After reading and explaining at some length the 6 counts of the indictment, he said it would be seen that this indictment was drawn with minute particularity. It is so drawn because it was known to be necessary that every charge should have certainty and specialty, and because they knew it was necessary for this jury to decide the defendant guilty of some particular thing, and not guilty of the general charge of embezzlement. This is not the state's prosecution. Here is the indictment in the handwriting of Mr. Ryland, bank attorney. Here it is, drawn by the bank and prosecuted by the bank. It was indispensably necessary that the time, place, and circumstances should be stated. Mr. Leslie, in his argument, attempted to state the difference between embezzlement and larceny, and my ear was startled when he made the declaration that embezzlement was no offense under the common law. He differed with Mr. Leslie and contended that it was always a crime in England. Before made felony by statute, it was like perjury, a high misdemeanor, for which the offender might have been imprisoned, whipped, cropped, branded, or deported to the plantations. The indictment, as the jury has been told, was defective in point of law, yet the defense did not choose to argue its legality before the court in order to have it quashed. They did not choose to give such aid to the ulterior objects of the bank by delaying this investigation. A civil action was brought against the defendant at the same time this suit was instituted, and he thought the present a very good time to launch their bark. He did not want them to have an opportunity of trying that civil action before this investigation was had. He wanted prompt action, knowing as he did that his client was prepared to meet all assailants, come from whence they would, or as powerful as they might appear. He wanted prompt action for another reason. All defendants' means and funds were locked up. Such as had escaped the inquisitorial vigilance of the directors and attorneys of the bank, were seized by the sheriff on attachment, and it was necessary that they should be restored in order to put him in the way of earning his daily bread and retrieving the losses inflicted upon him by the wanton prosecution. Such an indictment as this could never have been gotten through the grand jury, but for two reasons. The directory of the bank were represented on that jury. Barnes was there, and he would not impeach him or say he was unworthy to be there, and he was capable of making any explanation. The charge was preferred by the bank, and this indictment was in the bank attorney's handwriting, and he felt assured that had not a representative of the bank been on that jury, such a paper would never have gotten through. No foreman would have endorsed on its back a true bill. The counts in the indictment were conjectural, like the general charge, only capable of being sustained by circumstantial evidence, and before he got through, would show their motives for bringing the charge. No man could wink so hard as not to see that the state has nothing to do with this case. The state has other indifferent motives in its prosecutions than that which influenced this. The state has a motive in shielding injured innocence, and to bring the offender, however high in life he may be, and arraign him at the bar of justice. It has a motive to do that, in order that the law may be upheld. The law has a high duty to perform in bringing the guilty to justice, and not a less duty in protecting innocence from prosecution. This indictment was wholly defective. He would say he felt confident, had his friend Lackland, the state's attorney, managed this case, he would have ended a nolle prosequi in the first week. But the bank had its motives in this prosecution. It may be asked, what motive has the bank? Can it in this way get back its money? No, not directly, but they may learn how to prosecute the civil suit with better effect by the coercive means of a criminal prosecution. They may feel their way in this proceeding and learn how to build up a state of circumstances, step by step, which may promise them a better hope of success on the civil than on the criminal side of this cause. Besides, if they can fix suspicion on Childs, they acquit themselves. They may lose their money indeed, but they save their reputation. He then alluded to the discovery of the loss of bags on the 10th of August, the surprise, frenzy, and vast confusion which seemed to reign about the bank on that and succeeding days, and the sudden manner in which they jumped to a conclusion of the amount gone and the guilty party. He did not deny some of the men about the bank honestly believed at that time that Charles was guilty. Mr. Guy has only at this late period informed us how he is going to calculate our guilt and cipher us into the penitentiary. But these calculations were not made at that time. They leaped in the dark, and were ignorant of their loss, and all attendant facts. The brightest intellect among the directors comes here ignorant of the charter and bylaws of the bank, and proclaimed the fact from the witness stand. The bank was a corporation, a political corporation, a state bank, governed by the legislature. The character of the bank had to be maintained. Here was a loss discovered all of a sudden, and however they might reason, the public mind must be satisfied, and although the mass might be induced to fix on Giles as the guilty man, still all the rest in or about the bank were equally liable to suspicion. There was nothing so high or holy about them as to prevent it. Our reverence for bank directors is not an impervious shield against suspicion. We know how the legislature sometimes makes them. They pick up some little fellow who, by hook or crook, has got $500 worth of type and prints a party paper and manufactures him into a director to give him some importance. And happy for us is it, if, after serving a little while, he turns patriot and leaves his country for his country's good. It is well known how the state manufactured directors, and it was necessary for private stockholders, in consulting their interests on their part, to put in men of the best business capacity. Mr. Barnes used to be elected by the legislature, and he is a businessman, but becoming too soft in his politics, was left out. And then he was put in by the private stockholders, in place of George Collier, because private stockholders had money at risk, and had some wish to support the reputation of the institution. There was a high motive operating upon the institution to bring this charge. This court sits every 2 months and the circuit court every 6 months. Cases in this court can be tried at the first term. In the other court, they cannot. And the prosecution brought against Giles in that court would be pending 6 months, and perhaps a year. If this case could be continued from time to time, and every valve kept open, they expect new light, and by this means not only afford time to Mr. Geyer to cipher out the guilt of the accused, but they hope that somebody in Missouri or somewhere else would start up and tell them something to lead to the knowledge of what they lost, and how they lost it. It is in proof that the bank lost $20,000 some years ago, and which disappeared like the gifts of the witches. Some men of wealth are proud of the reputation of being the rulers of the money market, and the only men allowed to deal in a bank in Broad, Missouri. Who is not proud of his professional ability and standing in society? These directors had that reputation to sustain in regard to the management of this bank. They had to sustain themselves, and brought this charge against Giles, who left the bank early in May, and left it fully endorsed by the directory, although it was made to appear from the stand that this endorsement was dissented from by some of the board, yet when they produced the record and evidence, we find it was by unanimous vote. Who conducted this prosecution? It was not the state. This was evident to all who had been present during the investigation. But to show the matter beyond all question, he read from the minutes of the board already in evidence, at a special meeting, August 13, the famous Monday on which the search warrant was issued, and the disgraceful proceedings thereupon transacted. It was ordered by the board that the president be directed to retain Messrs. Gamble and Bates, Geyer and Dayton, Haight and Partner, and Williams and Kirtley, to act in connection with the bank attorney in the prosecution of the matter of the abstraction of funds from the bank. Ryland was already bank attorney, and these gentlemen were to assist him. They take no notice of Lackland, the state's attorney, and mark, these gentlemen were not to help him. He is in the condition of the young sparrow, in whose maternal nest the cuckoo laid its eggs. He would now make some remarks as to how the case had been actually conducted, and in doing so, he would have to advert to the opening of Mr. Haight. What is the use of an opening statement? Rule 26 of the practice in this court says, on the trial of a case, the circuit attorney shall open by reading the indictment and commenting thereon to the jury, and give the law expected to be involved in the facts to be proven. Was this done? And further, it goes on to say, that after the evidence on the part of the state is given, defendant's counsel may be permitted to open the defense, commenting on the testimony already introduced and that expected to be introduced, and after the evidence is closed, the circuit attorney shall be required to tell the law and facts, etc. This was the rule. Now let us see what was done. When Mr. Haight opened the case, he said, quote, I hold the indictment in my hand, but it is not necessary to read it, unquote. The rule says he shall, and put on it the interpretation and views he intends to insist upon before the jury. Quote, it is sufficient to say it charges him with embezzlement, end of quote. Why, embezzlement is as broad as the universe of the conceivings of the imagination. Quote, he was an officer of the bank entrusted with its money and took it for his own use, end of quote. Larceny and embezzlement, says he, are different. We have this indictment, both under the general law and the charter of the bank. He then referred to both these and to the punishment to be inflicted under each, etc. After speaking of this matter, Mr. Haight said there could be no dispute about Giles being such an officer or entrusted with the funds of the bank. We admit that Giles was such an officer, but dispute his being the keeper of these funds. We admit he was specie teller from the first, but deny that he had charge of the specie of the bank. 25 days had been exhausted in hearing the testimony in this case, which was introduced to the jury by Mr. Haight in a very short time. He told you it was mostly circumstantial, and warned you it would be necessary to observe it closely in order to see its importance and applicability. He then told you it was due to yourselves and the accused that he should give a general outline of the evidence. And what did that outline consist of? Simply a detail, the manner in which the coin was counted, telling the amount then thought to be on hand, and the means by which the supposed abstraction was discovered. He also told you that Giles kept the count of the coin, and his count corresponded with that of the committee. From this, Mr. Geyer was to do his ciphering in order to show such and such amounts of these boxes of foreign gold, and from that to draw his inference that there were forced balances upon the books. Mr. Haight said, quote, the counting in February was a count of all the money on hand, end of quote. Was it? If it was, then banknotes are not money, for they were not counted. Clark made an aggregate statement and they took it as correct. They did not pretend to count the paper. Mr. Haight told you further that the committee counted every day for several days, when upon application of defendant, who complained for want of time to prepare the coin in suitable quantities to the bag. They only counted on alternate days, that as the gold was counted, it was placed in bags and boxed, and the name of the direct accountant placed on each box. Quote, that the 10 thaler pieces were a coin which was not intended to pay out from the bank, but to be sent east as they were boxed. End of quote. Quote, that the boxes in which this description of coin were placed were large boxes, numbering from 1 to 57, and that the money could not have been taken from them after this count on 1, 2, or 3 occasions without assistance. End of quote. After going on and describing the manner of the counting and weighing in December, he says, quote, that count might have been a test against all the world, except the defendant, who could easily remove from the chest of the shelves gold once counted, and in such quantity as to make any amount he pleased on hand. End of quote. No counting was a test against Giles. The wand of that magician could remove any amount from chest to shelf at pleasure, and produce double counts. The legislative committees were no check against Giles, though a test against the whole world beside him. Where is the charity, not to say justice, in such an imputation? He continues farther, quote, by the count in February, the amount of gold exceeded by $100,000 the amount found on hand before or after. End of quote. He passed this without remark. There was no evidence of external violence to the bank or vault, and there was only one person in the bank who had charge of the cash and balancing the cash account. He denied it, and no man could say it without a fearful disregard of the law and the obligation of the cashier. We shall establish beyond all doubt that this particular sort of money, thalers and sovereigns, were boxed up with a view of being shipped east, and also show that during the count, Childs was in the vault frequently during the day and went down there several times during the night. He was sure that Mr. Haight did not weigh the words he used when he said he went down into the vault at night. There was not one iota of proof or circumstance leading to establish that conclusion. Mr. Haight then dwelt on Mr. Child's position in the bank, the temptation and the inducements for making false statements at the February count in order to cover up previous deficiencies. Has any proof been introduced to show an abstraction from the bank previous to that count? Not a particle. That matter has been left to Mr. Guyer's arithmetic, and yet it was boldly assumed in the beginning. Mr. Haight started with the proposition that the money was taken from the vault, but now, after laying together the heads of the directors, above ground and underground, they falsify this eerie superstructure erected as a tower of strength against this defendant. Some of them knew he was growing rich too fast, and that was mooted as early as December last, that his immense expenditures, gorgeous magnificence, and oriental displays were such as to look too splendid in their minds for a poor, blind plebeian. It surpassed their understanding that a poor teller in the bank with a salary of $1,200 could live in this Rothschild style. They had forgotten when they made that jump in the dark, when they charged this magnificence to the stolen money, that he could not have spent it a year ago and stolen it since last January. During the examination, when a question was raised, the court took occasion to say it was not pretended this money was taken before the February count. Then Mr. Guyer rose and corrected the court, and said that was the very thing they did contend, that it was not taken off at that time or since, but long before, and covered up at that count by what Mr. Haight called some hocus-pocus, other particulars of which he did not tell us. The manner in which the case was opened, there were no points laid before the jury to help them to single out in their own minds the facts which were to mark the case, and he did not believe one of the jurors knew more about the case after that speech was concluded that they did before it was begun. End of section 40. Section 41 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for embezzlement. St. Louis, Missouri, Part 21. Mr. Bates then spoke of the manner in which the prosecution had been conducted and followed up by the counsel who had preceded him. He was not going to answer the propositions of Messrs. Williams and Leslie. They carried out the idea of Mr. Haight, that we have arrested you, got a great bugbear of an accusation against you, and now prove your innocence. Both those gentlemen had asked, what have you proved to show your innocence? We are not forced to prove anything, and it is not our duty. No man in the room could prove that he did not steal that gold. Mr. Leslie said the argument was all blatherdash, trash, and froth. If we advance any proposition in testimony, it amounts to nothing whatever. Facts were stubborn things, and what advanced did not suit this prosecution. We shall proceed to notice the means resorted by the bank to get testimony. First, when Messrs. Walsh, Brandt, and the President were upon the stand, they were asked if any gentleman had been procured to go east and make diligent searches for the hidden treasure of Childs. It seemed to strike them with surprise, and they looked as if cold water was trickling down their spines. No one could remember that the board, as a board, had ever retained any man to go eastward. At that time we had not got possession of the minutes of the board, and these gentlemen supposed we never would. This fact was held back. None could tell whether it was a recorded matter, and all agreed in saying it was done by consent of the directors, had in an informal way. That a good many little things were done by the directors, not considered material, which were not put upon record. They were asked pointedly if any man was retained for that purpose, and they answered there was a gentleman going eastward, and they did get him to say he would stop in the principal cities and look into the matter, and would charge only for the time he was so detained. Look into the record. What does it say? Tuesday, August 14th, 1849, the board met, 10 directors present when Mr. Brant moved a suitable person to be procured to proceed east, with the view of ferreting out evidence as regards the person or persons who may have abstracted funds from the bank. Mr. Barnes moved, as a substitute, that the agents of the bank in Baltimore, Philadelphia, New York, and Boston be instructed to employ a police officer to inquire if N. Childs, Jr. has any money deposited in his credit in any of those cities, and ascertain if any stock or other evidences of debt has been brought or sold by the said Childs or any of his relations, or if any stock stands in the name of the said Childs on the transfer book in either of those cities. The question being on the substitute, it was negatived, and the proposition of Mr. Brant adopted. The President and Mr. Brant were appointed a committee to procure a suitable person to proceed east. You know how many gentlemen were examined on that point, and not a word could be gotten from them. No me recordo. I did not write it down. We have got no memorandum, and they forgot all about this. They did send a man to the eastern cities to make inquiries. They sent letters to banks in all parts of the United States, where they had agents, to hunt for its stolen property or its proceeds, not only in the name of Childs, but his relations and family. These letters were not all. We had proven by Barnes and several of the directors that they had searched the broad continent to see if they could find one vestige where Childs had invested a dime. They had found nothing, but since the fact has come out that an agent was procured to go east, they have insinuated the receipt of a telegraph dispatch and letter from Baltimore, the contents of which were not given. They found no money, however. The sending an agent east and letters to the bank were not all the means used to obtain evidence. It was an important matter, and Bolin must be sent for. He came, and being disappointed in the man, they suddenly charged about and attempted to destroy him. Bolin, it will be remembered, came upon invitation of a gentleman of wealth, a prosperous bank director. Several years before Bolin went into the bank as porter, he was a trusty agent in the house of Mr. Christie, upon whose recommendation he got the situation in the bank, and that gentleman, from his acquaintance, was selected to give the invitation. Accordingly, on the 15th August he writes, directing his letter to John Bolin, Esquire, not Bolin the plebeian, or Bolin merely, or John Bolin, or even Mr., but John Bolin, Esquire. Sir, mark you, your favor by mail was received this morning, informing me about your land, etc., all of which is satisfactory. He took great interest in his affairs. The bearer, John E.D. Cousins, no Esquire title there, visit your place to get you returned to St. Louis as a witness in the case of the bank against N. Childs, Jr. Cousins did not go merely to invite Bolin to come. A letter would have done just as well. He went to get him to come, and if he did not come willingly, to bring him, not because there were whispers against his character, in connection with this loss, but because he was wanted by the bank as a witness. That was it. It was expected he would be a swift and hoped to be a willing and powerful witness. To be a witness against Giles, says the letter. No one would suppose the bank to pay $100 and take such trouble to get him here for any other purpose in the case. The circumstances will be explained by cousins if you have not previously heard them through the public prints. You had better return as soon as possible. Why? The letter was written on the 16th, and he could not return in time to be a witness before the grand jury. Why return as soon as possible? It carries upon its face the answer, as the directors are anxious to converse with you about the matter. What did the directors want to converse with him for? He being summoned as a witness in a case where the state was prosecuting. After addressing Bolin in this style, the note closed as follows. I was at your house yesterday and found the ladies well you left in charge. Hoping to see you in St. Louis. I am respectfully, W.T. Christie. Well, Bolin was brought to St. Louis and he was conversed with. He told you that when they were trying to drill him, he gave them to understand he would tell what he knew when he came upon the stand. He boldly appears before them and demands what they have against him. Bolin tells us how it is, say they. He answers as he properly should, and for this he was kicked overboard and must now be sacrificed. The prosecution had not given 1/10 of the part of the testimony they intended to give. They had witnesses summoned to prove nearly all of the defendant's dealings, but so unsatisfactory did they make out with such as they were brought on the stand that they declined going through their host. They found, as far as they progressed, that every transaction was but an honor to the defendant, that he would come out white as the mountain snow. No man to say he ever wronged him, or did other than justice in his dealings. This being the manner in which they sought evidence against Giles, the next important work was to manufacture public opinion. Giles was arrested on the 13th of August, and on the 16th, in order to allow free scope for conversation about the matter, that it might have influence with all they met. The board of directors, on the motion of Mr. Brandt, repealed the bylaw, imposing secrecy on the members of the board, so far as the same related to the resignation and abstraction of N. Giles, late teller of the bank. No reason or argument is given to show why this was done, and is left for us to conjecture. Their object was not only to set their tongues at liberty regarding the abstraction, but to discuss something else. They talked the matter over freely among themselves, and scattered through society their suspicions as facts, and their crude opinions as the just conclusions of law and truth. And thus they hoped to forestall the public mind, to make sure of their victim, condemned before he was formally accused, and slain before the first weapon of law was drawn upon him. Eavesdropping guards were placed about the houses of individuals. Respectable citizens were seized and imprisoned. Mr. Anderson was arrested, and his person searched for coming out of Giles' house from a friendly visit, and Mrs. Hogan and Gay were simply inquiring for Mrs. Hayden's, were threatened with a club and hurried to the calaboose. And all this was done, not by any pretense of lawful authority, but by the barefaced violence and insolent tyranny of the agents of the bank. The affidavit for arrest was made on Saturday, the 11th of August, at which time the criminal court was in session and the grand jury sitting. Application was made to the justice, and the warrant issued. The action of the board on that matter is as follows, taken from their proceedings of August 11, 1849. It appearing to the satisfaction of the board that a large amount of funds had been abstracted from the bank, that affidavit be made by the president and cashier for the arrest of Nathaniel Giles, Jr., late teller in this bank, which resolution was unanimously approved, and was further ordered unanimously that said officers proceed to take out a search warrant with a view to have the house and premises examined. They first approved the affidavit and then approved the search warrant. The affidavit is in the handwriting of the bank attorney and is as follows. The affiants, James M. Hughes and Henry Sherrills, both of lawful age, being first duly sworn, say that the said James M. Hughes is the president and the said Henry Sherrills is the cashier of the bank of the state of Missouri, the office of which bank is located in the city and county of St. Louis, in the state of Missouri. The affiants further state that the funds of the said bank of the state of Missouri have been embezzled and stolen, and the amount so embezzled and stolen is $120,000 or thereabouts, and that the discovery of said embezzlement and theft of said amount of said funds was made on this day, the 11th day of August, A.D. 1849, and that said embezzlement and theft was committed in the county of St. Louis aforesaid. The affiants further state that they have good reason to believe and do believe that the said sum of $120,000 or thereabouts has been embezzled by Nathaniel Childs, Jr., who is lately the specie teller and one of the officers of said bank of the state of Missouri. And the affiants further state that they verily believe that he, the said Nathaniel Childs, Jr., did, while acting as the specie teller and officer of said bank of the state of Missouri, embezzle and appropriate to his own use the said sum of $120,000 or thereabouts of the funds of said bank, and with intent to cheat and defraud the president, directors, and company of the said bank of the state of Missouri. Then follows the writ of the justice to the marshal, commanding him to arrest and deliver to the keeper of the county jail of St. Louis the body of Nathaniel Childs, Jr., and the marshal's return thereon as follows, in obedience to the within writ. I arrested the within named Nathaniel Childs, Jr. by his body, and have brought him before Esquire Butler, in obedience to said writ, this 11th day of August, A.D. 1849. James A. Phelps, City Marshal. The marshal did not execute the writ to commit him to jail, because he had been bailed. There was some testimony to show that the bank, or some of the gentlemen connected with it, even went so far as to endeavor to deter Messrs. Wilgos and Alexander from going his bail, in order to prevent him from going to his family, and to raise the popular belief that his guilt was so apparent that even his old friends could not venture to bail him. The criminal court and grand jury were in session, yet application was made secretly before a justice for a warrant. This was done in order to make an impression upon the public mind that he was the guilty man, and so guilty that it was necessary to take him with all speed and secrecy as they did, for fear he would flee from justice, and confine him at once to the four walls of the jail, as the only place of safety for so great a culprit. It would paralyze Child's efforts, dishearten his friends, and enable them the better to carry out the program of their operations. At this minute, the record of this warrant and arrest is not complete. Up to this minute, there has been no man to the justice to wind up the record and close the proceedings. He would tell the jury why it was convenient to have it in that shape. If the testimony had gone forward before the justice, Childs would have counsel there. The unkindness of the case would have been displayed. The witnesses would have been cross-examined before they had consulted, so as to remember facts alike, and before the memorandums were prepared, so as to harmonize their details of fact, and avoid the danger of mutual contradiction and mutual destruction of each other's testimony. He, Mr. B., was absent when Childs was arrested, but returned as soon as possible after receiving a letter requesting him to stand up for defendant in the hour of his calamity. The first thing he heard upon his return was that there was a search warrant out, and he called at Justice Butler's to get a copy. It had not been returned. He hunted for Officer Phelps and demanded its return or execution. It was held above the heads of these parties as in terrorem. It was returned in a few days marked as follows: not executed by request of the bank attorney. James A. Phelps. Fee 50 cents. Date forgotten, but fee marked. The cashier reported that he had proceeded to take out a search warrant to search Mrs. Whitlock's house in order to ascertain if anything could be discovered in regard to the abstraction of the funds of the bank, which was unanimously approved. Thus the whole matter stood approved by the board. The warrant is to search for stolen gold coin of the bank, and is directed to a public officer. When he heard of the proceeding under this warrant toward the poor young widow on Spruce Street, his indignation was aroused, and he felt for the decency of justice in this land. It was not the hasty and precipitate action of any one individual. The plan was contrived at the bank, deliberately planned, and illegally, wantonly, and cruelly executed. If you note the report of the cashier to the board, it was not in the manner of law to search for stolen property, but to ascertain if anything could be discovered in regard to the abstraction of the funds of the bank. A general inquisition after facts, not a legal search for stolen goods. The affidavit states in terms, and specifically, the kind of money lost: 10 thaler pieces of the Kingdom of Germany, and sovereigns. You have seen by the statute that no search warrant can be taken out unless the property lost is described, and nobody can search under the warrant except a sworn officer of the government. Private malice is shut out. In a country thought to be worse governed than this, in England, a man's house is his castle. No matter how poor the man nor how mean the house, still it is his castle, the fortress of his safety, which no rude hand should dare to violate, and the hallowed scene of all his domestic affections and social charities. It is indeed a sacred place, protected by the strongest ramparts of the law, and sanctified by all the endearing sympathies of life. The loftiest orator of Britain informs us that the lowly hovel of the peasant is a castle as impregnable in the eye of English law as the princely piles of Blenheim and Waterloo. The tenant may be ignorant and poor. His hut may have walls of mouldering mud and a roof of rotting thatch, rent and broken and open to the inclemencies of the winter. The wind may enter there, the rain and snow may enter there, but the King of England dare not enter there. And do not we here in Missouri boast of a higher degree of legal liberty and a larger measure of practical independence? And can our citizens be expected tamely to submit to the more than royal authority assumed by the bank in seizing our persons, and besetting our homes with spies and eavesdroppers, and placing guards and listeners in our very chambers? This warrant was not a frenzied paper. It was the deliberate writing of skillful men, written by Mr. Kirtley and reviewed by Mr. Ryland, the bank attorney. His opinion had been asked by one of the parties concerned in regard to the proceedings on Spruce Street under this warrant, that he gave it to the effect that these gentlemen were guilty of an indictable offense, that they obtained property there by false pretenses. Mr. Bates then read from the minutes of the board the proceeding in regard to the appointment of a committee to superintend the prosecution of such person or persons supposed to be engaged in the abstraction of the funds of the bank, upon which committee Messrs. Yateman, Sturgeon, and Barnes were appointed to act in connection with the president. Barnes escaped the work by being on the grand jury. Hughes, having no stomach for such a fight, shirked out, and Yateman would have been left alone, except for Dr. Forbes, who gallantly volunteered and marched up to the assault, like our high-spirited youths to the storming of Chapultepec. He considered an important point in this case, the proceedings on Spruce Street. This branch of the matter, they had been told by Mr. Leslie, had nothing more to do with the case than Gulliver's Travels. To me and all lovers of decency and the justice of the law, it was important. He did not suppose that in their proceeding the directors had any hostility against Mrs. Whitlock, but it was important to prostrate Charles, whoever else might be overwhelmed in his ruin, to blast his reputation, to make this community believe that instead of being a Christian, a moralist, and a gentleman, he was a hypocrite, a debauched libertine, a foul adulterer. If he could not be pulled down without attacking female character, let that even be made a sacrifice. They had jumped in the dark. They reasoned upon this matter not without some knowledge of the philosophy of the human mind. Once convince you that Mr. Childs, a professed Christian and moralist, a preacher of the gospel, was a hypocrite and libertine, and you would believe, on far slighter testimony, that he was a swindler and a thief. Did not Mr. Forbes tell Mrs. Whitlock that rumor said there was improper intimacy between herself and Mr. Childs? And when asked what object he had in giving this gratuitous insult before two strangers, Messrs. Yateman and Ryland, did he not say it was to make her give up whatever she had belonging to Mr. Childs? Upon application of the thumbscrew of cross-examination, this was admitted. They had a twofold object: to blacken character and force her by a cruel moral duress to confess and surrender the papers. Yet these kind gentlemen would not hurt a hair on Mrs. Whitlock's head. What was their conduct? Mrs. Williams and Forbes came as pretended friends, and demand papers and documents belonging to Mr. Childs, but nothing for which they have a warrant. They insult her with the assurance that her reputation is assailed by rumor, and threaten her with officers at the door ready to search the house and, if need be, her very person. If this had been true, still their conduct would have been cruel, but it was false, and they knew it. She declines their demands at first, but reluctantly, when tortured and driven to the last extremity, she admitted the possession of some papers handed to her that morning by Mr. Childs, and said she would go upstairs and get them. Then it was that Mr. Williams proposed that an officer should accompany her. When she shrunk from the proposition and said, "Oh, no, you go with me, Mr. Williams," he did accompany the lady to her chamber, and when he returned, had possession of the papers, which at once were handed to Dr. Forbes. Entirely satisfied with their excursion, Messrs. Yateman and Williams left the house in glorious triumph, and were soon followed by Ryland and Forbes. The police drawn off, and all came to the courthouse to meet in conclave. What their action in conclave amounted to, we are not informed in evidence, but only know that soon afterwards the policemen intruded into the very chamber and remained for hours, and officers were sent to guard her house during that night. While at the house, and the fact of a search warrant coming to the ear of Mrs. Hayden, who was upstairs and ignorant of the proceedings below, and hearing that the officers were about to leave without executing the search, she demanded of them to do their duty, to search, and not go away and say they had a warrant, but were not satisfied. Phelps came reluctantly in, ashamed of the job, did look about a little, but so slight was his search that he regarded it as nothing, and returned the warrant, not executed by request of the bank attorney. This search warrant was only a pretense, a scarecrow held over the head of unoffending and unprotected females, and the papers obtained by that means were not only obtained by falsehood, but the actors subject to an indictment for obtaining them under false pretenses. These proceedings have all been ratified by the bank, who assumed the responsibility. These gentlemen of the bank would not have dared attempt such proceedings against a man who knew his rights and would maintain them. They dared not go to Child's house and attempt it, although his house was first mentioned in the warrant. If that poor woman had the presence of mind at that time to tell these persons it was a proceeding of which she was ignorant, to have patience and be seated until she sent for someone to counsel her, if she had sent for someone who knew her from childhood, if she had sent for Mr. Polk, Mr. Wright, or myself, he ventured his right hand, they would have gone away ashamed of the cruel and dishonest errand on which they had been sent. Notwithstanding these transactions, Mr. Geyer says it has nothing to do with the case, and this is reiterated by Mr. Leslie. No more to do with it than Gulliver's Travels. Why, gentlemen, this is a mockery, an insult to your understanding. Is not this case of circumstantial evidence? Has not Mr. Child's life been ransacked to find incidents great and small, from which you may infer his guilt? And shall others, equally liable to suspicion, presume to say that their misconduct, their very crimes, shall raise no implication against their innocence? They have the monopoly of banking, to be sure, but while I have the freedom of speech, they shall not, with impunity, violate the laws of the land and the decencies of life. They shall not, unresisted, put a helpless woman to moral torture. Yes, gentlemen, it has something to do with this trial. It is a case abounding with circumstances of peculiar aggravation, a case in which every generous sentiment, every impulse of gallantry and of manhood may be properly called forth into active cooperation with law and justice. If ever suffering virtue deserved a tear, if ever persecuted innocence cried aloud for sympathy and protection, now is the time. Now, when lawless violence rushes upon its victim with headlong haste, reckless of the ruin it scatters in its track, and tramples with thoughtless cruelty upon the downtrodden bosom of unprotected woman. Yes, gentlemen, it has much to do with the case, the law, the facts, the morality of the case. But, say the gentlemen, we got the papers. And what are they? They are plundered papers, plundered from Mrs. Whitlock. She had a perfect right to have them, as a friend of Mr. Child's, and they had no right to take them. Had they been given to me, as they were to Mrs. Whitlock, think you, gentlemen, they would have gotten them? My life upon it, they would not have been so impertinent as to have asked me for them. Here is a package of papers, holding up a bundle, endorsed, private papers of Mrs. Hayden, and to be delivered to Mrs. Hayden, Mrs. Whitlock, or Mr. Childs, and dated December 4th, 1848. You remember what Mr. Hirschberg testified respecting this package. It was in the vault of the bank as a special deposit. Mr. Hirschberg testified he gave it to an unknown hand. He believed one of the directors, but could not remember to whom. He gave it to them sealed and in proper order. It was returned to Hirschberg to be again placed in the vault by Mr. Walsh, but then it had been violated by cutting around the seals. This package was called for during the examination, but not produced by the bank, and was eventually obtained from the bank by an order from Mr. Childs endorsed by me, and was brought into court mutilated as it is. He mentioned this to show how unscrupulous his bank officers were, and how little regard they paid to the rights of others. It seems nothing in their keeping is safe. He did not know what it originally contained, nor could the teller of the bank say he had delivered what he had received on deposit. He did not know what paper was gone, having blindly jumped to the conclusion that Childs had got their money, or thinking it safer for their own reputation to have the world believe so. They claimed the right of reprisal on his property. They issued letters of marque to make the captures, and give to Mr. Williams a del credere commission to guarantee his acts and contracts in the premises. They are very vigilant in the search after his effects. They violate special deposits in their own vault. They threaten and terrify helpless women, and wring from them confidential trusts. But they are very prudently abstained from touching his property open before their faces, if it happened to have a man to guard it, who knows his rights, and knowing, dares maintain them. Among the things delivered up by Mrs. Whitlock was a small deposit book in which was an entry to her credit with Clark and Brothers for $1,800. She was compelled to give it to Mr. Williams, a check for that amount. Why was this money forced from her? What pretense of law or decency is there for extorting from her the check for that balance? It might have been her own, or Mr. Child's, but certainly it did not belong to Mr. Williams or to the bank. Obtained in this shameful way, no wonder it was concealed by a variety of artifice, privately shifted from hand to hand, so that no one director could tell the whole story. From Williams to Forbes, from Forbes to some unknown person at the bank, from the unknown back to Williams and Yateman, who cashed the check and delivered the proceeds to another unknown at the bank, who handed them to Mr. Sarby. He vested it in his own name, bearing interest, and delivered the certificate to the cashier, who never made the mark of his pen upon it, or any book of the bank. Thus they get possession of the money of other people, and thus they hide it. I will not say embezzle it, with every mark of contrived secrecy that betrays their consciousness of wrong. But they have got the papers, and Mr. Leslie says in them they have gotten the avails of the stolen gold. How dare they say so, without one iota of testimony to prove the assertion? Having now stated the nature of the indictment, the motives for instituting, and the manner in which the prosecution has been conducted, the extraordinary means used to obtain testimony, sufficient to weigh down any man, the unusual and cruel means used to poison the minds of society, and its powerful reaction upon the bank, he would now ask, what was the charge against defendant? Yesterday evening the jury was asked to chew the cud of reflection during the night and determine if they could what was charged against him. If they knew what the charge was, they knew more than I do. Having been driven to the necessity of guessing, they could guess also. You have seen by the sworn declaration of the cashier, endorsed by the board, that the money was taken away in January, February, and March. Then you learned that the money was not taken, in point of fact, but used to cover up an old defalcation, cover up a previous defalcation. When and of what? Abstraction has been the word in the mouth of every witness and of the counsel. Now they go into an indefinite past, since 1837, and in that long career they are to figure us into the penitentiary. Mr. Geyer is now to show me that somewhere there are forced balances made and false accounts shown. You recollect with what frankness he made a statement of what he intended to rely on in his argument. To this indictment are 6 prongs. Only one is to inflict the wound, and that is to be determined by figures. There is no pretense set up now that Giles stole this money after the February count. Mr. Haight and Mr. Williams deny it, though Mr. Sherrill swears to it in his affidavit. To this moment they don't know the charge, and now Mr. Geyer will go to calculating it. They say there has been an error in the books for years past, but don't know who made it or how it occurred, and that it would take 5 years to find that out. In coming to the body of the crime charged against defendant, he would show what was the duty of the officers of the bank, and that if that duty had been properly performed, this alleged embezzlement could never have occurred. In doing so, it would be necessary to trouble the jury by reading from the charter and bylaws of the bank. He called attention to the testimony of the directors in regard to the powers and duties of the subordinate officers of the institution. They knew nothing of that duty or how these officers conducted themselves. It was none of their business. They were directors. This was a hard year upon them. Excepting this year, they had nothing to do but meet at the board and drink champagne furnished by the younger members in sponging their robes of office. End of section 41. Section 42 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials Volume 2 by John D. Lawson. Trial of Nathaniel Childs, Jr. for Embezzlement, St. Louis, Missouri, Part 22. December 7th. Mr. Bates. The bylaws show that no clerk could carry on outdoor business so as to interfere with his duty in the bank. This rule did not apply to tellers, in illustration of which he referred to Mr. Clark, receiving teller, who had knowingly carried on outdoor business, and as far as the rules were concerned, he contended the teller could do business out of the bank as well as any director. He contended that if the president and cashier of the bank had done their duty as laid down by the charter and bylaws, or if they had come near discharging their duty, Childs would not be here charged with this embezzlement. He could never have abstracted $1 without it being known to them. True, the director said it was not their business to see that the officers of the bank discharged their duties, yet they, by the charter, are charged with that duty. They were appointed for the purpose of governing the whole institution. No officer lower than the cashier was mentioned by the charter, and he, as the exclusive keeper of the cash and by the 21st bylaw, required every day to verify the daily balance of the tellers, and if a discrepancy occurs to report the same to the board. This duty was plain, but all the evidence went to show he had not discharged it, and he himself was anxious to have it understood that he never pretended to do it, his bond and the rules to the contrary notwithstanding. The teller was not the keeper of the cash. Mr. Sherrills went into the bank inexperienced. Colonel O'Fallon, who had been president of the branch bank of the United States, and Mr. Smith, who was engaged in the agency of the Commercial Bank of Cincinnati, were the only men of experience he had around him at the commencement of the institution. Mr. Sherrills had no knowledge or experience. It was his duty to know, and to do what the charter and bylaws required. And where knowledge is a duty, ignorance is a crime. If he, as a lawyer, should take a case for any gentleman of the jury, and from ignorance lost it, he held that he would be accountable. The duty of the cashier was plain and simple. Suppose he had kept the treasure in the vault, and on every day furnished each of the tellers with sufficient cash for the day's operations, and at the close of business, struck the balance according to their transactions. Could any abstraction of its funds ever have taken place? It was impossible. Childs had access to the vault, and therefore he had charge of everything in the vault. Absurd. A trick to shuffle off the cashier's duty upon the teller. It was directly in the teeth of the bylaws of the bank. Why, by the bylaws, the teller only gives bonds to $10,000, while the cashier is required to give bonds for $50,000. If nothing else showed the responsible party, this in itself would. The teller makes no report to the board, has no communication with it. The cashier, and he alone, strikes the balances and verifies the statements furnished them. Is it just, we asked, for those directors to come here, one after another, and strive to make the impression that Childs is responsible for the cash of the bank? He might be held responsible for that part of the funds which legitimately came into his hands, but none other. If I handed my servant $10 to purchase any necessary, I would expect him to come to me and say, "Here is $7.50. I spent $2.50. And here is the proceeds of the basket." If he did not properly account for the money given him, I, as the keeper of my funds, would hold him responsible. So it should have been with the cashier of the bank. He was the keeper of the cash, and should have watched his officers. The money in the vault was not, in point of fact, in Childs' possession. The vault was merely a little cellar, with doors and apertures, and Sherrills had keys to it, as well as Childs. Since this loss, however, the directors are petitioning off the vault, and only giving out such amount of funds as are necessary for daily use. the teller's ticketing for it, just as the specie teller ticketed for the paper he received for daily use. As Clark took the ticket from the specie teller for the amount of paper furnished him every day and settled after the close of business, so it was the duty of the cashier to do. Not a director could tell how it happened. These tellers were trusted with the treasure of the only banking institution in Missouri, trusted with the highest and holiest fund in the state, set apart by Congress for the instruction of the rising generation of Missouri. They could not tell who had possession of that money. Even Colonel Campbell, who had been 8 years in the bank, never knew who kept the keys of the vault. Mr. Yateman told you that until last August, he never knew who kept the keys of the vault. No wonder Mr. Barnes could not recollect that he had the keys on one occasion down at his store, as no one seemed to know where they were kept. Suppose the claim of right had arisen as to who had possession of the bank, Shirles or Childs. How would Shirles lay his claim? Certainly by the charter and bylaws. Childs would say he had the keys and did have access. It has been decided over and over again that mere access to a thing does not put in possession of the party. For that matter, every officer of the institution had access to the vault. Childs was not even in constructive possession, and not being in his possession made the crime against him different. Without possession in himself, the taking of the money would be larceny, not embezzlement. Embezzlement is a breach of trust, the applying to one's own use, property already in possession, and is contradistinct from larceny, which implies a taking from the owner. The taking of the property of bank by any of the clerks there employed is not embezzlement, but larceny. Archbold, page 189, says, if an owner of goods deliver them to another to carry, and does not relinquish possession, and the person to whom they were delivered runs away with them, he is guilty of larceny. Mr. Guyer will not say that embezzlement was no offense at common law. They did not hang men for it at common law. It was not a felony, but a high misdemeanor. The character and quality of the crime is changed by statute, in several instances both in England and America, so that what was but a misdemeanor formerly is a felony now. It is a truth in point of law that the cashier was the keeper of the money of the bank, and in point of fact that he keeps it much more than anybody else. He makes all the reports to the board and to the public, and swears to them, and yet, strange to say, he never counted the money, and knows nothing about it. I called for the specie teller's account for the purpose of showing the jury what it was, a mass of figures, and from which Mr. Guy was to make his arithmetic. I did not intend to go deciphering. That part of the case on our side belonged to Mr. Blennerhassett, and well the state knew it. Yet we could not beg nor threaten, coax or provoke them to give him a prior statement of what they intended to rely on. He was not to be drawn from the main defense or line of argument laid down for himself by the statement of Mr. Guyer just as he, Mr. B., was rising to address the jury. These specie books represented the gross amount supposed to be in the vault. This amount it took the directors a month and 9 days to count, by relays of committees, under comfortable circumstances, and having nothing else to do. Could they state what was in the vault by the knowledge of others? Shirles was general boss, as Mr. Christie says, and when Childs went into the bank was not particularly experienced in bank business. He ascertained from the beginning the amount in the vault, and afterwards on every day put in this book the amount he supposed to be there. Childs was not required to count the cash. The semi-annual committee were, and Shirles swore to their statements. From these statements Mr. Guy was going deciphering. No matter how false the accounts may be, they are true as to Childs. He is as stopped. He cannot explain. He can't tell the truth, and if false balances are discovered there, no matter who made them, it is to be taken as proof that Childs stole the money. These counts by the legislative committees, shall we not take them as correct? Shall we not be bound by what they swear to? You see, they cannot be true in point of fact. Suppose Mr. Geyer should succeed in his ciphering and shows there was a balance of $100,000 wrong. Is Charles to be stopped because he every day put that down as the amount he's supposed to be in the vault? Suppose Charles, who has access to the vault, had removed $120,000. How does Charles know that fact? He would go to the vault each morning, bring up a few trays of gold and silver, and note the amount of them on his memorandum, but never pretend to count the show of gold in bags or that in boxes. The seals of boxes can be opened, and money has great temptations for other men than Charles. Charles has all night and Sundays for that purpose, were he disposed. He was desirous by this to show the false basis on which Mr. Geyer was going to build his argument. When Charles reported, his reports were subject to the revision of another man, and in no instance has a witness been brought forward to disprove them. It was the duty of Charles to examine the cash every day, and he must have examined it in order to make his reports. How could he make out his reports to the public and the governor unless he knew the state of the bank? If he was ignorant of that, he deserves expulsion from his office. He charged nothing more on Charles than he was forced to. He charged no man with the crime. He only defended Charles. Everything that could be had been said by Charles in connection with this loss, and nothing said of anybody else. No suspicion aroused. Mr. Yateman, when on the stand, expressed surprise that any imputation should be placed on the directors at the time Charles was arrested. He never heard it, and supposed if it had been made, they would have protested against it. He was then asked if Charles did not express surprise that he should be suspected and protest against it. Oh yes, to be sure he did. Charles was astonished at the charge, and he was not astonished that the directors and all should so readily unite to charge him, and thus exculpate themselves. Self-preservation was a natural instinct, and men will resort to it. Did any of these men who so readily charged Charles stand fearer in the community than he did, down to this disclosure and prosecution? If anybody in or about the bank was suspected, you were bound to suspect gentlemen. They had no rowdies there, none but men who were not ashamed to look as upon a level with the proudest citizen they meet. Mr. Bates then alluded to the imaginary blunders in the bank, for which the February-March count was to be panacea, the cure-all. Yet even there they blundered grossly, as was manifest by their memorandum and record. This was illustrated by box number 30, which was recorded to contain 4 bags, marked on the outside to contain 5, and when opened did contain 4 bags. Yet, from this box, 30, it was contended a bag was abstracted, and it was the box in which the discovery was first made. Then again, box 34, which is marked to contain 5 bags of sovereigns, and so signed by the President, is recorded as only containing 4 bags. He did not intend to go into a calculation, but only called attention to these facts to show that the directors themselves blundered. They don't say that Charles did, in fact, take the money, only that he had an opportunity, because he had access to the vault. He was directed by the President, previous and during the count in February, to put the coin in bags, 1,000 pieces in each, for convenience in counting. Gentlemen of their leisure and wealth could not do this, although it was their duty. This arrangement was not completed when the count began, and hence his absence down in the vault during the count. And here is the time he was mysteriously engaged, as they would have it, in opening the boxes, removing a bag and resealing them again. He was down there by order, and this too during bank hours. You recollect from the vault opening into the banking room, where all the clerks are engaged. Besides the door, there are 2 peepholes. Charles could have gone into the vault at these times with his wax, but he must have a light in order to use it, and in using it must necessarily have produced a smell, from the character of the ingredients of which wax is made, which smell must have escaped through these apertures into the banking room, under the very noses of Mr. Robinson and the discount clerk. They must have known that sealing was going on in the vault, had it been the case. It was next to impossible that so much wax could have been in the vault without discovery. He was liable every moment to interruption. It was in business hours. The clerks all at their posts, the vault door open. He might be seen through the skylights, or detected by the smell of the burning wax. Why, he bought some wax from Mr. Fisher, a director. Say they, are you going to convict Charles of being a fool as well as a knave, by supposing he would go to Fisher to buy wax for that purpose, when there was plenty lying upon the mantelpiece in the bank? Well, Charles could have done it as well as Charles, and so could others. Charles' chances were better, 10 to his 1, and if he be the weak and gullible man some think him, somebody else could have done it in his absence. Charles had access to the bank from his dwelling and kept keys to the vault. When he passed into the bank in the evening to get his snuff-box, Burke standing at the door, he could easily have removed the bar from the door, and having gone into the banking room at his leisure, without the knowledge of Boland or the watchman. Burke, Boland, or Cochrane could have done the same thing. A decrepit old man watched around the bank, and by leaving this bar off and taking advantage of his absence at another part of the building, it would not take 3 minutes for an outsider to get in, and while he, the watchman, is walking his rounds and crying, "All's well," there they could be in the vault sealing and unsealing at their comfortable leisure. The keys to the vault were accessible. They were kept upstairs in Mr. Sherrill's residence in a drawer, fastened with a common lock, and everybody about the house were likely to know where they were kept. An outsider could have got them by collusion with the servant, and Sherrill's never known the fact. Boland was sent for by the bank, but after his arrival, they found they could not use him, and so they resolved on destroying him. He testified that on 2 occasions, Mrs. Sherrill went into the bank on Sunday and testified something about the wax. To disprove his statement about the wax, all directors were recalled, and Mrs. Sherrill was dragged into court to contradict the other statement and thus impute to him perjury. Boland says he gave the key to the servant on 2 occasions in her name. She says no. She got the key but once, and then for the purpose of seeing a jeweler's bill which she knew or believed to be in the cashier's room. I have no thought that Mrs. Sherrill was accessory to the stealing of the money. From childhood hitherto, she has been far above such an imputation. But, like all the ladies of ancient and modern times, from the Garden of Eden to St. Louis, she has a spice of curiosity. She longed to see that bill of jewelry, to note the items and conjecture the destination, but she little thought that to her womanly curiosity the public would be indebted for proof of the astounding fact that a Negro slave could get the keys of the bank for the asking. Do you suppose this was the first or last time that the key was got by asking? If you do, you stultify Boland and Mr. Sherrill too. Do you suppose these things remain unknown, that there are no spies upon the bank as upon private houses? Do you suppose they did not know the servant girl could get the key of the bank by simply asking for it, and that, by means almost as easy, she might have access to the keys of the vault? This was the state of careless insecurity in which the treasure of the bank was kept, and while this state of things continued, it is no less cruel than absurd to say that Charles took the money. But he could have done it, say the learned counsel, and so could others, far easier than he. Mr. Sherrill said every Sunday wholly to himself, to be in the bank at his pleasure, with the vault keys in his pocket, and had opportunity to smuggle in all persons he chose to have with him. He had the seal. He had a knowledge of the localities of the money. He had the books and memorandums of the count, and he, as well as Childs, could have played a hocus-pocus to cover up former deficits. Who then stole the money? We charge no man, but we say that it is less reasonable to charge the man who had a bare possibility than the man who had every opportunity and means, and equal temptation to commit the crime. Mr. Bates then proceeded to comment upon the conversation between Dr. Forbes and Mr. Childs, just previous to his arrest. He alluded to Childs' answer to Forbes' question at that time, that the money was taken by Shirls, Hirschberg, or myself. But I am innocent. Childs at that time did not know how easy Shirls' keys could be obtained, and in his remark only included those who had keys to the vault. This, however, he considered of little or no importance. Mr. Bates then noticed the accusation that Childs was rising too fast and getting rich, and commented on the failure of the directors to adduce one circumstance against him in that connection. They had traced his transactions for the 15 years he had been living here, and even gone to his residence in Maryland, while an industrious, orderly apprentice, yet had not found a man to say he was unjust in his dealings, or unfair in any one transaction of his life. He knew this goodly city when it was a little town, and had but 4 brick houses in it, and about 2,500 inhabitants. He had seen it grow and rapidly increase in numbers and wealth, and many of its enterprising citizens, animated with the spirit that built up this city, grew with its growth and strengthened with its strength. Is it any impeachment of Mr. Barnes, one of our great merchants, now so enterprising and prosperous, and apparently so wealthy, and still so rising, to say of him that but a few years ago he was a very intelligent and faithful clerk, living on his salary in a respectable mercantile house in this city? Is it any impeachment of Colonel Brandt, now one of our few millionaires, the owner of a princely fortune of his own making, to say of him that 20 years ago he was only a deputy quartermaster, with the rank, pay, and emoluments of a captain of infantry? If these be reproaches, then all our leading men of wealth and influence, our great landholders, our eminent merchants, our far-seeing and nice calculating brokers and financiers, instead of glorying in the achievements of their talents and industry, have cause to blush over the mushroom growth of their bloated fortunes. Gentlemen, few of us are natives of this country. We are all adventurers, coming from a distance, to seek a fortune or make a name. We had very little to bring with us. If we had been rich and prosperous at home, we would have shown our wisdom by letting well enough alone and staying there. But with most of us, migration was a necessary of life. I remember as if it were yesterday the first time I ever crossed the Mississippi, the 29th of April, 1814, and I can give you, with entire precision, the inventory of my worldly wealth at that interesting epoch. Imprimis, a horse, saddle, and bridle. The horse a first-rate gelding of the best hunter blood on the shores of the Chesapeake. Item, a pair of saddlebags, well packed with pretty good apparel. And lastly, in actual cash in my pocket, $3.50. I came without fear or doubt of the future, buoyed up by the confident hopes, puffed up, it may be, by the silly vanity of youth. I never allowed myself to doubt of a reasonable measure of success. I knew then, as I know now, that, in the good providence of God, integrity, industry, and perseverance never go wholly unrewarded, that in all civilized society they entitle their possessor to personal independence and to the decent respect of the world. True, I have not made a fortune, as some of the bank directors have, and as Mr. Childs is charged to have done. That is my fault, for I have had ample opportunity. But if I were called upon to account for the little I have, surely I could not go as Mr. Childs has gone, triumphantly through the severe test which he has been subjected. He contended this charge was a contrived scheme against Childs, concocted in the dark recesses of the bank, and had utterly failed in its end and design. He then referred to Mr. Barnes' recollection of Child's statement to the board, the original of which had been destroyed by Childs upon advice from Mr. Wright, in which statement he alleged that he made it an invariable rule to save $30 per month out of his salary. All the directors had stated in evidence that Childs received a salary of $1,200. To show their recollection of facts, he read from the record of January 13, 1839, in relation to the salaries of the officers of the bank. In regard to the salary of the tellers, he read as follows. On salary of first teller, Mr. Dobbins, moved to strike out $1,400 and insert $1,200, which was negatived by a vote of 9-1, and the sum of $1,350 was agreed to. On salary of second teller, Mr. Dobbins moved to strike out and insert $1,200, which was negatived by the same vote, ayes 9, nays 1, and the sum of $1,350 was agreed to as the salary of the second teller. This was in 1839, a year and a half after the bank went into operation, and its business was small, that Childs was allowed $1,350. Yet all these directors, in order to infer a fraud from his low salary, were declaring he only received a salary of $1,200. He brought this fact forward and commented upon it at some length to show the character of this proceeding and the unfair manner in which Mr. Childs had been treated from the beginning of this prosecution. You have heard Mr. Guy's brief announcement that he meant to prove by an examination of the specie books and weekly statement that there were false and forced balances of the coin, and infer from that Mr. Childs had somehow acted very improperly. But he did not say, nor insinuate, that if he fully succeeded in that attempt, it would amount to proof of any one of the 6 counts of this indictment. He knew it would not. I am not going into an examination of those accounts, and as far as concerns this indictment, while I suppose the amounts are right, I care not a straw whether errors are found in them or not. I have at hand, however, several answers to Mr. Guy's hypothesis of false balances, and first, it is impossible to make it out without falsifying the whole course of the prosecution, for they have denied the correctness of all former countings of the money, and of the receipts, therefore, all former statements of the amount counted. And how can they make out a false balance at any particular day, without establishing a true balance at some former day, to serve as a standard to measure by? Second, the cash balance, true or false, was not Child's balance, but the bank's. How the silly practices arose of stating in the specie book, in every day's entry of business at the counter, the total amount of coin in the vault, of course, I know not, but suppose the cashier, the general boss, as he has been called, directed it. But so it is the gross amount was carried forward every day. Now does any man pretend that Childs so stated it upon his own knowledge, his own counting every morning? This fact is physically impossible. He could not do it, but must have made the statements on faith of the semi-annual accounts of the directors. Third, if Mr. Guy should have the ill fortune to cipher out false balances on the book of the bank, some dignitaries higher, I wot, than Childs will begin to quiver in their shoes. Men will begin to read the charter and bylaws, and so find out that it is the bounden duty of the cashier every day to settle the cash account, take charge of the cash, and report any impropriety without delay to the board. They will discover also that the directors must, twice in every year, count the money and publish to the world a full and fair statement of the condition of the great interest committed to their wisdom and honesty. That they do, in fact, pretend to have such countings and make such publications, and that the cashier swears to every one of them. Now, if Mr. Giles should succeed in proving that the books are false, the balance is forged, and the money represented in fact not there, Charitable people will begin to wonder how such things can be under the management of such vigilant and virtuous financiers, and the legislature, when it meets, may take it into its head to be displeased at being habitually imposed upon by the biennial blunders of its own committees and the semi-annual falsehoods of the directors and cashiers. But enough of these false balances. For aught I know, they may deeply concern the bank and the public, but as concerns Mr. Childs and this indictment, their existence or non-existence is the same to me. And now, gentlemen, I am almost done. I thank you for the patient and strict attention with which you have listened to my remarks, too long continued. I would gladly have avoided the necessity of speaking to you at all, and in all good faith proposed to submit the cause without argument, for I knew from the beginning that my client was in no danger of conviction. The duty was to me a painful one, for it imposed upon me the necessity to turn upon the pursuers and carry the war into Africa. I have discharged it to the best of my ability. My conscience is satisfied. The charge against the defendant is now proved to be flimsy and groundless. There is not one word of testimony tending to show the affirmative fact of his guilt. The whole air-built fabric is based on the simple fact that he had an opportunity, and is therefore possible that he might have committed the crime. His own conduct and demeanor during the whole of this trying scene is his best eulogium. Strong in conscious innocence, he has stood unmoved amidst the storm of accusation, and unterrified by the fearful odds of numbers, wealth, and social influence arrayed against him. His calmness and self-possession have never for a moment forsaken him. He could not be provoked nor seduced from the even tenor of his way. Accused, he did not recriminate. Reviled, he reviled not again. Defended by no armor but moral courage, with no tower of refuge but the simple dignity of conscious rectitude, he stood, serene and safe, in the tumultuous onset of his foes, while his friends looked on with honest pride and beheld all the arrows of his enemy, blunted by that impenetrable armor, fall harmless at his feet. I have no fears about this indictment. I know that he must be acquitted of that. But that is not enough. I long to see him sent back to society, cleansed, purified, washed white from the social and moral contamination of so vile a charge. Restore him, gentlemen, restore him, for you alone can do it, to the position in society which he has so worthily won, and so long sustained as a man of business, a gentleman, a moralist, and a teacher of the gospel of Christ. I have done. He is in your hands, and God grant him, through your means, a safe deliverance. Mr. Geyer for the State. Mr. Geyer. The position of counsel who had the concluding argument was generally understood to be a post of honor, yet never a position of ease, and in this case, after 30 days of successive toil, with enfeebled constitution and intense application of mind to the subject matter of the trial, he should not, in opening his remarks, spend the little time and strength left him in apologies. His purpose was to argue the case upon the facts, a course of argument not yet attempted by the gentlemen on the other side. Indeed, they set out by informing the jury that they did not understand what charge was against their client, and the gentleman who last addressed you, after occupying a whole day in preliminary observations, again reiterated that the nature of the charge was not understood by the jury, and in his opening remarks in the afternoon of Thursday, among other things, sent you home to chew the cud of reflection on this point, an idea, he supposed, suggested by Mr. Blennerhass's prolific cow with 5 calves. From the first day of the cause to the present, their sole desire has been to cover up the facts in order that they might not be understood, and call on you to acquit without reflection. His purpose should not be only to make it understood what the charge is, but to dig up from the mass of evidence by which they have been covered, the facts which apply to the charge. He had a memorandum summary of the points taken by the defense, and in the course of his remarks would advert to them. He did not intend to discuss them at the length bestowed upon them by the opposite counsel. They started with the proposition that their desire was not merely to get an acquittal, but a triumphant acquittal, so that the defendant be turned loose unscathed if not unsuspected. Yet, when the senior counsel rises in his case, he contends the indictment is defective and ought to be quashed, and throws before the jury a question of law for them to decide in order to avoid the trial upon facts and evidence. He asked how that tallied with the profession that they anticipated a triumphant acquittal. This was one of Mr. Bates' new points. Another was to make charges upon the directors and upon every witness, as if they were now here upon their trial, and the jury not passing on the guilt or innocence of the accused, but sitting here to indulge their prejudices and passions, or represent those entertained by others toward these directors. There were some points made by other gentlemen in their argument, which we would pass over for the present, among them the extraordinary attempt to deny that the money was gone. Mr. Geyer said he had taken down a list of the penitentiary offenses insinuated against the directors and officers of the bank during the argument by the defense, sometimes insinuated and sometimes almost directly charged in words. They were, first, of embezzling the money themselves with an agreement to divide it. Second, having stolen the money, it was used in bribing the members of the legislature at the last election for president. Mr. Bates tells you he don't charge it, yet he says there was an election last winter for president, and great sensation in the bank in consequence, and it was an occasion in which money might have been profitably used. Third, having stolen the money by entering into a foul conspiracy, they caused it to be charged against Childs, and that merely because he had left the bank. 13 directors and the president, who will compare advantageously with any of the men concerned in this cause, either counsel or witnesses, they enter into a secret conclave, having robbed the bank, to charge the fact upon Childs, and having done that, they become suborned witnesses. Fourth, they more than insinuate that Burke, the watchman, was drilled and had his consideration. Fifth, that they sent for Boland and attempted to bribe him. Sixth, with obtaining goods upon fraudulent pretenses, threats were made that prosecutions are to be instituted in consequence. These gentlemen counsellors, who think the man ought to be damned who instituted this prosecution upon good cause, and who made an effort to detect the guilty party, are to be concerned in prosecuting not only the gentleman who made the much harped-on expedition to Spruce Street, but all others of the bank, because they ratified the proceeding. Seventh, with false swearing and perjury, 7 distinct charges of penitentiary offenses, to console which they are all brought into court to commit an 8th, the high crime of perjury, the most ignominious in the sight of God or man. He was struck with surprise at hearing the epithets which had been employed in denouncing these gentlemen, especially the 4 gentlemen who went down on Spruce Street: savages, cowardly, hypocritical, etc. And had he time to go over his notes, he could furnish a sheet of extracts of the kind. Who were these 4 gentlemen so denounced by Mr. Bates? 3 of them are members of the same church and have partaken in the same communion, probably communed with the distinguished orator who used the language on the 1st of this month. And he could not help thinking at the time, behold how these brethren love one another. We too had come in for a share of the kind, brotherly sentiments of the counsel on the other side, but he was not going to defend himself from them. He would ask the jury that when they go to chewing the cud of reflection, they may say with how much forbearance it had been borne throughout the trial, and received with the proposition to argue the facts piece by piece, instead of indulging in vehement declamation. He asked if they were to be tried, to contrast the conduct of the counsel of the state with that for the accused, and he was willing to abide by it. Mr. Bates offered, and since he has boasted of it, to submit the case to the jury without argument. He had practiced a long time with Mr. Bates, and they both knew what the game of brag was, but it was some time since either had anything to do with it as a game. This brag of submitting to the jury without argument was just as it was in that game. The man with the weakest hand brags the loudest, while the strongest hand says nothing, but coaxes on inch by inch. He scarcely knew a man who bragged very much to have much to brag on. What did they mean when they proposed to submit this case without argument? Had they not argued it inch by inch? Had they not time and again declared there was nothing before the jury to argue upon, and caused a stamping in this lobby in order to produce the impression that the case was going one way? Was argument proper? Mr. Bates told the jury that even now, after hearing argument for a week, they did not understand the case. Was this not a case in which, of all the others, argument was necessary for the administration of justice? Whatever your verdict shall be, the public mind should be satisfied. Yourselves satisfied that the whole case was before you, presented by counsel on each side, and then, by looking to the evidence, to see which presented it in its true light. A large mass of the testimony had been hastily read to the jury. They had not seen the documents, and much of the guilt or innocence are to be found in the face of papers produced, and in the handwriting of Childs. Most of the testimony consists of figures which it is impossible to understand of a sudden, and he thought he would show that these figures told more than the gentlemen were willing to tell or find out. He did not wonder at Mr. Wright's horror for Cocker and Dilworth, when he would find by the writing and ciphering of defendant that he was responsible for something he had not produced. The gentleman who opened the argument complained loudly that the old landmarks of the law had been beaten down, that he was oppressed by the rule of the court, by which he was compelled to open the case on their side, and in this he was followed up by Mr. Wright, who complains that rules were made to fit this case, so great was its importance, which would not suit any other. He did not deem this important. The rule by which they were governed had certainly existed in the criminal court 10 years, and in the last 2 cases he had in their court, one in 1840 and the other a few years afterwards, it was forced against him in his side of this question. The grievance was this, not that the rule had been violated and a new one made for this case. They wanted to send Mr. Williams ahead. They were not willing to take him one at a time. They wanted to hunt him down in couples, because he had in some way been concerned in producing developments exceedingly inconvenient for the counsel of the accused. Mr. Wright commenced by saying he was forced to speak, but did not like to give reasons of compulsion. When started, however, it was harder to stop him than to get him to go. He traveled far distant from the regions of the case and the trial, and like a spirited courser in the sulks, when the spur is put to him, jumped the track and bounded to the field. Never touched it again except to cross it. Spurs through the field and finally lets down when he happens to meet with Mr. Sherrill's servant girl. It happened just at the time when some of his numerous correspondents gave him information of scandal. He let down. He did not think they ought to complain of the argument, for he did not know what sort of case this would have been for entertainment, had it not been for the speeches of Mr. Wright and his successor. He proposed in the argument he would submit to travel with more rapidity than the gentleman who preceded him over that part of the case they introduced, and which in his judgment had nothing to do with the inquiry. He noticed it only for the purpose of removing so much of the rubbish thrown on the case as would enable them to try the facts they had sworn to try. What has been the conduct of the directors during the progress of this investigation that led to a conviction in their minds that $120,921.62 had been abstracted from the bank by somebody? They, be it remembered, are charged with despoiling those boxes themselves, and having entered into a conspiracy for the purpose of convicting Childs of an offense whereof they have been guilty. Is it not remarkable that these corrupt savages, when the disclosure was made, should have sent for Childs the first thing, in order that he might see the boxes opened, that he might examine them for himself, and that he should be a witness of the evidences they were to furnish against him? Every box, excepting a few of the first, was opened in his presence, and when a remark was made about the seal, his attention was drawn to it, and he attempted to account for the difference in its appearance. When it was ascertained that there had been abstractions from 16 boxes, and when those directors, astonished at the condition of things, were looking about to inquire how it was done, one of them, a personal friend to Childs, asked him about it. Childs then had no accusation against the directors, no imputation against them. He thought he was safe in saying that this imputation of the directors was an afterthought suggested by the investigation, and nothing but the desperation of the case induced them to resort to it. Dr. Forbes in that conversation asked if it could not be a mistake. "Oh, no, sir," replied Childs, and in answer to the question, "Who in the name of God could have done it?" replied, "Nobody but Charles Hirschberg or myself. I am innocent." It never occurred to him to charge the directors with having despoiled these boxes or entering into a conspiracy to fix the charge upon him. Judge Charles and the president made affidavit that afternoon and had Childs arrested, and that figures largely in the course of the defense. And Charles is charged with swearing to a falsehood because he took the word of Childs. It may be indiscreetly took it. He took Childs' official written reports, rendered to him as cashier, under oath that the money was there, when in fact it was discovered not to be in the vault. According to Childs' own representation, it was coin. According to the memorandum book, it was coin, gold coin, 10 thaler pieces and sovereigns, and according to these reports, and his opinion that it was taken from the box's bag at a time, he made affidavit to losing a given number of coin, for which he is charged with perjury, because it may afterwards appear not to be coin taken from the funds of the bank. Mr. Geyer proceeded to notice that portion of Mr. Bates' argument which charged that Childs' examination before the justice, at the time he was arrested, was dispensed with in order to allow the bank to manufacture public opinion. He thought an examination before the justice would have been the surest and best mode to create public opinion against Childs. But such was not their desire or wish. Childs was arrested and entered into recognizance, and Mr. Wright says, to appear before the justice for examination. What then? Was the justice corrupted by the directors? What is the reason it was not carried on? He would tell them, and it was a matter of surprise to him, that gentlemen argue a case and charge criminal acts, and don't themselves look at the record to see what was done. The grand jury had been in session some 8 or 9 days previous to Childs' arrest, and he held in his hand an application from the grand jury for a bench warrant, which was issued August 15, 1849, and by which the matter was taken out of the justice's hand. This charge of an attempt to manufacture public opinion is a specimen of the evidence of guilt on the part of these directors. End of section 42.